Wonderful to see you all. My name is GrantSmithEllis, and I am a towel. And you may say, sir, you are clearly a man. And I would say, no, we can't go over this every day. I am an anthropomorphic towel in man form. Yes, hello, ladies and gentlemen. Alana, it's great to see you. Ange Whittick, God bless you, my dear friend. It's wonderful to see you. Deaf Otter, it's great to see you in the morning. My dear Jew Drops, the towelette of all towelettes. It is great to see you. And I think, ladies and gentlemen, we all begin today with a prayer that Alan Jackson does not again besmirch towels and mistowel paper towels and generally cause an uproar within the towel universe related to his disdain for towels. And you might say, Grant, I thought this was coverage of the John O'Keefe and Karen Reed retrial, and I would say to you, yes, but I did not attack paper towels. It was Alan Jackson. Just like I did not bring up the Stay Puft Marshmallow Man, that was also Alan Jackson. Now, a few things. One, there's a lot of pollen in the air because it's been raining for the past 3 days in Massachusetts, and it is also springtime. Number 3, great to see you, JI5 and Lisa Cox. Number 2, I want to take a moment because of Christina, our venerated, wonderful honorary towel Christina. Christina has done some excellent work. Oh, don't worry, JJ. We will review what Alan Jackson said about towels. Yes, ladies and gentlemen, we will not allow those comments to fade into the dustbin of history. We will, like Vico's recursive historical circle, continually bring up Alan Jackson's attack and smear and mistoweling of paper towels, and thus, through a syntactical precision of the highest order, we shall define the Hegelian syntactical historical form by virtue of Alan Jackson's disdain for paper towels. Yes, the Overton window morphed into a benevolent, beautiful form in order to explicate to the wider public Alan Jackson's disdain for paper towels. Yes, ladies and gentlemen, I have thought about this subject deeply because I am a towel. But yes, a few things I want to do, ladies and gentlemen, a few things I want to do this morning. The first is we have an update, as I mentioned, from our venerated Christina Towel. And Christina Towel has told us, because of her amazing work, that there have been some developments related to the Stay Puft Marshmallow Man and Chewbacca. Now, you might be saying, Grant, why is the Stay Puft Marshmallow Man relevant to this? And I could show you the clip, but I think it's more important for you all just to understand that Alan Jackson, out of nowhere, brought up the Stay Puft Marshmallow Man during a cross of a firefighter. And so, ladies and gentlemen, I must say, first of all, yesterday you may have heard that it was raining outside of Norfolk Superior Court in Dedham. Ladies and gentlemen, Chewbacca and the Stay Puft Marshmallow Man do not do well in the rain. As you can see, according to Christina, with her on-the-ground reporting, Alan Jackson may indeed be getting ready to call Chewbacca and the Stay Puft Marshmallow Man to the stand because they were somehow soaked yesterday in the rain in Dedham. They were the only 2 people outside the courthouse who were members of the media. Yes, ladies and gentlemen, this was Christina's on-the-ground exclusive reporting. We managed to discover that the Stay Puft Marshmallow Man and Chewbacca do not do well in the rain. Yes, the Stay Puft Marshmallow Man seems to have shrunken from his 200-foot-tall form down to a mere, I don't know, somewhere about 5'10" there. Chewbacca's probably about 6'5", so maybe a little bit under 6 feet or so, and I bet that was very demoralizing to the Stay Puft Marshmallow Man. And yes, ladies and gentlemen, there was a question from the venerated Trevor McIntyre whether this Free Karen Reed crowds are shrinking. They went from 11 last week to 0 on Monday to 4 yesterday. Ladies and gentlemen, the crowds have simply been decimated because the Free Karen Reed movement was likely artificial for 2 reasons. 1, Karen may have been paying for crowds at a certain point, and 2, the feds may have been using the Free Karen Reed movement as a honeypot in order to generate leads about the state police, which eventually led to the cover-up of Sandra Birchmore's murder being exposed. But yes, ladies and gentlemen, we'll get back to that in a minute because yes, Christina is a legend. These visuals and on-the-ground exclusive reporting are wonderful. But yes, ladies and gentlemen, we have another update. According to Christina, she spent a lot of time discovering this. It took her a long time to get this exclusive. Chewy may have taken the bar, okay? The Stay Puft Marshmallow Man got so concerned about having to get called to the stand and the potential for Rule 17 subpoenas and just trying to fit his 200-foot-tall self into Norfolk Superior Court that he had Chewbacca pass the bar, according to Christina's reporting. And now Chewbacca will represent the Stay Puft Marshmallow Man if Alan Jackson tries to call the Stay Puft Marshmallow Man to the stand. And you might be saying, I don't think 7-foot-tall Ewoks named Chewbacca can be lawyers in Massachusetts. And I would say to you, ladies and gentlemen, I did not discover this. Christina has found proof that Chewbacca is in the courtroom with the Stay Puft Marshmallow Man in front of the bar with a suit. Therefore, ipso facto, QED, Chewbacca is a lawyer. Now, I realize that's a lot of logical inductions there, but if you think about the logical syllogism that I just laid out, it is proof positive that Chewbacca is not only clearly a lawyer, but that he is in the courtroom representing the Stay Puft Marshmallow Man to protect the Stay Puft Marshmallow Man from Alan Jackson should the Stay Puft Marshmallow Man be called by the defense in the Karen Reed and John O'Keefe case, and should Alan Jackson issue Rule 17 subpoenas to a 200-foot-tall marshmallow. Now, listen, normally this would be an absurdity. There would be no way in just the realm of any possibility that Alan Jackson would be doing this. But, ladies and gentlemen, venerated reporter honorary towel Christina has confirmed for us those two pieces of information. Yes, hello, Angela Powell. It's great to see you. I hope you're enjoying our morning update from the venerated reporter towel Christina, who has found exclusive information that Chewbacca who is actually Chloe the dog, in a wig, has passed the bar and is now the Stay Puft Marshmallow Man's lawyer. Okay, but, ladies and gentlemen, there is one more, even better, exclusive piece of information. Good morning, Bina. Hello. Ladies and gentlemen, we don't have to watch the fan at all today. Do you know why? It might have been Christina during her exclusive interview, Christina, the honorary towel, but somehow, some way, we also convinced the Stay Puft Marshmallow Man and Chewbacca to help us not have to look at the fan. And you might be saying, Grant, I'm tormented by the spinning fan. How is it possible that a marshmallow man and a dog in a wig who looks like Chewbacca has solved this problem? Well, ladies and gentlemen, there you go. We don't have to look at the fan spinning anymore. We can simply look at a picture of the Stay Puft Marshmallow Man and Chewbacca in court. There you go. It's all you could have ever wanted. Christina Towell is truly an excellent on-the-ground reporter, ladies and gentlemen. Yes, we now not only have the insights into Chewbacca, who's actually a dog named Chloe in a wig, becoming a lawyer to protect the Stay Puft Marshmallow Man, but all day, if we need to watch the fan spin, we can instead look at our two favorite people of all time, the Stay Puft Marshmallow Man and Chewbacca, who have stopped the fan from spinning. Yes, ladies and gentlemen, it's coming up on 7:40 in the morning. We are waiting for the 9 a.m. start of testimony on day 11 of the John O'Keefe and Karen Reed trial. We have no idea what's coming next, but we certainly are pleased to start the day with an update from our exclusive towel correspondent, Christina, who has tracked down an extensive series of developments related to the Stay Puft Marshmallow Man and Chewbacca. Now, I heard some questions about very importantly, I heard some questions, ladies and gentlemen, about what Alan Jackson said about towels yesterday. Now, I want to do a few things here, ladies and gentlemen. The first thing, ladies and gentlemen, please bear with me. The first thing I want to do, fellow towels and towelettes and washcloths and paper towels, in particular paper towels today, on the day in which they are recovering from being smeared by and mistoweled by Alan Jackson. They were called rags, ladies and gentlemen. And soap dispensers and flannels and beach towels and hemp towels and every kind microfiber towels, every kind of towel out there. And washcloths, of course. Ladies and gentlemen, we must first, just to prove my point, before you say, listen, I've tuned into this stream, and on this stream I have found a man talking about the Stay Puft Marshmallow Man. Now, before you critique me for that, I must defend my honor, ladies and gentlemen. I must defend my honor. And in order to do so, I must show you a video where Alan Jackson extemporaneously, out of nowhere, as an excited utterance in open court, brought up the Stay Puft Marshmallow Man. Now, I normally I wouldn't feel the need to defend my honor here, but I feel like it is such a ridiculous situation. It is so nonsensical. It is so absurd that the only way I can defend my honor is by bringing this clip of the Stay Puft Marshmallow Man. Now, the better part of this is that there is also a section of this clip where the Stay Puft Marshmallow Man, perhaps with Towel's help, is next to the witness on the stand. That makes it absolutely hilarious. All right, I'm searching this. Yes, I am that dedicated to my... I found it, ladies and gentlemen. Oh, it is a glorious day for towels. I have found the clip of of Alan Jackson for no reason, bringing up the Stay Puft Marshmallow Man. We shall watch it together. We shall be towels, and I will prove my point to the wider towel universe. Yes, I'm not gratuitously doing this. Here we go.
Not to get too colloquial, but a puffy coat is like, it's got down and stuff in, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay, hold on. Listen to that clearly. That cannot be misinterpreted.
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay.
You heard it, ladies and gentlemen. Alan Jackson, not Little Towel, brought up the Stay Puft Marshmallow Man. I will absolutely continue to stand by that. But now listen. I understand that there were some very serious concerns among the towel universe about what Alan Jackson said about paper towels. So before we dive into any more recaps about yesterday, day 10 presentation of evidence, let us go right to the issue that truly is on the minds of the towel friends from South Africa to Germany to the UK, to Australia, to the Americas, to Bosnia-Herzegovina, or Bosnia, I don't know, I think there's still one country. I know Edin Dzeko played for Man City, so I think it's Bosnia-Herzegovina. It's tough to follow developments in the Balkans, ladies and gentlemen. Geopolitics there is very convoluted, but I'm doing my best, and I really want to go to Croatia one day to visit the town of Split. Anyway, going back to my point, all the towel friends across the world have on the forefront of their mind, how did Alan Jackson, first of all, bring up paper towels in the trial? And second of all, why did he insult them? And we will answer that question now. Okay, this is the sobering clip. Ladies and gentlemen, I want to give you a heads up. This clip is a little disturbing. If you are a paper towel in particular, I highly recommend that you cover your ears. I don't think it's appropriate for paper towels to listen to this clip, especially if you have younger paper towels around. It is disturbing, it is offensive to towels, and it is hurtful. Alan Jackson just cannot help himself, ladies and gentlemen. He continues to go off the rails. Come on, clip. I know you can do it, Little Towel. I found the moment. Let's listen.
Do you see the rag in that photograph as well?
Yeah, we could call it agree to call it a rag or a paper towel.
You think it's a paper towel?
I'm not sure. It looks like a paper towel on the in the pictures, but it's a white object. Yes.
For all I care, it's the white thing. That's
yes.
Fine. All right. And do you see that that's next to a tire just at the top of the picture, just for orientation purposes?
Yeah, it appears to be 18 to 2 feet, 18 inches to 24 inches behind the tire. Yes.
Okay, and that, of course, is the tire of the.
You heard it, ladies and gentlemen. You heard it. Alan Jackson mistoweled a paper towel. It absolutely caused a ruckus. There was a towel poll. 88% of the towel fans and friends and universe said, well, I don't think any towels are actually a fan. We are going to prevent fans from being towels, but that's another discussion. Ladies and gentlemen, 88% of the towel universe was offended by that remark. You cannot just mistowel a paper towel. You cannot do that kind of thing. It offends every single constituent element of the towel universe. We arose with one voice and we said, no, Mr. Jackson, no, you must show more respect to paper towels. In fact, there was just a rallying cry of support for the paper towels. Oh, my word, ladies and gentlemen, you should have been there. It was one of those days where you truly felt proud to be a towel. All right, but yes, welcome to the Honorary Towel Fold Color Box 101. I love how you spell the word color. Now, the next thing we must get caught up on, ladies and gentlemen, is we saw further, never before seen footage of Karen Reed played for jurors during yesterday's trial, and this was one of the moments, probably one of the biggest moments of the day, but we will review all of the moments together as we prepare for the start of testimony in just over an hour and 15 minutes at 9 a.m. Eastern. My name's GrantSmithEllis. I'm also known as Grant, Howard Cosell, David Attenborough, Taillight, and I'm here with you either way.
So when John got out of the car at Brian Albert's house, he took my full vodka soda, which is sitting in the cup holder.
Thank you.
The comment?
That.
Thank you.
All right, your next witness.
One more, please, Your Honor. The Commonwealth moves into evidence and seeks to play clip number 17, please.
Okay.
I gave an interview with ABC with Matt Gutman. I think this was whom I gave the interview to, and I said, he asked why was I saying, could I hit him, did I hit him? And I said, yeah, my first thought was, I'd been out late, I'd been drinking, and he's in the general vicinity of where I last saw him. I mean, they talk about the left side of the property and the right as if it's, Hammersmith Farms. It's a postage stamp. It's 50 feet. So he's in the front yard to the left of the front door, and no one's coming out of the house. Jen's telling me nobody's seen him. So I'm thinking, Jesus, was I starting to pull away and I ran over his foot? Like, he's roughly where I left him. So yeah, when I found him, I was thinking, did I clip him somehow?
Same jump drive has clips.
Okay.
Thank you.
So in order, it has 18 and then 17, or are they in the reverse order on the clip?
If I may see the exhibit. This one exhibit contains clip 12, clip 12A, clip 16, clip 17, and clip 18, all which were previously introduced.
Okay.
Oh my goodness, it's Murder by Maestro. And it's JI5 and Lisa Cox and Alana. Oh my goodness, ladies and gentlemen. And we even have a Dr. Marie Russell parody account with us among the honorary towel fold now. Congratulations, Dr. Marie Russell parody account. We are glad to welcome you to the honorary towel fold. Also, Murder by Maestro, every single time he pops up in the chat, because he is a 24-year-old who speaks hexadecimal, I just start becoming an animated towel, and there's nothing that can be done about that. Okay, we have other things to do, though, ladies and gentlemen. One of the things I want to look at is we just saw the never-before-seen footage of the clips of Karen. Very devastating, admitting that the last place she saw John O'Keefe is where John was discovered, where his phone data showed from after 12:32 a.m. and 16 seconds on January 29, 2022. The alleged moment Karen backed up her car with a BAC between 0.14 and 0.28, which is 2 to 4 times the legal limit, to 24.2 miles an hour. And then within a millisecond upon the moment of alleged impact with John, reduced to 23.7 miles an hour with a 4.7 degree steering wheel correction to the right. The exact place where John's phone showed he never moved from that alleged moment of impact until after 6 a.m. That morning, when he was discovered lying on the lawn, dying, dead from a traumatic brain injury after he potentially stumbled up the berm of the lawn and then fell and hit his head, coupled with hypothermia as indicated by the reddening of John's pancreas. Yes, ladies and gentlemen, that's why Karen said in previously unaired footage that she thought she hit John. She knew it, ladies and gentlemen. She knew it, and the jurors heard it. Now, ladies and gentlemen, let's watch what was even more devastating. The voicemails, oh, the devastating voicemails involving Karen Reed screaming very, very inappropriate things, vile things at John O'Keefe. We're going to listen to them. This first one, 12:37 a.m., right as Karen's arriving back to John's home after driving from Fairview to Meadows Ave in Canton. Right between 12:32 and 16 seconds and 12:37, Karen drives back. You can easily do that drive in 5 minutes, especially if there's no traffic as snow's falling, very light snow, and there's no one on the roads. You could do that in 4 minutes, in 25 seconds to 5 minutes, maybe a little bit more depending on the route, which is exactly what Karen did. Ladies and gentlemen, Karen Reed was arriving back at John O'Keefe's home, connecting to his Wi-Fi right around 12:37, and she called the man who she had just allegedly hit while drunk driving and left him to die in the snow, and left the following voicemails for a man who was alone on a lawn in a blizzard dying. Let's listen to the true face and voice of Karen Reed that was hidden from the world via an insidious PR campaign for years, but overnight splashed the headlines of papers across the country and across the world, and for that matter, embraced within the towel fabric of the universe. That message also continued to resonate. Let's listen. It was horrifying. Cover your little towel's ears if they are in the location. This footage is graphic and disturbing, and it features a Karen Reed bared for the world, her true soul on display.
At 12:38:26 a.m., the defendant calls John. It's not answered. 12:39:03 a.m., the defendant calls John. It's not answered. 12:39:37 a.m., the defendant calls John. It's not answered. 12:40:43 a.m., the defendant calls John. It's not answered. At 12:41:35 a.m., the defendant calls John. Voicemail number 2 is left. Some beeping noises, appears to be a butt dial or accidental call.
Ms. Gilman, could you play the voice message at 12:41:35?
The defendant then texts John O'Keefe at 12:55:31 a.m. on the 29th, "I'm going home." The defendant texts John O'Keefe, "See you later," at 12:55:50 a.m. on the 29th. At 12:58:19 a.m., the defendant calls John. It's not answered. 12:58:47 a.m., the defendant calls John. It's not answered. 12:59:24 a.m., the defendant calls John. Voicemail number 3 is left with voice.
Ms. Gilman.
John, I'm here with your fucking kids. Nobody knows what the fuck you are, you fucking pervert.
At 1 a.m. 26 seconds, the defendant calls John. It's not answered. At 1 a.m. 49 seconds, the defendant calls John. Voicemail number 4 is left. It's 1 second called, no sound.
Ms. Gilman.
That was it. The defendant texts John O'Keefe, "Your kids are cucking alone," at 1:02 a.m. on the 29th. Defendant texts John O'Keefe, "I'm back in Mansfield. The kids are home alone," 1:04:14 a.m. on the 29th. At 1:10:17 a.m., the defendant calls John. Voicemail number 5 is left with voice.
Ms. Gilman?
Yeah, it's 1 in the morning. I'm with your fucking niece and nephew. You fucking pervert. You're a fucking pervert.
At 1:10:44 a.m., the defendant calls John. It's not answered. At 1:12:18 a.m., the defendant calls John. It's not answered. 1:12:46 a.m., the defendant calls John. It's not answered. 1:13:13 a.m., the defendant calls John. Not answered. Sorry. At 1:14:11 a.m., the defendant calls John. It's not answered. 1:14:44 a.m., the defendant calls John. Not answered. 1:16:10 a.m., the defendant calls John. Not answered. 1:16:38 a.m., the defendant calls John. Not answered. At 1:17:37 a.m., the defendant calls John. So when voicemail 6 is left with voice.
Ms. Gilman?
John, I'm going home. I cannot babysit your niece. I need to go home. You are fucking using me right now. You're fucking another girl. Kim's sleeping next to me. You're a fucking loser. Fuck yourself.
At 1:18:38 a.m., the defendant calls John. Not answered. At 4:38:14 a.m., the defendant calls John. Not answered. 4:38:49 a.m., the defendant calls John. Not answered. 4:39:39 a.m., the defendant calls John. Not answered. 4:40:05 a.m., the defendant calls John. Not answered. 4:42:05 a.m., the defendant calls John. Not answered. 4:42:54 a.m., the defendant calls John. Not answered. 4:45:10 a.m., the defendant calls John. Not answered. 5:04:27 a.m., the defendant calls John. Not answered. 5:21:28 a.m., the defendant calls John. Not answered. 5:21:58 a.m., the defendant calls John. Not answered. 5:23:26 a.m., the defendant calls John. Voicemail number 7 is left with voice.
Ms. Gilman?
At 5.
Pause, ladies and gentlemen. Now, we have Murder by Maestro in the chat. And do you know what that means, ladies and gentlemen? We are going to watch one of Towel's favorite clips, because why is that 5:23 a.m. voicemail where Karen screams, "John, was that you?" Now let's listen to it one more time.
At 5:27 a.m., the defendant calls John. Voicemail number 7 is left with voice.
Ms. Gilman?
One more time. Did you hear that, ladies and gentlemen? Did you hear that? I'm telling you, folks, we now are going to look at some information indicating from Karen's Lexus GPS that it's very possible Karen Reed went back to the scene that morning of John O'Keefe's death at around 5:23, and she may have tried to hide her cell phone data, but there's already camera evidence of Karen leaving John's house at 5:07 on video, at 5:11, driving towards Canton Center, on video at 5:18 a.m. coming out the other side of Canton Center. And ladies and gentlemen, just a little bit later, there is at 5:23 a.m. when that voicemail was left, there is strong evidence, potentially from Karen Reed's SUV, that she went back to the scene. And yes, ladies and gentlemen, Murder by Maestro himself, the honorary towel, the super towel, the 24-year-old hexadecimal speaking wonderful person. Ladies and gentlemen, let's see what Murder by Maestro put together for us little towels so we can learn about how big that 5:23 a.m. call really is. Here we go. I didn't even catch that the first time. Did you all hear what he just said? The best laid plans of mice and men, folks. The best laid plans of mice and men.
What he realized is that all of that data was unreadable.
And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. Navigation information, phones that were plugged into the radio, travel logs, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also, in the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips.
Wait a minute, I didn't even catch that the first time. Did you all hear what he just said? Hank Brennan said that it wasn't just that only 1 of the 3 chips was read. The reads expert used the wrong software or the wrong chip reader, which is hardware. Oh my God. Oh my God. Oh my God. Murder by maestro. You were right to be yelling from the rooftops about this, my friend. I will tell you right now, you nailed it right on the money. Could not be any more prescient. Nailed it. Nailed it. Nailed it. Absolutely 100% nailed it. There is a lot there, folks, and we haven't even heard the disclosures about what this detail is going to contain. I have my prescient forecast based on my extrapolation of all of the evidence in this case, being one of the few people who has read every single thing on this godforsaken 700-item docket at this point. But I'm telling you, folks, I'm telling you this is huge. I'm telling you now that it's huge, because it wasn't just the chip-off was incomplete and only 1 of 3 chips was extracted and read. It was that the wrong software was used initially, too. Oh, my God. Oh, my God. It was definitely, I have a strong feeling Karen Reed's expert was like, oh my God, I can't believe Lally's letting me do this. Let me give myself some plausible deniability. Well, Brennan's got all 3 chips now, and the data went from 2.4 gigs to 8 gigs. Oh my word. I'm so glad we watched this. Now, ladies and gentlemen, let me explain something to you about the implications of this. We'll watch another clip with Hank Brennan and Towell's wonderful map. Ladies and gentlemen, listen. What this is talking about is, so not only is there, and I'll show you the map more closely, not only is there video evidence of Karen's Lexus, her black Lexus, driving at 5:08 a.m., 5:11 a.m., and 5:18 a.m. in a direct line through Canton Center, out the other side near the purple line, and then over towards Fairview Road, where you take a right at this weird intersection, drive up like 500 yards, and then take a left onto Fairview. And that is the same exact way if you took that left onto Fairview, and then if you kept going straight and taking the left onto Fairview, that is where, if you just kept going straight, you'd eventually get to Jen McCabe's house if you kept going straight on that road and didn't take a right to go back to John's house, but instead stayed straight and then eventually took a left. So do you see what I'm saying, ladies and gentlemen? There is a 17-minute gap between 5:08 a.m. and 5:35 a.m. It does not take 17 minutes to drive from One Meadows Ave to Jen McCabe's house. If you drove the direct route, it would take less than 5 minutes. Even if you drove through Canton Center to, quote, look for John, the route that takes you, very conveniently enough, right past Fairview Road, it wouldn't take you 17 minutes. But you know what might take you 17 minutes? If you drove slowly through Canton Center, got to the train tracks around 518, instead of going from the train tracks to Jen McCabe's house, you took a left onto Fairview Road, got there around 5:23, either tried to pick up Taillight, confirm John was dead, whatever it was, and then went to Jen McCabe's. That would put you at Jen McCabe's at 5:35 a.m., ladies and gentlemen. And if you don't understand what the insight was about Karen's Lexus GPS data, we haven't seen it presented yet. But because during the first trial, ADA Adam Lally and the prosecution team, for some reason, let Karen Reed's expert, named Maggie Gaffney, who's on the witness list for this retrial, do the chip-off of Karen Reed's Lexus infotainment system, which has time and place and location data and when phones connected and disconnected. Ladies and gentlemen, only 2.4 gigs out of 8 gigs from that infotainment system was read the first time around, because Karen Reed's expert used the wrong chip reader, which is a piece of hardware, and only extracted 1 of 3 chips. Hank Brennan's expert, who we believe is from Aperture, maybe we don't know exactly who did the chip off, that expert got all 3 chips read, as you just heard, got 8 gigs of data, ladies and gentlemen. And that data may well show what Karen tried to hide from the world. Her return trip to Fairview Road, when that voicemail was left. John, was that you? Now listen, she has a Fall River accent. Ladies and gentlemen, You can't interpolate it based on you have to get through the intonation. It's John, where are you? Okay? John, was that you? Not John, where are you? Someone was saying, John, where the F are you? No, there's no cuss in there. It's a short phrase. John, was that you? Now, we can listen to it one more time, ladies and gentlemen. Let me bring this up for you one more time. Now, you have to think about this from the perspective of Karen's accent, okay? Please keep that in mind. She has a Fall River accent. So, John, was that you? There's an inflection on the was. It goes up. Was that you? It's 4 words. If she said something like, John, where the F are you? All of it would be drawn out like in her other F words. You don't, when you say those words, you really draw them out with that accent. So she's not saying a lot of words. She's saying, John, was that you? It's 3 seconds. She can't put more words in. It's very quick. So let's listen to it one more time.
Ms. Gilman.
John, was that
Ms.
you?
Gilman.
It's John, was that you? It's 4 words, ladies and gentlemen. John, was that you? I'm telling you, Christina said she sent it slow down. I think what we can do here is, let me change the playback speed. Let me see. Oh, yeah, we can just listen to it slowed down here. Listen to this.
Voice.
Ms. Gilman.
There's some echo. It's John, was, and then the AS echoes a little bit. John, was, us, that, you. Ladies and gentlemen, no, color box. I'm telling you, I'm from Massachusetts. I could tell you that the kids are down the park and I want to go down the Cape or whatever. I'm telling you that she is saying, and we can play it again, John, was that you. I'm telling you that's what it says. I know her accent. I've been around her. She's never answered my questions, but I've heard her talk 85 times at least. She's saying, John, was that you? So let's listen one more time. So it's John, the N hangs, okay? John, was, the AS echoes, was, us, that, you. John, was, is, that, you. Exactly. It's one of those 2 phrases. It was not John, where the F are you? There's not enough time. It was not John, where are you? It is John, was, is, and it ends with you. John, was, I think it's John, was, that, you. No, we're not playing it backwards. Now, what we can do, though, is we can play it at 0.25 speed, okay? And we'll do a dynamic audio analysis here to the best of our abilities. Let's listen to it again at 0.5 speed this time, okay? Hold on. Got to start at 6:01. All right, ready? I understand why you guys are getting confused. She's saying John and then hiccuping or breathing in. John, was that you? Folks, no, John, was that you? It's 4 words. We'll listen to it one more time. There's a little bit of an echo, okay? But it's John, was that you? Oh, I get why you're getting confused. So do you see at the end of John, she's saying, John, was that you? So I'm going to imitate it for you. John, was that you? So that's why you're hearing that kind of little bit of an inhale there. But I have headphones on. I can hear it very clearly. It's John, was that you? Yeah, no, I mean, but Christina, listen, I'll listen to your audio here, but we are listening to it dynamically at the rate, and your audio might also be cleaned up, so it might not be. So I'll listen to it now. Hold on, one more. Yeah, so this is edited, Christina. The voice here is pitched down, and it's clearer, but whoever did this edited, the video you sent is edited in post. We're not actually, this is the raw audio feed from the court. and there was an echo. So the person that you, Scott, sent that audio file from removed the echo and then reduced the actual tone of Karen's voice to make it clearer, and it does clearly say, John, was that you? But the way we're listening to it is its original form. I'm not cutting out anything. There was an echo. Karen's voice is higher pitched, and we're going to listen to it one more time. And I want you all to just one more time really pay attention to what Karen's saying here and listen to specifically the end of when she says John. She's not saying John conversationally. She's screaming it. She's holding the end. She's hanging it. John, is that you? There's a JOHNNNNN. Breathe in. Was that you? So let's listen one more time. Do you see how it's not a word? Exactly, Christina. It's not a word. She's gulping between John. Was that you? So yeah, it's clear as day. Now that I've listened to it on different speeds, John, was that you? Yep, exactly, Alex. You nailed it. You nailed it. She was excited. She was screaming. So when she said John and hung the end, she breathed in. Was that you? Absolutely. Yeah. No, I know. But Murder by Maestro, I'm from around here, and so the accent, I'm very attuned to her accent in particular in different moments, because I've heard so many clips. I've heard her in panic. I've heard her mocking people. I've heard her screaming. And so I know that she said in that clip, John, was that you? I would bet everything. I'm not a betting man really, although I use free promotions. I would literally bet everything I know about this case on the fact that she said, John, was that you? I've never been more confident about something related to this case in my life. There's no room for interpretation on my end. John, was that you? No question. And now listen, we're not done with this, folks. We have a little bit more to look into, because what Towel wants to bring up for you all is my towel map. I made a towel map, ladies and gentlemen. Yes, I made a towel map. Yes, the towel map is very detailed. And yes, the towel map has Hank Brennan talking even more about Karen's Lexus infotainment system, which may prove the devastating final blow that decimates the Reed defense. Now, I think it was under Return to Fairview. I'm going to find it. I am a towel. I am a towel who is intent on locating this clip, ladies and gentlemen. Now, how about, I think it was like 5:20. I think we could do 5:23 a.m. to find it, because that's a very specific time. Yes, ladies and gentlemen, I want my map, my glorious map. No, that's not it. Let's see. GPS. I know if I put in GPS, it will be in there, because I always am talking about Karen's Lexus GPS data. All right, so there was the Murder by Maestro clip. But where is the map clip? I would like my map, ladies and gentlemen. I would like my map. I made a wonderful map. Hank Brennan talked about, maybe infotainment. I feel like that word is so specific. I found it, ladies and gentlemen. I found it. I found the map and the clip I wanted to show, because I am a towel. So there we go. Oh, your comments may have gone off the screen for a second. That is okay. I will bring them back now. Ladies and gentlemen, I found the clip I wanted to show you. Let's watch it together. Let's listen to Hank Brennan explain even more what this could be, what this Lexus, and how it ties into the voicemail that jurors heard yesterday.
Account for all discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. There's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday. That's all included.
All right,
the analysis is done. The accident reconstruction is done.
Got the point, folks? Was that you? And you just saw it. You see Towel's map. A little bit hard to see on the broadcast. That's okay. But the point is, Towel has understood the implications of that voicemail, and now you all do as well. And Murder by Maestro, our dear Towel friend, I pinned your comment for a reason, because we do want to look at the devastating images of Karen Reed's taillight broken at 8:23 a.m. on Canton Police dash cam footage that we have seen, that the jurors have now seen. Yes, ladies and gentlemen, here it is. Towel is getting you fully caught up if you missed yesterday's day 10 of testimony in the Karen Reed and John O'Keefe trial. It's coming up on 8:15 a.m., just 45 minutes or so until testimony resumes today. We don't know who the witnesses are going to be. We don't know what clips of Karen may be played. My word, ladies and gentlemen, I am in Howard Cosell Towel mode for good reason. Let's begin. The clip, the taillight, the devastating testimony.
Could you stop, please, Ms. Gilman? I note that the time is 8:23:10. Do you remember the time when you got there?
I didn't make note of it mentally at that time, but I've since learned that, yes.
Is this video that you have just watched consistent with your memory that morning?
Yes.
The cruiser cam is showing two vehicles in the driveway. When you arrived that morning, did you know whose vehicles they were?
At that time, no.
At that time, did you pay any particular attention to either of those vehicles?
No.
If I could show Exhibit 10, please. So does that appear to be a still photo from the video we just watched?
Yes.
And could I have Exhibit 11, please? When you arrived for the wellness check that morning, were you working as an investigator in any way?
No, I was not.
Did you happen to pay any particular attention to the right side of the back of that car that morning?
No, I did not.
And is that photograph a close-up of the previous picture?
Yes.
Does it appear to be a still photo taken from the video on the cruiser that you were driving that morning, or that you were in that morning?
Yes.
Okay, you can take that down, please. Thank you. After you arrived at Meadows, did you do anything?
All right, ladies and gentlemen, you heard it there. You saw it, the broken taillight. Now, I will tell you, folks, there is one other important thing we have to talk about this morning. There are already so many Towel friends watching. We may break a Towel stream record on YouTube before the testimony even begins. Pardon me about that. Towel friends, I swallow air from sometimes because I have a disability wherein my esophagus and airway don't really function correctly. It's unfortunate. But yes, ladies and gentlemen, what I want to show you is there was a discussion by Henry Blue today, okay? Henry Blue, yesterday there was a motion in the Karen Reed trial from state prosecutors to prevent, which was just a renewed form of an oral motion from earlier in the pretrial process, to prevent Karen Reed from bringing up the Sandra Birchmore investigation. Now, if we take a look at that motion, okay, it's right here. It's from, I know I posted it at some point because we got it early in the day. Here it is. I'm a towel. And this is the ruling. It was a motion from the state that the Sandra Birchmore probe was irrelevant and that therefore the Reed should not be allowed to mention it. Now, we are going to watch a video that explains the context. Yes, the same unit who investigated Karen Reed for John's death also allegedly, potentially covered up Matthew Farwell murdering Sandra Birchmore. However, there is no Karen Reed in that investigation had nothing to do with the cover-up of Birchmore's murder. The investigation of Karen being responsible for John's death was clean. That's why there is no federal probe. It's closed into John's death, but it's likely that the federal probe into John's death, which heated up over the summer of 2023, was a honeypot to get information on the MSP and the state police, and that honeypot with Aiden Kearney involved and with the feds as well. You're going to see the explanation. May well, ladies and gentlemen, have led the DOJ to uncover the MSP writing off Sandra Birchmore's murder as a result of self-harm when it was actually the result of Matthew Farwell and his actions. And the reason why it's so likely that happened is if we go back to February 1st, 2021, the night Sandra Birchmore was murdered at 9:23 p.m. or so, Matthew Farwell was spotted on surveillance camera in Sandra Birchmore's apartment. Now, 3 days later, the investigation starts when Sandra's discovered. Her school where she worked puts in a wellness check. The police find her. It's February 4th, okay? Within 48 hours, February 4th to February 6th, the Canton police, because they help investigate until the state police take over. The Canton police, okay, they confirm Farwell was at Sandra's apartment at the exact moment of the murder. The maintenance worker from the Sandra's building tells the Massachusetts State Police that Farwell was the man who helped Sandra move into her apartment, and he was there at the moment Sandra died. The Canton police get evidence from people at Sandra's school that Farwell knew Sandra was pregnant, and Farwell had been abusing Sandra since she was a child, and that Sandra was going to have the baby, and that if Sandra didn't stop the baby from being born, Farwell would, quote, take care of the problem himself. Canton police turned that over to the state police unit. The state police unit detailed to the Norfolk DA as two people that used to work for the Stoughton police with Matthew Farwell. Okay, the person who killed Sandra was a cop in Stoughton named Matthew Farwell, allegedly, according to the feds. Now, two of those troopers, the guy who wrote the report on Farwell and exonerated him, was John Fanning. He used to work in Stoughton, and Yuri Buchnick also used to work in Stoughton. Both then went on to the MSP unit detailed to the Norfolk DA. Now think about this, ladies and gentlemen. We know there were more cops involved than just Farwell with abusing girls in Stoughton, young girls. We know that Farwell's brother was potentially involved. We know that there's another guy in front of the post-commission, Robert Devine, who might have been involved. And ladies and gentlemen, we also know there may have been more victims. Ladies and gentlemen, I'm telling you, there may have been more victims of this ring of cops. And further, Matthew Farwell is charged with murder of a cooperating witness under a federal statute that only allows charges if the witness was cooperating with a federal official or judicial proceeding. How do I know this? I looked at the statute. Ladies and gentlemen, we need to think about this in context here. Henry Blue, who is definitely potentially Karen, according to people online, is trying to spread misinformation. Of course, the Sandra Birchmore murder investigation should not be brought up in the context of Karen's trial. But that's a distraction from the real issue, which was Karen got a favor from the old DOJ in Boston under Josh Levy, who's now suing President Trump on behalf of Harvard, and Rachel Rollins, who had a grudge against the Norfolk DA, and Dustin Chow in the public integrity section, who had a grudge against the Norfolk DA. Karen and David Yianetti, who was on Rachel Rollins' transition team when she became Suffolk DA. Ladies and gentlemen, Rachel Rollins, who got forced out of the U.S. Attorney's Office by the DOJ's Office of the Inspector General in May of 2023 because Rollins launched a pretextual probe after Rollins' ally Ricardo Arroyo lost a primary for Rollins' old Suffolk DA seat to Kevin Hayden. Rollins launched a probe into Hayden pretextually and leaked it to the Globe and Herald and then got forced out of office. Ladies and gentlemen, the implications here are astounding. It means that Karen Reed got a wink and a nod from the old DOJ because she helped uncover or helped the DOJ stumble on to the Sandra Birchmore cover-up. And by August of 2023, according to public remarks from former U.S. Attorney Josh Levy, the probe was looking into Birchmore's murder, ladies and gentlemen, no longer John's death. The federal probe. And yes, they were overlapping, but they're not tied to each other. They're only tied to each other to the extent that there was potential federal corruption, with Josh Levy allowing Karen's witnesses from ARCA to violate Judge Cannoni's sequester order during the first trial. Josh Levy potentially allowing Karen and her lawyers to hide payments and communications involving ARCA from the state trial judge, Judge Cannoni, and from state prosecutors. Ladies and gentlemen, it all changed when the new DOJ came into town. That's why this whole case has shifted. That's why the dynamic has changed. Because the new DOJ, well, they recognize the value of what Karen helped them, the old DOJ, uncover related to Birchmore's murder and the cover-up thereof. They realized the DOJ was playing loose and fast with Karen and her lawyers to just take out spite against the Norfolk DA. And that's why the new DOJ under U.S. Attorney Leah Foley, in my opinion, realized that this was a black mass redo. Karen was reprising the role of Whitey Bulger, and the FBI and the DOJ had looked the other way. And ladies and gentlemen, that's why the new U.S. Attorney confirmed the end of the federal probe into John's death and released the documents under the TUI protocol, which is established via U.S. ex-rel TUI v. Reagan from 1985, as interpolated by 28 U.S. CFR 126.000, which is itself interpreted in Section 25 of the DOJ Operations and Sections Manual. That's why U.S. Attorney Leah Foley on January 30th, 2025, released the slight sliver of information, the header of an invoice between Reed and Arca, that within 14 days forced Reed's team to disclose those hidden payments and contacts. Then the federal probe was confirmed as over. Ladies and gentlemen, then Josh Levy sues President Trump on behalf of Harvard. Do you see what's happening? U.S. Attorney Leah Foley came in and cleaned house. But there was some merit to the Birchmore cover-up being real, and that's the big secret. Will Matthew Farwell cooperate? His hearings keep getting pushed back. Will that lead to the arrest of people who potentially facilitated that cover-up? Oh, ladies and gentlemen, it is all tied together, and we can watch Towel lay it out now. How do I know that? Because, ladies and gentlemen, I explained it all for you yesterday, and to rest little Towel's voice, we will listen to that as we wait for court to come into session today, because I am a towel. And yes, I do know all of this by heart, but I want to rest my voice. Josh Levy, I'll be happy to play a clip overviewing that. Okay, so we have a question about Turtle Boy, Rachel Rollins, Josh Levy. I'll be happy to play a clip overviewing that. Basically, the overview is Turtle Boy, Aiden Turtle Boy Kearney, just before the Karen Reed trial even started, just keep this background in mind. Turtle Boy had a connection to the former Suffolk District Attorney turned former U.S. Attorney Rachel Rollins, who was very liberal. Rollins was very liberal. For some reason, Turtle Boy and Rachel Rollins had direct communication during the 2020 Senate primary in Massachusetts between JFK Jr., one of the Kennedys, red hair guy who used to be a representative for the Massachusetts 4th District in the Federal House of Reps. Joe Kennedy Jr. or something. Joe Kennedy Jr. ran against a guy named Ed Markey for JFK's old Senate seat in Massachusetts in a Democratic primary. For some reason, Rachel Rollins, at the time, it was either Suffolk DA or maybe U.S. Attorney, was working with Turtle Boy. No, she was Suffolk DA at the time. Working with Turtle Boy to send a Republican spoiler candidate named Rayla Campbell to events for Joe Kennedy Jr. Now, you might say, why would they do that? Well, Rachel Rollins, I think, really wanted Joe Kennedy Jr. to lose that primary. And you might say, well, that's a little weird. Why? Well, the Democratic Party establishment, I think, saw Joe Kennedy Jr. going up into JFK's old Senate seat as a potential trajectory for Joe Kennedy Jr. to challenge Joe Biden in the 2024 primary. Now, in hindsight, for the Democratic Party, although I'm apathetic about this, that probably would have been better than what happened, the disaster that was Biden trying to run and then dropping out and Harris trying to run midway. So, ladies and gentlemen, let me give you that's the little bit of background here, because how interesting is it then that Turtle Boy and Rachel Rollins work together? Then Rollins gets appointed U.S. Attorney, okay? And right after that happened, she leaves her Suffolk DA seat and gets appointed U.S. Attorney. What's one of the first things that happens while Rachel Rollins is U.S. Attorney? Ladies and gentlemen, Rachel Rollins talks to a man who's running for her old Suffolk DA seat named Ricardo Arroyo, then a Boston City councilor. And she wants Ricardo Arroyo to beat Kevin Hayden for that seat. Kevin Hayden is a Democrat who was appointed to fill Rollins' seat when she went to go be U.S. Attorney, potentially a position U.S. Attorney that Rollins got as a thank you for helping, with Turtle Boy's assistance, Ed Markey ward off a Joe Kennedy Jr. Senate primary challenge in 2020. Rachel Rollins goes off to become U.S. Attorney in Boston, Massachusetts. And then she tries to rig, in essence, or tries to help Ricardo Arroyo win her old seat. When that fails, Kevin Hayden, the man who Ricardo Arroyo was running against, was a Democrat, but he was appointed by Republican Governor Charlie Baker to fill Rollins' seat, because Rollins left when the governorship in Massachusetts was under Republican control before Baker went to become the president of the NCAA. Anyway, so Baker, the Republican, fills Rollins' old district attorney seat in Suffolk County with Kevin Hayden, a moderate Democrat. Rollins was the antithesis of that, very liberal. We'll get into that in a second. But Rollins, right away, independent of the Karen Reed case or anything like that, says that to Ricardo Arroyo in a text message that she's going to make Kevin Hayden pay for beating Ricardo Arroyo in that DA primary. Hi, Murdered by Maestro. Great to see you, dear friend. But tell friends, listen, because this gets even more intense, right? Rachel Rollins then opens a pretextual probe into Kevin Hayden to punish Hayden for beating Arroyo in the Suffolk DA primary, right? Then leaks the investigation to the Herald and the Globe to smear Hayden. Does that sound like a familiar precursor to other things that might have been going on, Towel friends? Well, ladies and gentlemen, by May of 2023, Rachel Rollins gets forced out of office by the Department of Justice Office of the Inspector General because Rachel Rollins did indeed, as it was found by the Inspector General. You can read the DOJ's OIG report from May of 2023. Rollins launched that probe into Hayden, leaked it, and then used it to smear Hayden, and she was found to have violated a bunch of rules and also found to have violated 18 U.S.C. 1001 by trying to mislead the OIG during the investigation. Well, let me layer one more thread into this fascinating explication, ladies and gentlemen. Did you know that Rachel Rollins, a former U.S. attorney in Massachusetts, who I just explained got forced out because she launched and leaked pretextual federal probes to smear political opponents? Did you know Rachel Rollins had a history of tension with the Norfolk DA, completely unrelated to the Reed case, dating back to Rollins' time as Suffolk DA? Why is that, ladies and gentlemen? Two bifurcated reasons. One, Rachel Rollins back in 2018 or earlier, maybe 2015, somewhere in there, started trying to advocate in court motions for not giving lifetime sentences to youthful murder offenders between 18 and 25 on the grounds that they weren't fully developed, mentally ready to be charged as adults. Well, ladies and gentlemen, do you know what happened as a result of that? 4 other DAs in the Commonwealth of Massachusetts, ladies and gentlemen, intervened in that case, including Michael Morrissey, leading to a very public fight and spat between Michael Morrissey and DAs and Rachel Rollins. Well, do you know what else caused a little bit of history of tension? Rachel Rollins was a notoriously soft on crime prosecutor. She, instead of doing the soft broken window approach to prosecuting, she did the opposite. She wouldn't prosecute a list of low-level offenses, ladies and gentlemen. And as a result, other DAs started getting upset about that in the Commonwealth, and that caused more tension between Rollins and Morrissey. Oh, why is that relevant, ladies and gentlemen? Because we come to find out that in November of 2022, Karen Reed, David Yianetti, and Alan Jackson walk into the office of then first U.S. Assistant Attorney Josh Levy, who worked for Rollins, and they started, I believe, the pretextual federal probe with John O'Keefe's death. Now, there was another reason why the DOJ up in Boston, not just Rollins, with her history of pretextual probes and grudges against Morrissey, not just Rollins had a grudge against Morrissey, but a high-ranking line prosecutor in something called the Public Integrity Section of the Department of Justice named Dustin Chow. That man also had a grudge against Michael Morrissey, and you can find this in public court filings from the Karen Reed and John O'Keefe trial from December of 2023. Michael Morrissey used to work with Dustin Chow's wife. Dustin Chow's wife in 2015 during a joint prosecution involving, ironically enough, the U.S. Attorney's Office in Boston and the Norfolk DA. Dustin Chow's wife was passed over for a promotion in the context of that hearing, prosecution, and other things like that. And so Dustin Chow's wife had a grudge in 2015 against Michael Morrissey. Dustin Chow then went around saying he would do anything he could to burn down the reputation of the Norfolk DA as a result of his wife being passed over for that promotion. So you see how these constellation of factors all align. People in politics hold grudges for a long time, long time. Rachel Rollins had a grudge against Morrissey for 2 reasons. Dustin Chow, high-ranking line prosecutor in the Public Integrity Section that looks at this kind of public corruption, had a grudge against Morrissey. November of 2022, Karen Reed, David Yianetti, Alan Jackson walk into Josh Levy's office because David Yianetti, interestingly enough, to make this even more layered, was on the transition team for Rachel Rollins, which means he was very close to her, probably raised a lot of money for her when Rollins became Suffolk County District Attorney. Okay, ladies and gentlemen, so Yianetti's got the connection to Rollins. Rollins probably says, give me a little plausible deniability here, meet with Levy instead. They meet with Levy, who, unbeknownst to everyone, though, Levy would go on to have some kind of personal direct connection to Karen Reed. He would talk to her ex parte about the ongoing federal probe, all sorts of stuff that shouldn't have been happening. But anyway, Josh Levy, when Rachel Rollins gets kicked out in May of 2023, goes on to become actual acting U.S. attorney from the District of Massachusetts. What happens immediately after that? A grand jury for the summer of 2023 opens into John O'Keefe's death and then quickly closes by the end of that summer, or winds down, formally closing a few months later. Now we know in public that it is confirmed as closed. But ladies and gentlemen, how interesting is it then that right as the John O'Keefe probe winds down, in August of 2023, the investigation into the cover-up of Sandra Birchmore's murder, a young woman who lived in Canton that was in a very tormented, abusive relationship with a former Stoughton cop named Matthew Farwell, who was murdered in her apartment, right? Only for that murder investigation, within 48 hours, the local police, before all the investigation was turned over to the state police, because unattended deaths and things like that are always in the original jurisdiction of the state police. And although there's initial processing of the crime scene by first responders from the local police department, in this case Canton, the state police actually do the investigation. Within 48 hours, the Canton police turned over to the Massachusetts State Police evidence that Matthew Farwell, the former Stoughton cop, was at Sandra Birchmore's murder on February 1st, 2021 at 9:23 p.m., the time that she was killed. Then the Canton police provided to the MSP evidence that a maintenance worker at Sandra's apartment building said the man who was at Sandra's apartment at the time of her death was the same man who helped her move into her apartment, Matthew Farwell. Then the Canton police went to Sandra's school where she worked and got evidence that Farwell had been telling people that he knew Sandra was pregnant, Sandra was excited to have the baby, and that Farwell would, quote, take care of the problem himself if Sandra wouldn't induce the death of the child or have an abortion, okay? However you feel about that, we're not getting into the politics of it. I think women have a right to choose, and I will stand on that till my last day. Now, ladies and gentlemen, after that evidence was handed over between February 4th and February 6th of 2021, the Massachusetts State Police Unit, the same unit that is detailed to the Norfolk DA that investigated Karen for the death of John O'Keefe, ladies and gentlemen, that state police unit gets handed the information. Two of the police on that state police unit, one man, John Fanning, who wrote the police report that we're about to talk about, and another man, Yuri Buchanan, who's a trooper on the Norfolk DA unit, used to work in Stoughton, ladies and gentlemen, the same police department where Matthew Farwell worked. And what did the MSP unit detailed to the Norfolk DA conclude about Sandra's death? Somehow, some way, that it was the result of self-harm. And ladies and gentlemen, I have reason to believe that in August of 2023, a federal probe then, as it shifted away from John's death, opened concurrently into Sandra Birchmore's murder and the subsequent cover-up thereof. And ladies and gentlemen, I believe, and I now know because of public statements from law enforcement partners, that the federal investigation into John O'Keefe's death is over. But that probe may well have led the Boston DOJ to uncover the cover-up of Sandra Birchmore's murder. And ladies and gentlemen, if you've been following this twisted tale, then what you'll realize is the DOJ had all the reason in the world to give Karen a wink and a nod and let her do things like collude with her ARCO witnesses, allow the ARCO witnesses to violate Judge Cannoni's sequester order, hide payments and contacts with Reed from Judge Cannoni and state prosecutors. And ladies and gentlemen, before we delve even more into this timeline after the fall of 2023, let's talk about how Aiden Kearney in April of 2023 gets involved with the Karen Reed case, starts reaching out to Karen through an intermediary by the name of Natalie, who went to college with Karen, PR person, liked talking about houseplants with Karen, etc. So Natalie gets hooked up with Aiden Kearney via this woman named Jen Altman. Karen knows Natalie from college. Okay. Karen and Aiden then start speaking through Natalie as an intermediary. The very first thing Aiden Kearney brings up to Karen is how Aiden Kearney in April of 2023 was facing an issue and he needed help. Karen Reed then hooks up Alan Jackson with Aiden Kearney on April 21st, 2023. Ladies and gentlemen, Aiden Kearney, according to what I have seen reported at the time, was facing an investigation unrelated to the Karen Reed trial for wiretapping a woman who lives in Rhode Island. Ladies and gentlemen, I think that woman's last name is Haskin? Haskin or something like that. Okay, there's a lot of women from Rhode Island who are involved with Turtle Boy in some way, shape, or form. So, Veronica, Virginia, something along those lines. Okay, so ladies and gentlemen, now let me continue with this story. Turtle Boy's facing this wiretapping investigation. The Holden police are doing the wiretapping investigation. Turtle Boy thought that if he used a Rhode Island number or something, even if he was in the state of Massachusetts, he couldn't wiretap the woman because Rhode Island's a one-party consent state or something, and the woman was in Rhode Island or something. But no, Turtle Boy was allegedly physically in Massachusetts, so the Holden police were investigating him. Ladies and gentlemen, within 2 weeks of Karen Reed hooking up Aiden Kearney with Alan Jackson, I have it on good authority that the FBI Worcester Field Office, an agent named Samuel Weiner, yes, that is his real name, directly intervened in that wiretapping prosecution of Aiden Kearney and made it go away. Ladies and gentlemen, do you see what I'm saying here? And then all of a sudden, Aiden Kearney gets this cover to run rampant over the summer of 2023, tormenting witnesses, writing all these stories on his blog, a pace of which he has never reflected again. Almost like the FBI was using all the attention on the Karen Reed case as artificial cover in order to generate leads about the state police, which eventually led them on to Sandra Birchmore's murder cover-up, which led to the August 2024 indictment of Matthew Farwell. Whereupon, at a press conference, Josh Levy said the investigation into Farwell started exactly 1 year earlier. See where I'm going, ladies and gentlemen? And how interesting is it then that it is only after Josh Levy and that whole cohort is removed from the DOJ when President Trump takes office in January 2025, that on January 30th, 2025, Hank Brennan gets the first ever responsive TUI request under a case called U.S. XREL TUI v. Reagan from 1985, which is interpolated by 28 U.S. CFR 126.000, which is itself interpolated in Section 25 of the DOJ Operations and Sections Manual, okay? For the first time, the new U.S. Attorney, Leah Foley, and her office turn over to Hank Brennan just the top of an invoice between Karen Reed's experts from ARCA, who were retained in the context of that shady federal probe that Josh Levy, Rachel Rollins, and others helped start, and Reed's team. Within 13 days, ladies and gentlemen, or 14 days, February, or within just maybe even less, February 13th, 2025, Karen Reed's lawyers are forced to turn over, ladies and gentlemen, forced to turn over evidence to Hank Brennan of their contacts and communications with ARCA. And then, ladies and gentlemen, days later, although the TUI rules do not allow U.S. Attorney Leah Foley to directly confirm the end of the John O'Keefe and Karen Reed federal probe, what happens? U.S. Attorney Leah Foley tells Dan Ray on WBZ Nightside that, well, she can't confirm those kind of things. The DOJ does allow law enforcement partners to confirm such things. Within a week, the Brian Walsh prosecutors confirm that the federal probe is over. Hank Brennan, the prosecutor in the Reed case, says out loud he had permission from U.S. attorneys, the Leah Foley or her office, to confirm the probe is over in open court. And then the Canton police release a statement saying they got permission to confirm the O'Keefe probe was over. And so, ladies and gentlemen, and then we therein recognize that it was, in fact, this sordid overlap between the DOJ's investigation into John's death, which closed, and then the discovery of Sandra Birchmore's murder, which led the DOJ to, 1, give Karen a wink and a nod, 2, facilitate this old grudge against Michael Morrissey, 3, use Aiden Kearney's coverage of the case as a honeypot and give Aiden Kearney some protection to generate tips about the MSP. And then 4, it explains why in December of 2023, ladies and gentlemen, when Aiden Kearney faced a bail revocation for going over to Lindsay Gattani's apartment. By the way, it was Lindsay Gattani, who we've talked about on this stream, a superhero in so many ways. Lindsay Gattani was given information by Aiden Kearney that Karen Reed and Josh Levy were talking directly in the fall of 2023. Natalie, the intermediary I mentioned earlier, she had a falling out with Karen because apparently she called Karen late at night about something to talk about her personal problems, and so Karen cut her off, Natalie off. Therefore, the only information that was available about Karen Reed and Aiden Kearney and Josh Levy's relationship between June of 2023, when Karen cut Natalie off, and December of 2023 was Lindsay Gattani. Well, you know what? When Aiden Kearney got criminally charged in October of 2023, ladies and gentlemen, for witness intimidation and a bunch of other things. That was in Stoughton District Court. Those charges got bound over by a grand jury, an indictment on December 20th, 2023. You know what happened next, ladies and gentlemen? Another grand jury was open, and Lindsay Gattani on December 21st, 2023 got a subpoena for that grand jury. Why? Aiden Kearney must have been thinking, well, the previous charges just got indicted. What could the state be doing a grand jury about now? What does Lindsay know? Oh, did Lindsay have information about Karen Reed and Aiden Kearney colluding potentially to torment witnesses in Karen's trial? Did Lindsay Gattani have information about Aiden Kearney saying Karen controlled what he could publish on his blog? Yes, ladies and gentlemen. Did Lindsay Gattani's information eventually lead to a search warrant affidavit and a search warrant being approved for Karen Reed's cell phones? And did it get worse, ladies and gentlemen? Did Aiden Kearney go over to Lindsay Gattani's apartment on December 23rd, 2023, and try to find information on Lindsay's phone, and according to that search warrant from Karen Reed's affidavit, tell Lindsay not to cooperate with the new grand jury? And when Lindsay refused, did a situation happen where Aiden was accused of pushing Lindsay onto a couch, wiretapping Lindsay without her consent by recording her with a phone in his pocket or something along those lines, and then committing witness intimidation? Yes, and on December 23rd, 2023, after Aiden Kearney spent the weekend declaring himself a fugitive on social media, did Aiden turn himself in for a bail revocation hearing? At which point, ladies and gentlemen, did Tim Bradel, Aiden Kearney's lawyer, say that he had been on the phone with the FBI and the DOJ that morning? Yes, and do I have reason to believe that Aiden Kearney was reaching out desperately to high-ranking Free Karen Reed supporters, begging for FBI agent Leah Ferreira's number over that weekend, only to be told no? And does it make perfect sense then that Tim Bradel invoking the FBI and DOJ on Monday was a last-ditch effort to keep Kearney out of jail because the FBI and DOJ didn't need Kearney after they generated their leads and stumbled onto the Birchmore cover-up and the O'Keefe probe was closed? Yes, ladies and gentlemen, it all makes sense. It's a modern black mass redo. My name is GrantSmithEllis. I did that from memory. I could write it right now. I think I have put it all together. And yes, ladies and gentlemen, I even have reason to believe that in the fall of 2023, the Massachusetts State Police were trying, ladies and gentlemen, to figure out what the federal probe was about. And I have reason to believe the Massachusetts State Police were told that they and Michael Morrissey were the targets of the probe, and they must have realized in the fall of 2023 that it was not about John O'Keefe's death. It was about the murder of Sandra Birchmore and the subsequent cover-up by the same unit that investigated Karen for John's death. Ladies and gentlemen, I think that's exactly what happened. And I think when people got too close to that story during the pendency of the investigation, winter of 2023, spring of 2024, they would get their wings burned off to prevent them from explaining to the public what happened. And that's why, ladies and gentlemen, I believe State Police Officer Brian Tully, who himself was trying to figure out what a federal probe was about in the context of his official position as a state police officer, which never should have happened, then took Lindsay Gattani's phone extraction, a 15-year extraction of Lindsay Gattani's phone, manipulated it allegedly while in state police custody to remove only messages from Tully to Lindsay and from Kate Mafia Masshole Peter to Lindsay, with Kate being an alleged PI who worked for a guy named Marty Kraft and helped look into the Aiden Kearney prosecution, or help assist with the Aiden Kearney prosecution reportedly. Tully then took a 15-year extraction of that phone, unprecedented in the history of every single case that I've talked to high-ranking people about. Unprecedented. Takes a 15-year unredacted production of that phone, except for those manipulated messages. That included intimate moments of Lindsay Gattani's family life, the births of her children, and releases it directly to Aiden Kearney's lawyer on April 24, 2024, just days before Karen's first trial starts. And did Brian Tully do that for a number of reasons? I believe so. I believe Brian Tully did that, one, to undermine Lindsay and prevent her from being able to tell people that the actual federal probe was probably about Sandra Birchmore. Two, I believe Tully did that so that Aiden Kearney would send those documents around and then provide a useful distraction from some of the other Karen Reed and John O'Keefe trial witnesses at Lindsay and her children's expense. And ladies and gentlemen, I think furthermore, I think there was collusion for months to prevent a protective order from issuing related to that cell phone extraction so that Lindsay would be used as a tool and have her credibility artificially decimated to avoid her being able to relay the tale of this DOJ investigation and how it uncovered Sandra Birchmore's murder. Yes, ladies and gentlemen. Yes, ladies and gentlemen. It all ties together. It all fits. It all makes sense. Everything is explained. The mosaic has been painted. The historical tiles come together, and the timeline of the events is sealed in towel stone. Murder by Maestro, you're right, it could not have been a mistake. And my ability to memorize all this, which should be impossible, and relay it all to you in a coherent manner, which should also be impossible, can only mean that someone out there, somewhere, was meant to hear this information. And Towel is but a mere conduit, conveying it so that you, whoever you are, hopefully in the government oversight apparatus or in the FBI, can take this and for some godforsaken reason, stop delaying the justice that is deserved for Sandra Birchmore and Lindsay Gattani. For the love of God, there's no reason I should be able to convey all this point by point by point with specific details, dates, timelines, hours of the night, down to the minute. It's for a reason. Someone out there's meant to hear it. And by God, I beg of you to act on it. Please bring justice to these voices who became ping pong balls in a godforsaken proxy war between the state police, the Norfolk DA on one side, and Karen Reed, Aiden Kearney, and the DOJ on the other. Well, who asked for that? Eva, I hope you got what you wanted and more. I did everything I could to lay out for you and answer your question. It may have been more than you were expecting. There you go, ladies and gentlemen. You heard it. You saw my diagrams. Oh, yes, it's a huge backstory. I have somehow put it all together. I have even written a post today that you won't be able to see on your screen until I get rid of this image. But the post I wrote, you can find it on my Twitter. It details all of this. It has the primary source links. It goes on and on. Ladies and gentlemen, Towel likes to write. Yes, Towel writes tens of thousands of words for some reason on Twitter, and it perplexes the masses. Yes, ladies and gentlemen, I highly recommend you read the post I just reposted right now. It has every primary source, every document. It tags the GOP Oversight Committee. It tags President Trump because Josh Levy's suing President Trump. It tags the OIG for the Justice Department. It tags the Justice Department themselves. Towel is on a crusade to get justice, and two things can be true at once. Karen Reed and Aiden Kearney can be guilty of the respective crimes for which they are charged, in my opinion. And Brian Tully could have abused his official position on behalf of the state police unit detailed to the Norfolk DA to find out what the federal probe was about after the probe into John O'Keefe's death closed and transitioned to Sandra Birchmore's murder and subsequent cover-up in August of 2023. And ladies and gentlemen, Brian Tully handed that 15-year unredacted production of Lindsay Gattani's phone to Aiden Kearney's lawyer on April 24th, 2024, just days before the Karen Reed trial, the first one was going to begin. And the only things removed from the extraction while in state police custody were messages from Tully to Lindsay and messages from Kate Peter to Lindsay. Ladies and gentlemen, there's an explosive story in two regards regarding Sandra Birchmore's murder, the DOJ probe, and what happened to Lindsay Gattani. It's all there, black and white, if only you can read between the lines. Oh, ladies and gentlemen, I think we have slowly put it all together, and Lindsay Gattani is key, and the probe of Sandra Birchmore's murder is key, and it all lines up. And yes, there is no way Brian Tully could have accidentally leaked that extraction. I believe he fed Aiden Kearney and people around him information so that they would distract the public from other Karen Reed trial witnesses who are not desolate, lonely single mothers with very few political allies except for some Towel who happens to know people in various organs of the government. Oh, dear God, ladies and gentlemen. That was from what clip, Eva? We watched that yesterday. the clip on Twitter. It was only 30 minutes. We basically finished. But you were here. Eva, that was my soliloquy to you yesterday. I think you even sent a super towel chat of $4.99 at the end of it. It was a wonderful opportunity for us all to be towels. But, ladies and gentlemen, we now will check out the arrival of Hank Brennan at court this morning. Give little Towel a second. Towel has a lot of things on his mind. Is it this one I want to get rid of? I'm a towel. All right, ladies and gentlemen, let's begin the clip. I must increase the quality so that we see Hank Brennan in all of his 720p glory. Yes, ladies and gentlemen, that looks like Hank Brennan. It might not actually be Hank Brennan. I can't see that far. My towel eyes are not good. Is that Karen Reed's attorneys avoiding the media? Ladies and gentlemen, use your towel eyes. I can't quite see that far. Is that Alan, the Marshmallow Man Jackson, or is it Hank Brennan? I can't. Then maybe it's not either one of them. I can't see that far. Yes, Eva, I posted it on X this morning, actually, in response to Henry Blue and this reporter from LA Mag named Michelle McPhee, who interestingly uncovered that the Boston Marathon bombing may have been a burn notice issued to 2 government agents who had been run to Chechnya because one of the older brothers in the Boston Marathon bombing committed a triple murder in Waltham in 2011, and then he potentially became a federal informant who was sent to Chechnya in order to spy on terrorist groups, and then Russia sent him back to the U.S., but the U.S. ignored it, and then strangely those 2 brothers ended up involved in the Boston Marathon bombing. Michelle McPhee wrote a long series of articles on Newsweek for that, but now she's trying to talk about Sandra Birchmore and Karen Reed, and I'm like, if you're going to do that, Miss McPhee, who I respect as a journalist, then understand the context and how the old DOJ weaponized the Reed probe because it stumbled onto Sandra Birchmore's cover-up, and there was massive corruption between Karen Reed, her lawyers, and Josh Levy, Rachel Rollins, Dustin Chow, and others potentially. Maybe Adam Deutsch as well. Ladies and gentlemen, that is why Little Towel was so incredulous. And also, I can't see to determine if that was just some random man or if that was someone who's related to the case. Why? Because my eyes are not that good. That may have been the prosecution. Ladies and gentlemen, that was Adam Lally. So was that Hank Brennan ahead of him? I can't see that far, ladies and gentlemen. Let me make this larger for a second. Little Towel. No, I don't think that's Hank Brennan. He's too lanky. All right, ladies and gentlemen, let's look at the arrival of Adam Lally, doing a wonderful job on direct. I'm a towel. Let's see if we have any audio. Just 3 minutes now, Little Towels until the start of the court. My name's GrantSmithEllis. We've been going for 90 minutes. You know what that means. If you haven't liked and subscribed, please consider doing so. Pardon me, Little Towel is having some trouble. He is burping a lot today because of his medical condition. But do please consider supporting Towel Stream with a like or by subscribing. You can also support Towel Stream in other ways. You can continue to be nice to your fellow towels. You can do acts of service. There are also ways to donate to Towel Stream. You can send super towel chats, although that doesn't give you any more prominence than any other commentator because we are all equal towels here, no matter of our towel form. Yes, towelettes, washcloths, beach towels, paper towels in particular, hemp soap dispensers. I saw the Sheffield flannel here as well earlier. We are all honorary blades thanks to the Sheffield flannel. God bless you. Ladies and gentlemen, yes, there is so much going on. We are awaiting the arrival of Karen Reed. The court cam is about to come on. Oh, ladies and gentlemen, get ready. We're going to be into session on time. I think today I am a towel. Okay, hold on, ladies and gentlemen. Hold on. I am a towel. Oh, I forgot to jump forward because I did a little buffer. Because I'm a towel. We don't have to wait for Karen Reed. We can jump forward. Oh, that's Bob Alessi. Is that Bob Alessi? Bob Alessi walking up alone. He is a Bob Alessi. He looks very clean-shaven, and he is still a Bob Alessi. He talks in a very monotonous tone for hours, then starts yelling randomly in a way that does not make sense. Bob Alessi struggling to carry his briefcase up the stairs. Little Towel on Towel Attenborough duty. Yes, ladies and gentlemen, this is a combination of Howard Cosell and David Attenborough. All right, here we go. Alan Jackson and Elizabeth Little get the glamour shot. You know the rules. Oh, actually, hold on. I have a plan. We'll give Karen the... Hold on, I have a plan. Let's see if we can get Karen framed between them. No? Okay, I have a better plan. She doesn't... No, that's a little ridiculous. Okay, that's good. Hold on, we must start the clip, ladies and gentlemen. Get ready. Good morning, ladies and gentlemen. My name is GrantSmithEllis. It's coming up on 9 a.m. We're about to go into session on day 11 of the John O'Keefe and Karen Reed trial. Yesterday, Tuesday, was devastating for Karen. Karen's vulgar voicemails to John in the minutes after she is alleged to have drunkenly struck him with her Lexus and left John to die in a blizzard from hypothermia and a traumatic brain injury. Terrible, horrifying voicemails weaponizing John's niece and nephew as John lay dying on a lawn, alone in the cold. Karen's arrival at court this morning, ladies and gentlemen. Let's take a look in real time. Join youtube.com/@GrantSmithEllis to chat with the Towel Friends and keep up to date on all the day's developments. Only the birds read them. Paralegal, Karen Reed. A lonely, quieter figure, carrying her own bag up the stairs, her legal team in tow. Oh, ladies and gentlemen, it is not good for Karen Reed. And just to really hammer home the point, let's look at what it looked like when Karen Reed left court yesterday. We have the clip ready to roll on Towel Stream because we are towels.
Anything more to say about the clip that was played today?
No, thank you.
What about the clip that is inaudible? Can you say what's in that clip?
I'm sorry, Matt. Say
How about the, do you remember making those phone calls, Sam?
Yes.
What was your...
Silence. Ladies and gentlemen, a silenced Karen Reed. And I will bring it up for you one more time because I realized that we did not actually get to see the clip. And now you will actually be able to hopefully see the clip. Yes, ladies and gentlemen, a silenced Karen Reed. You heard the clips in the background. And now you can see the clip on your screen. Join us today for coverage.
Anything more to say about the clip that was played today?
No, thank you.
What about the clip that is inaudible? Can you say what's in that clip?
I'm sorry, Matt. Say
How about the, do you remember making those phone calls, Sam?
Yes.
Ladies and gentlemen, silence. Silence from Karen Reed. We will see you for court soon. My name's GrantSmithEllis. Tune in, youtube.com/@GrantSmithEllis. Join the Towel Friends. They are wonderful. All right, ladies and gentlemen, we must get ready. The Karen Cam is about to come into session. We know that the court is almost in session as well. And ladies and gentlemen, I have set it up so hopefully we don't have to watch the fan. Oh no, it's the fan. Oh, ladies and gentlemen, it is the fan. I'm so sorry, but I will get us over to the multicam view as soon as possible. Wait a minute, before we do that, all day we don't actually have to watch the fan because we have the saviors of the Towel Friends who have stopped the fan from spinning. Look how happy that little marshmallow is. I know watching Karen was hard, but now you can feel better. He stopped the fan from spinning. Chewbacca's thrilled. The Stay Puft Marshmallow Man is thrilled. I'm thrilled. Let's go over to the Karen Cam view. Ladies and gentlemen, as a towel, I cannot put into words how thrilled I am that we didn't have to watch the fan spin. Oh no, now we have to watch this fan spin, but at least John's image is on the screen. Yes, ladies and gentlemen, justice for John O'Keefe is in sight, and us, the Towel Friends, will be here to watch it happen. My name's GrantSmithEllis. Let us get the Karen Cam up and running. Let us prepare. Let us get ready. I am here with you. The moment is almost upon us. Court should be coming into session shortly. You'll hear a little bit of a dual audio overlap. We'll have a 20-second heads up. Then court will begin and the Karen Cam will turn on. And yes, yesterday, ladies and gentlemen, this was the only network that had the Karen Cam, the only record of the Karen Cam, youtube.com/@GrantSmithEllis. And ladies and gentlemen, as mentioned, don't forget to support your favorite public information service based only around towels. You can share this stream. Let your friends know. Let your fellow towels know if they want to see the Karen Cam, the most unique perspective in the history of criminal trials. If they don't want to have to listen to silence on the main feeds while the fan spins. If they want interesting commentary full of erudite and fascinating historical references that somehow combine into a beautiful mosaic stitched together in the form of a towel that explicates the web of connections between Josh Levy, Karen Reed, Dustin Chow, Rachel Rollins, Turtle Boy, Karen's lawyers, the Norfolk DA, a proxy war, and more. Yes, ladies and gentlemen, if you want Towel Stream to thrive, then go out there and spreadeth that word in a loving way. Feel like if I keep being Bob Cosell Towel, Howard Cosell Towel, my ability to provide fascinating commentary will only go on for so long. We need court to come into session. Oh no, ladies and gentlemen, I have dropped my water bottle again. And as towel friends, you have been witness to so many of my water bottles falling. Thankfully, they have caps. Folks are like, well, Grant can make almost anything interesting. Oh, Bill, it's so great to see you, Super Towel. Oh, ladies and gentlemen, we're about to come into session. Bear with us.
See me as the jury's coming over. Why don't you come up to Sidebar?
Sidebar! Ladies and gentlemen, we have a sidebar. I bring to your attention the reality that we have a sidebar. Ladies and gentlemen, we await Karen Reed. We watched the Karen Reed. Judge Cannoni has just ordered a sidebar. We don't know what this is about as the jury prepares to come over for the day. Yes, ladies and gentlemen, we await Karen Reed. The trial, day 11. Who will be the first witness? What is this issue at Sidebar about? We all watch together. Ladies and gentlemen, my name is GrantSmithEllis, and I am with you. The Karen Reed movement down to just a few people. Our normal ground camera was not even able to determine if there were people there because Tom's CPU did not go today. Ladies and gentlemen, we look in at the Reed family. John O'Keefe, a permanent reminder on the screen of their daughter's alleged crimes. And we will move that down so that we can see Miss Janet Reed. Yes, ladies and gentlemen, my word, it is quite a day to be a towel. We watch with eager anticipation to see just who will be the first witness called. And yes, we have even added a picture of John O'Keefe to Towel Stream to ensure that memory is forever reminded. Ladies and gentlemen, after we started saying Sidebar yesterday, someone even put up a YouTube stream of their own, and the title was Sidebar with a bunch of A's and H's. We have started a meme, ladies and gentlemen. We are true professionals. We now stream past the O'Keefe family. We see Peggy O'Keefe. The zoom in. I will move John to the other side. We now see John and Peggy O'Keefe next to each other. Peggy awaiting the end of the sidebar, the camera affixed on her face. Peggy is a resolute, powerful force. She is respected throughout the towel world. Yes, ladies and gentlemen, Crime Cricket has said everything that every towel would want to say. Towels for justice. Towels on the march. Ready your towels to peaceful arms as we begin to invade Norman Towel. And you might say, sir, what is Norman Towel? And I will tell you that is the new homeland for the towel people in the north of France. And while you may be confused as to the existence of the towel people in France, all I can tell you, ladies and gentlemen, is that it has been a long thought out discussion among the towel faithful, and we shall, in the interest of justice and in the name of fairness, pursue justice for not just John O'Keefe, but for any vulnerable decent human being, and we shall do so in a resolute towel form from our base in northern France called Norman Towel. Deaf Otter, we will always bless you, sir, or madam, or towel, for coming up with Norman Towel. Yes, you changed the course of history, Deaf Otter, and you will be the commander of the Towel Expeditionary Force, the TEF, as we send 7 million men, 14 million women, and the entire population of Russia, 148 million people, into northern France. Now, ladies and gentlemen, I know that you may think that this is an outrageous plan, but I promise you, ladies and gentlemen, there is a point. We will utilize our base in northern France to preach the way of the towel. And we will say to our towel friends, there is so much more to life. And we will show the world a better way. And yes, ladies and gentlemen, we now watch both families. We wait. We watch, we wait. The witnesses getting ready. The lawyers still at a prolonged sidebar. Ladies and gentlemen, it is quite a morning to be a towel. Who will be the first witness? Oh, we have support from Crime Cricket, the dear honorable towel. God bless you, sir. You are a true towel, a true super towel. And you have warmed little Towel's heart. Yes, the mission to educate, inform, and entertain the public through Towel Stream, it perseveres, ladies and gentlemen. Oh, God bless you. We won't use the name because people don't always associate their donations with how they send them. Someone else sent a towel donation as a thank you. God bless you, friends. I will get 7-Eleven pizza for lunch in just 2 hours and 49 minutes. Yes, I eat my lunch at 12 o'clock as long as there's not a delay in the court proceedings. As we wait court to resume, ladies and gentlemen, as we await court to resume, I will stay with you, and instead of us just listening to the muted stream, I will attempt to keep you entertained. And you may say, Towel, we are thus entertained, and I will say, God bless you all. Ladies and gentlemen, as we await, as I mentioned, the end of the sidebar, my name is GrantSmithEllis, and I will be with you until this sidebar ends. Now, you might be wondering, what is a sidebar? Well, a sidebar is when the lawyers and Karen stand with Judge Cannoni and we aren't allowed to hear what they're saying, and audio masking goes on in the court so no one can hear what they're saying. But we call it a sidebar because if we're going to talk about things in a New England accent, we will say sidebar, and I will not feel bad. Yes, Allie 90211, Towel has found that you can pay $1.50 per slice of 7-Eleven pizza if you buy 2 slices at once. And you might say, Towel, that is outrageous. There is no reason for you to do that. And I would say, yes, there is, ladies and gentlemen. I want to be as economically efficient as possible, and if I don't have a coupon for Burger King or McDonald's on my app, then I shall pay $3 for 2 slices of 7-Eleven pizza. And if you're wondering, Grant, this seems like an uncanny intonation for coverage of a trial. I know, the Towel Friends got me stuck in Howard Cosell towel mode. I am trying to get out of it. I don't think it's ever going to happen. Sidebars are private because they are privileged discussions between the judge and the attorneys, oftentimes related to evidentiary matters that could potentially be prejudicial, and things can be so prejudicial to one side or the other that before they even get a motion hearing, they get talked about at sidebar. Sidebars are a normal procedural legal technique, and most of a trial is a choreographed play. And so the lawyers already know what's coming. The judge knows what's coming. They negotiate ahead of time. The judge, as the referee, makes the final call. And I, as a towel, a lay towel, explicate for you what is happening. I repeat, ladies and gentlemen, extended sidebar. Extended sidebar. It can be good or bad. Bailey, it could be about the invasion of northern France. It could be about Turtle Boy. Right, it could be... Oh, we're done, ladies and gentlemen. The sidebar is ending. Stay with Little Towel.
Thank you. You are unmuted.
Stay with Little Towel. We should have the Karen Cam in less than 60 seconds, little towels. Your patience shall thus be rewardeth. Good morning, Lucy. Alex, it's great to see you. Lackadaisical, Paul Doherty, Alana, Deb H. We're waiting for the jurors to arrive. Ladies and gentlemen, you are all beautiful towels, and we will avenge the integrity of the towel universe, and paper towels shall not be besmirched again. Paper towels are not rags. Mark my words. All right, ladies and gentlemen, we wait. We watch. Are the jurors coming over? There's no sound yet. Stay with little towel. Of course, everyone loves towels. We are towels, ladies and gentlemen. All right. We await the announcement. As soon as the jurors arrive, ladies and gentlemen, you will see the party stand up. And what will Little Towel say? Little Towel will say we are about to come into session. We watch closely. Very, very closely. Towel's monitoring. Karen pointed. The Karen point. Ladies and gentlemen, let's rewatch the Karen point. Did you see the Karen point? There's nothing like it in the world, ladies and gentlemen. I repeat, we have seen the very rare Karen point. Oh my goodness, ladies and gentlemen, look at the moment. You on Towel Stream were able to see the Karen point, the very rare Karen point. Oh my word, ladies and gentlemen. You saw it live. Now we jump forward. We monitor the Karen in her natural habitat. She holds up a document. She hides it from the camera. She very expressively communicates with attorney Elizabeth Little. Oh, ladies and gentlemen, these moments, you would think you're at some kind of giant horse race. I don't really know, though, if that's an appropriate analogy, because I don't understand horse racing. Yes, someone tried to explain it to me. I still have no idea what's going on. All I understand is that the horses try to accomplish a goal, and it involves running in circles. Now, I've also said I don't think we should make horses run in circles. Yes, ladies and gentlemen, I think we are better suited having our horses continue to simply operate as free animals, able to go about their business as they so see fit. Now, ladies and gentlemen, we see the prosecution. We see John O'Keefe. I will try to keep him with his family. And we await the jurors, ladies and gentlemen. We await the jurors to walk over. Hank Brennan methodically preparing. The clerks awaiting the arrival of the jurors. The parties will stand up at the moment upon which the jurors enter the courtroom. Oh, ladies and gentlemen, my family also immigrated through Ellis Island. They were Lithuanian Jews who were escaping pogroms in Russia in the 1800s, and they came over, and the immigration authorities couldn't pronounce their name, gave them papers, but named them Ellis. It is an interesting story, and yes, my family genealogist, or who's just a family member that's interested in genealogy, even found the small group of nomadic Lithuanian Jews who likely traveled over and entered Ellis Island, thus birthing the Towel lineage. Ladies and gentlemen, stay with Little Towel as we await this protracted process. It is not your fault, I repeat, ladies and gentlemen, it is not your fault that the jurors are being walked over. It is not the pool camera's fault. It is simply the result of a long walk. Oh, you're Lithuanian, Letha Cox. Yes, that is a big part of my heritage. I've never been to Lithuania. I'd like to go one day. I'd also like to go to Baku, Azerbaijan. Those two things aren't necessarily connected, other than the fact that I like the city of Baku. And you might say, Grant, that is a little bit weird. And no, it's not. The area in Azerbaijan is very interesting. And I think I'd like to overthrow, maybe not overthrow, but peacefully overthrow the strong man rule in Turkmenistan so that the world can be a better place. And if I get a foothold in the politics of Azerbaijan, which is going to be difficult because there's a lot of nomadic tribes, and I don't know what they're going to think of a guy who thinks he's a towel, but I'm going to try to unite the tribes of Azerbaijan in a movement to facilitate a base to then overthrow the strongman ruler of Turkmenistan. Now, you may say, Grant,
to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
All right, thank you.
Okay. exhibits reviewed from yesterday. No objections. Now you might say, Grant, I don't think Oh, jurors are entering. Ladies and gentlemen, get ready. I'm going to stick with you until the Karen cam turns on, as we'll know jurors are in and we're ready to go. Who will be the first witness? The moments are intense. Towel watches with bated breath. We somehow started talking about Turkmenistan and Baku and Lithuania. Isn't that a wonderful moment in the history of Towel Stream? I know you've all wanted to hear about how much I like Baku and why. Does anyone want to go to Baku? I'd love to take you. Bill, let's go. Yes, Bill, I would love to go to D&E Pizza for slices, but it would cost me $20 in gas, and it would. I don't mind paying for the pizza, but that would the cost per slice would be like $17.
Hear ye. All persons having anything to do before the Honorable Beverly
Here we go.
Cannoni, Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right, good morning again, counsel. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. No or shall take. All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keefe.
Sir, follow me. Now step up, raise your right hand. Face the clerk, thank you.
You raise your right hand. You solemnly swear the evidence given to the court and jury in the case now and hearing should be truth, the whole truth, and nothing but the truth, so help me God.
Yes.
Good morning.
Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes.
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Did you have a role in investigating this case?
Yes.
Were you assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Okay. Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence.
Okay.
Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir. Sorry.
With the court's permission, can he show the item?
Yes.
Thank you. Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
All right, any objections, Yianetti?
There is no objection.
Exhibit 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who's collecting it.
The time that you write in the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that can be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury. Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just two pieces, or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the two bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay. Okay.
Ladies and gentlemen, we have a sidebar. My name is GrantSmithEllis. We should see Karen any moment there walking to the sidebar. John O'Keefe with his family, ladies and gentlemen. I did not mean to make John O'Keefe that large, but if we're going to do the sidebar, then, ladies and gentlemen, John O'Keefe will be on the screen. This is likely David Yianetti objecting to this piece that may have broken off while in the evidence bag. We will watch in real time I do not expect that this objection will be sustained because the evidence was properly marked and stored. Yes, ladies and gentlemen, here we go. Deb H., it's so good to see you. I'm so glad you found the channel. We should be back in just a matter of seconds here, ladies and gentlemen. John Chu, Karen's Taillight. Oh, it's getting bad for the defense. Towel is with you. Just 15 seconds or so until we're back in session now. And John O'Keefe is covering the lower Karen cam. It's okay. We are okay with that. Just waiting. Here we go.
So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes. Sir, in the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip. I'd like you to safely secure it, bring it with you, and bag it when you leave.
Yes, sir.
And then I'd like to introduce that exhibit.
78. So we're going to mark the little chip.
You
Ms.
would like to
Yianetti
mark it?
asked to
Okay.
mark that. Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
Exhibit 78.
Thank you.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have Exhibit 73, please? Sir, if you could look at Exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes.
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a photo. Do you recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
Okay. There's no objection, Mr. Yianetti?
There's no objection, no.
Exhibit 79.
With the court's permission, could we show Exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
Yes.
Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, Trooper. I'd move these items into evidence.
No objection, Your Honor.
All right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Mr. Yianetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Terry Roberts?
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself?
Yes.
In this case, it would have been an iPhone 11?
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number?
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form?
Yes.
And the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well?
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022?
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach you, Honor?
Yes.
Now I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct, 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the...
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay. It's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation, no.
You have not yet?
No.
The lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your unit, while this case was going on. Whose case is it, or who has that case? Your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
Okay.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach, Your Honor?
Yes.
No, not at all.
Yeah. I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done. And Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take
Sure,
a look, sir.
go ahead. Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but...
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
Yes.
Okay. And the two of you would have participated in that interview together, correct?
Yes.
But you did not write the report, correct?
No, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. I may approach Judge.
Yes.
Thank you. You're welcome. Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. You, or asking you this, you retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from C.F. McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach.
Okay.
Thank you. I'm sorry. And again, if you read that silently to yourself and look up at me when you're done. Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. Right. I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
This is C.F. McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any analysis.
And with regard to the Waterfall Bar and Grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Okay. Now, another member of your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
Sidebar. Ladies and gentlemen, sidebar about Trooper DeChico's nickname. It is a sidebar. Ladies and gentlemen, I am a towel, and we are at sidebar. Oh no, it's the fan. Anything but the fan, ladies and gentlemen. We are going to have to watch the Reed family on the Karen Cam. Yes, ladies and gentlemen, if you haven't heard the news, this is one of the only networks showing the Karen Cam. Share it with your friends. We're going to break the Towel YouTube stream record. My name's GrantSmithEllis. Thanks for supporting Towel Stream. God bless you all. We should be back in the session in within 10 seconds, maybe 15 seconds, depending on how long of a Towel stream delay there is. I'd say 10 seconds now. 5 seconds. 4, 3, 2, 1. All towels go.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Mrs. Staines, you can ask that differently.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment. May I approach, Your Honor?
You want this one back?
Oh, please, thank you. So I've placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you. Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Objection. Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of questioning.
Sustained.
May we approach?
Okay. Jurors, feel free to stand up.
You're at Sidebar. Ladies and gentlemen, Sidebar. Sidebar, ladies and gentlemen, we continue to monitor closely as we are at Sidebar. My name is GrantSmithEllis. I am a towel. Let's see. I am a towel mostly because I know that being a towel is incredibly important. And as we listen closely, ladies and gentlemen, to this very go nowhere cross from David Yianetti, Modelo Macy has made one of the points of the day, and that is that they are a towel. God bless you, Modelo Macy. Anyone who is a towel has truly arisen to their vocation on this earth. And yes, you know it's bad, ladies and gentlemen, for the defense when Towel's sidebar commentary is more interesting than David Yianetti's cross. It is a dumb cross that is going nowhere. It is very bad. It is not doing well. My name is GrantSmithEllis, and we are waiting for something to actually happen that is not David Yianetti being a spaghetti. Yes, ladies and gentlemen, David Yianetti may as well be Chewbacca and the Stay Puft Marshmallow Man at this point. He is not a towel. Yeah, no, that's just been, the jury has been very bored with Jackson and Yianetti. John DePetro has been reporting eruditely from the courtroom, or in an erudite manner, and the jurors don't even take notes when Jackson and Yianetti cross. They only take notes when Brendan is talking. Ladies and gentlemen, we are about to come back into session. The sidebar is about to end. My name's GrantSmithEllis. 20-second countdown. Karen arrives back at her seat with Alan Jackson. They lean in close. They talk. Karen, a frail figure. Towel is a towel. Do you know why they call a towel a towel? Because it's a towel. Here it goes, ladies and gentlemen. Any second now. I am a towel. 3, 2, 1. Let's go.
Were you watching Dr. Scorti-Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
Objection.
It's the same thing, just ask a different.
What direction were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job, conducting the autopsy.
And in order to do that,
body.
I'm sorry?
She was looking at the body, I assume.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scorti-Bello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No, none. Thank you.
All right, you're all set, Trooper.
Thank you.
So, jurors, this break I'm going to take now. All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so
okay.
We'll take a recess
Ladies,
after the next half hour, maybe a little bit.
Ladies and gentlemen, we have some things going on. Don't go anywhere. Don't go anywhere. The lawyers are going to stick around. Ladies and gentlemen, the jurors are being dismissed for 30 minutes for coffee, but there is something going on with the lawyers. Stay with Little Towel. Ladies and gentlemen, this is Towel Stream. You are watching live. The jurors are filing out. We're waiting for Karen Cam to turn back on. Oh, here we go, ladies and gentlemen. 20 seconds now. The session is coming back. We have more to go. What will this hearing be about? Oh, my word, ladies and gentlemen. We have one of those moments. What do the lawyers have to talk with Judge Cannoni about? And here we go.
Seated.
So I want to talk a little bit more about what we talked about at Sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response. Then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate...
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shall...
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course a court is a judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. And the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what...
In one area, right? One specific area?
Well, you can call it...
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking me to allow.
If I could give you the answer, Your Honor, I will explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. it's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp would...
No, that was raised, but this... What was problematic in Maryland? The same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor,
okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them. In this case, it's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with a timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled, to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? But one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term Galbraithized anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, in any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location she has in her PowerPoint she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert, and this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate decision.
It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says, ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence The decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become eminently clear that it's a proper basis for cross-examination.
All right, and Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this. If they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls, but if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was an offer of proof earlier on similar evidence. But not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Okay. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal.
Well,
that's...
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue. And they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here?
Your Honor, may I ask one thing? May I, Mr. Good?
I just want to know, is she here?
She is, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Ladies and gentlemen, oh my word, GrantSmithEllis here. Dr. Jessica Hyde is most likely the next witness in the Karen Reed and John O'Keefe trial, but Judge Kearney wants a half hour to review before we begin. Oh, the defense is going absolutely nuts at the very last minute. Oh, they do not want Jessica Hyde to confirm that Karen Reed asked Jen McCabe to Google how long to die in cold at 6:23 and 6:24 a.m. on 1/29/2022. My name's GrantSmithEllis. We'll see what happens after the break. We may need to go into a 30-minute session, folks, where Judge Kearney reviews this last-minute nonsensical argument from Bob Alessi. Bob Alessi is saying, just so folks understand, and this is why Hank Brennan's analogy was so wonderfully apt, Bob Alessi, ladies and gentlemen, was basically saying, imagine you have a situation where a medical expert, okay, a medical expert in a case wants to offer testimony, okay, about forensics in a state court in Maryland, okay? And accident reconstruction forensics. And during a Daubert-Lonergan hearing, which is to qualify the expert, the court says, yes, you can testify, yes, your methodology is appropriate, but no, you cannot offer evidence about accident reconstruction. You are a medical expert. Bob Alessi is saying that because Dr. Jessica Hyde, in a Daubert-Lonergan hearing in Maryland, was limited to not testify about something about Apple source code that no one in the whole country has access to, that should somehow impeach Hyde's methodology in this case. It's irrelevant, and Hank Brennan was right to point this out for two reasons. It's the Herrera case out of Maryland. One, it's irrelevant fundamentally, ladies and gentlemen, because the methodology in the Herrera case had nothing to do with the methodology in the Reed case. Two, it's irrelevant because Dr. Jessica Hyde was allowed to testify. She was never found non-credible. She was found to be an expert witness. The only thing was in the Daubert-Lonergan hearing, the court said, on this issue, you can't testify. All right, ladies and gentlemen, we're about to go into the recess. Let's hear Judge Kearney announce it. All right, 30-minute recess, ladies and gentlemen. My name's GrantSmithEllis. Stick with us. I will be with you. We'll be back around 11. All right, I ended the clip. That was a long motion hearing, ladies and gentlemen. That was a long motion hearing.
Hey there, Karen Reed trial watchers. You know what a lot of the trials we cover remind me of?
No, I don't. Ladies and gentlemen, that was a long motion hearing. My name is GrantSmithEllis. We covered every minute of it, and I explicated to you why Bob Alessi's argument was so bad. And I am a towel. Oh, we don't have to watch the fan. We instead can watch the Stay Puffed Marshmallow Man and Chewbacca. Oh, ladies and gentlemen, it is wonderful. And by the way, Stumblin' Mumblin' Richard Green might not even be called. Oh, ladies and gentlemen, we have so much to go over during towel break, but first, I wrote up the post. Let me post it. Might not be calling Richard Green the tech expert with a history of arrest for filing false police reports during the retrial. This happened. This was announced during a shock moment when lawyers for Karen Reed attempted a last-minute move to undermine the state's expert, Dr. Jessica Hyde, and her and Hyde's confirmation of a 6:23 and 6:24 a.m. Google search by witness Jen McCabe. Oh, ladies and gentlemen, it was then concluded the break with a further 30-minute recess. We will be back into session after 11 a.m. It also appears Dr. Hyde will be the next witness called to the stand after 11 a.m. today. Oh, ladies and gentlemen, we have so much going on. We must tell the towel friends. We must alert the world. We must be good little towels. Dr. Jessica Hyde is going to further confirm Jen McCabe's 6:23 and 6:24 a.m. Google search, and the Karen Reed defense is having a meltdown about it. And you might say, Towel, you are doing an excellent job keeping us updated, and I would say thank you very much, dear towel friends. I do my best. Now, I will say, I think it's important that towels stop yelling in Bob Cosell towel form. One, because yes, these are important moments, but I don't think I actually need to mock Bob Alessi by yelling. I think it puts a lot of stress on little towel's vocal cords. The other thing is, yes, there is a lot going on, but we as little towels are keeping the world updated. Yes, ladies and gentlemen, I'm even uploading a dual clip of that last hearing. Yes, I'm going to post both video files so people can watch because it was longer than 1 gig, and I try to limit recordings so that I can upload them to other platforms without issue. All right, ladies and gentlemen, Dr. Jessica Hyde testifying in just a few moments. Towel uploading and spell correcting. All I spelled wrong was appellate. That's a hard word to smell. Spell. I spelled confirming wrong. Oh no. I forgot a D in the word Maryland. Ladies and gentlemen, I'm so sorry. I apologize to the people of Maryland. They are truly Marylanders. I spelled Ian Whiffin's name right. I got everything else right. I only forgot those few words. Or I only misspelled those few words. Ladies and gentlemen, what shall we watch to get caught up over the break? What clips shall we see? Well, there wasn't really very much. Oh no, I dropped my water bottle. There wasn't very much that occurred during the morning session. It was really that shock last-minute interruption before Jessica Hyde took the stand. Oh, ladies and gentlemen, no one saw it coming. And by the way, did you know that Karen Reed's expert, Stumbling Mumbling Richard Green? You want to see something interesting? Little Towel shall bring it up for you in just 1 second, because I must upload these other files. Well, I guess I can bring it up for you anyway. Okay, watch this, Little Towels. And you might say, oh, Towel, what are you going to bring up for us? Oh, ladies and gentlemen, if you thought it was interesting enough, we'll wait till you see what is about to happen right now. We won't see Stumbling Mumbling Richard Green for a few weeks, but let's just look at Stumbling Mumbling Richard Green's history. The defense expert who so misread a Celebrite data point about Jen McCabe's 6:23 and 6:24 a.m. Google search that Celebrite had to change their program. Richard Green, who had to rely on, the Celebrate chat support and wouldn't return Ian Whiffin's call. And by the way, ladies and gentlemen, over the break, we are going to preview Jessica Hyde's testimony because I have it from the first trial because I'm a towel. Oh, yes, ladies and gentlemen, I know that you... Oh, I have the thing posted. Why is he screaming? Don't blame me for yelling. It was actually Bob Alessi. Yes, Ed Jobs, you are a prescient towel. We are going to bring up Dr. Jessica Hyde's testimony from last year. But first, ladies and gentlemen, what is this? What is this? Oh, my word, is this a Richard Green arrest report? Did Richard Green get arrested, ladies and gentlemen? Oh, my word, Karen Reed's expert, Stumbling Mumbling Richard Green, really did get arrested for filing a false police report, ladies and gentlemen. And I think there might be some other charges as well, which include battery. And, oh, yes, ladies and gentlemen, look, there was even an agreement Mr. Green's case number out of the county of the county court for the 6th Judicial Circuit of the state of Florida, and for Pasco Pinellas County, case number 16-16392-MM-E, state of Florida versus Richard Green. There's the agreement, ladies and gentlemen, on the right side of your screen, on the middle of your screen. You can see it right there, ladies and gentlemen. I can even do this, and I think I can zoom in. Oh, yes, I can. There you go, ladies and gentlemen. Look at what the defense did. They didn't want stumbling, mumbling Richard Green's arrest record in. They wanted to hide it from the jury, ladies and gentlemen. The Karen Reed defense wants to hide stumbling, mumbling Richard Green's arrest from the jury. Their tech quote-unquote expert. Look at him. That's him, ladies and gentlemen. And look at that text. Ladies and gentlemen, we can zoom in even more. Hold on, I'm a towel. I'm a towel. You can even read that on your screen. Look at that. The defendant stipulated to some kind of agreement. It looks like he took a plea in the case. Yes, ladies and gentlemen, it is on your screen. You can see it right there, the document before you. It's some kind of proffer agreement. And there you go, ladies and gentlemen. It's on stumbling, mumbling Richard Green. Richard Green, there it is. You can see it right there. And what was the charge that stumbling, mumbling Richard Green admitted to? Let's look very closely. It was a pre-trial and intervention for 6 months. Let's see. The crime that, for the purposes of this program, the defendant acknowledges and accepts responsibility for the crime he or she is charged, and acknowledgement not to be used against him in the event of future prosecution. The person agrees that such acknowledgement is the first step in rehabilitation. Oh, ladies and gentlemen, there you go. You can see it right there, the documents themselves, and there it was. You can see stumbling, mumbling Richard Green was actually arrested. And then you can see the charges over here. They related to battery, simple battery. The date of offense was 9/23/16, court date 2/5/18. And that was it, pretrial diversion for simple battery. And then the false report of a crime. There you go, ladies and gentlemen. That date of offense the same day. Oh, ladies and gentlemen, there is why the defense is so worried about their own expert, stumbling, mumbling Richard Green. Are they going to try to exclude? Are they going to avoid calling him? Are they making all this noise about Dr. Jessica Hyde just to avoid having to deal with the embarrassing nature of stumbling, mumbling Richard Green? We don't know, but ladies and gentlemen, we found the documents. We found the documents. I'm a towel. You're a towel. We're all towels. Now, we had a request for Jessica Hyde's testimony, and I am happy to oblige, ladies and gentlemen. I am an accommodating towel. By the way, since we only have about 15 minutes to go or so until Towel gets to prepare for his break and go get lunch, continue to support Towel Stream. Yes, feel free to like the stream, subscribe to the Towel YouTube, all the wonderful things you Towel friends do to say thank you for Little Towel. It means so much to me, and this is a public information service, so don't forget, by supporting Towel Stream and the unique Karen Cam and otherwise, you help other towels become informed consumers of information. And Towel's also getting exhausted, which means we must keep Towel fed. I don't think I should only eat popcorn and chocolate snacks and drink energy drinks and live off water and Prime. I think that is a terrible idea for Little Towel. And you might say, yes, Towel, we want you to go eat. And I agree. I will go get my lunch as soon as we're back from session, which would have been now if Bob Alessi didn't talk for so long. Oh, dear God, it's tormenting Little Towel. All right, ladies and gentlemen, let's watch Dr. Jessica Hyde. Let's look. Here we go. Let's watch one of Jessica Hyde's testimony, just a piece of it from last trial, and then we'll watch other parts as well. Let's listen together. I'm a towel. My name's GrantSmithEllis. Hold on, little towels. Let's begin again.
For Mr. Green, what, if any, issues, of course, of significance did you observe in his analysis?
In Mr. Green's analysis, there is a conclusion that is drawn that a search occurred at 02:47 a.m. on January 29th based on the artifact recovered from browser state DB that Taillight parses. And there are two errors with that. The assumption that that is the time of the search is a misunderstanding of the browser state DB artifact, because that artifact is not the time of search, it's the time of movement of the tab, as well as the statement that that it was deleted due to the demarcation of Celebrite as recovered.
Based on the totality of your analysis, your testing, and everything that you looked at in this case, what, if any, conclusions did you come to?
My conclusion is that there was a search at 02:47 a.m. for Hawk Mock Sports. That browser was in use, and there were continual searches due through the night. The phone was, I do agree with Mr. Green's findings that the phone was in use at that time at 02:27. Later, the phone a web search is done at 6:23 a.m. For how long. At that moment, Apple produces a suggestion for how long to digest food. The search is instead completed with how long TI, die, and CKLD at 6:23. A new search is conducted at 6:24 of HOS long to die in cold, Haas long to die in cold. That search is then the last search that is made in that particular tab. And that's my conclusion.
What, if any, conclusion did you come to in regard to items being deleted pertaining to those artifacts you were looking for?
In regards to those artifacts pertaining to those search terms, I had no evidence of deletion.
I have a moment, Your Honor.
Yes.
Now, ladies and gentlemen, let's watch even more. Let's watch even more of Dr. Jessica Hyde's testimony. Oh, also, God bless you to the towel friend who sent over a donation. I didn't even put the information in chat because I'm still trying to get up the images of, or the video of that pretrial here, or that last motion hearing. It took me 17 minutes to upload all of that footage, but I'm a towel and it is now shared with the wider towel world. Yes, ladies and gentlemen, I am an effective and active towel, at least mentally. My physical body is not doing so well. That's okay, little towels. I will eat soon. The brain needs calories, and I'm intent on getting some. Now, ladies and gentlemen, I have one more piece of information. I want to show you more of Dr. Jessica Hyde's testimony from the first Karen Reed trial. We had a request from Ed Jobs, and I will live up to that request because I'm a towel. All right, ladies and gentlemen, here we go. Let's see if I can get the best parts of Dr. Jessica Hyde's testimony. Oh, I have it all in order. Oh, my word, I'm a little towel. Wait a minute. Yes, I do have it all in order. I'm a little towel. Okay, ladies and gentlemen, give me 1 second. Give me 1 second. I have to get to where Jessica Hyde starts testifying. It was on June 14th, 2024, it looks like. Hold on. I'm trying to get to Jessica Hyde's portion of the testimony. Oh, interesting. You want to see footage that proves Karen Reed's car can back up to 24.2 miles an hour, by the way? I said 24.5 in the clip, but it's 24.2. Ladies and gentlemen, how interesting is this from Little Towel? What do we have here? Footage from the first trial of Karen Reed's Lexus backing up to 24.5 miles an hour? I do think so. There you go, folks. Reach 24.2. One more time. There you go, ladies and gentlemen. That's some interesting footage. Now that was played. Now you want to see what it looks like, what it looked like inside.
Center of the dash.
You want to see what Karen saw while backing up at that moment? Let's look, ladies and gentlemen.
Super Paul, as far as the, this is a closer up image of the screen that was visible in the center of the dash of the vehicle, is that correct?
Yes.
And if you could, using the laser pointers, this may be a little difficult to see. If you could, using the laser pointer, direct the jury's attention to what, if anything, you observe on this screen while the vehicle's in reverse now, correct?
Correct.
If you could, direct the jury's attention to what, if anything, you observe on this screen as the vehicle's in reverse with the exemplar pedestrian behind.
Yes. So this screen has now changed to a park assist screen, and it now shows a sensor for the back of the vehicle. And also same here, the sensor starts popping up in a yellow line for behind the vehicle.
Then in the camera view?
The extra camera view shows that's where our puncher bag dummy was, and also shows where the sensor's backed up to on the bottom here.
And Ms. Gilman, for the record, this is about 34 seconds in, if you could press play from here.
There you go, ladies and gentlemen. There you go. You just saw what it looked like. Karen definitely had sensors. She had backup lights. She knew what she did, in my opinion. Ladies and gentlemen, now we are looking for Dr. Jessica Hyde's testimony. It was clearly a long day of testimony. Okay, so Dr. Jessica Hyde actually testified in the morning, and I am a silly towel who went backwards who went all the way to the end of the day when I should have gone to the beginning of the day. Yes, ladies and gentlemen, we may get a little off track, but at least we locate all this information so quickly. And we will get back into session, folks, here just at the top of the hour. I found it, ladies and gentlemen. Oh, ladies and gentlemen, it is a glorious day for towels. I found it. I found the Jessica Hyde testimony. Where is it? Where is it? No, it was before that. What? Oh, there we go. Here we go. Here we are, folks. Wait a minute. That jumps a little out. Oh, that was exhibits. Here we go. That was the crescendo. We just listened to the confirmation of the search. Here we go. And ladies and gentlemen, we can even go back to the beginning of Dr. Jessica Hyde's testimony. Here we go. Let's listen to what the intro was like. This is the preview. Dr. Jessica Hyde could be testifying in just 8 minutes.
I went and became the director of forensics for Magnet Forensics, which is a company that develops tools for digital forensics. So there I was in a position where I did a large amount of research into new artifacts, unsupported access to devices, etc. I was there for 5 years before starting my own firm.
And then what did you, no, I'm sorry, let me start again. As far as what, if any, teaching experience in relation to the field?
That is an excellent question. I've actually been an adjunct professor at George Mason University. Since 2016, I've taught 20 terms. In their graduate program, I teach the Mobile Forensic Analysis course in their Digital Forensics Master's program.
In addition to your work and your teaching and all your training, are there any professional organizations related to your field that you're a member of?
Actually, several. I am a member of the Organizational Scientific Area Committee on Digital Evidence, which is a part of NIST, the National Institute of Science Technology. I am a member of the Scientific Working Group on Digital Evidence, also called SWIG-DE. I am the chair of a project called DFIR Review that does peer review of academic work that's done by practitioners in the form of blogs. I've been chairing that project since 2018, or when it started, with our first publications in 2019. I am the first VP at the International Executive Committee level of the High Tech Crime Investigation Association, also called HTCIA, which I've been a member of since 2012, and I've been elected, I'll ascend to president next September. I am also, I do a lot of volunteer work. I also am an associate member of the American Academy of Forensic Sciences, AAFS, and I just recently finished my term as an associate editor for Forensic Science International Digital Investigations, which is a peer-reviewed journal in the academic space of digital forensics. And I'm still a reviewer, but I stepped down from my duties as an associate editor.
Yes, exactly. Tell me more, Bob Alessi, about how you're going to try to go at Jessica Hyde, Dr. Jessica Hyde's credentials. Bob Alessi, this expert is going to eat you alive, sir. Get ready for it, and I mean that metaphorically. Dr. Jessica Hyde is literally a former Marine veteran. Bob Alessi, good luck with that. Let's listen more. Let's listen to Dr. Hyde's background in digital forensics. Bob Alessi must know he's in trouble, ladies and gentlemen. Bob Alessi is worried about this witness for good reason. She's incredibly intelligent.
Any sort of articles or publications have you published in relation to?
Great question. I've published a paper on the standardization of data recovery. I worked on that with Dr. Owen Casey and Dr. Nelson. That was published in Forensic Science International Digital Investigations Journal. I also was the second author on a paper related to the use of AI in digital forensics, artificial intelligence, and I've published numerous articles, blogs, white papers. I probably have published about 20 of those, but just speaking to the peer review work, there's 2.
When you say peer review, can you explain to the jury a little bit about what that means or what that process entails?
Absolutely. So a peer-reviewed work is when you have a novel piece of research that you then submit that novel, never been presented work to a journal. It then gets reviewed by numerous academic peers. It goes through cycles of revision where they ask more questions. On the standardization of file recovery paper, that process took about 14 months for it to be peer reviewed by experts in the field, and then it is published in a journal.
So you've had both articles that you've authored that have been peer reviewed and published, as well as you've performed the role of reviewer of other people's work?
Correct. I've performed in addition to the publications I've done, I reviewed at least 20 to 30 articles, both in a combination of support for Forensic Science International Digital Investigations Journal and DFIR review.
Now, Ms. Hyde, if you could explain to the jury, when you say the term as far as digital forensics, what do you understand that term to mean with relation to what you do?
I would describe digital forensics as the analysis of data from any storage medium that can control data, be that a mobile phone, computer, or cloud, for the intention of that data intentionally being used for court.
And with reference to your firm, Hexordia, where is that located? What state?
We are headquartered in New York State, in Bridgeport, New York, which is outside of Syracuse. We also have an office location in the DC metro area in Tyson's Corner, but we have employees in 6 states.
And with respect to your duties and responsibilities in regard to your firm, what is it that you do?
Great question. So I do perform digital forensic analysis on cases. I currently work on 2 U.S. government contracts supporting 1 digital forensic analysis and 2 novel research and exploitation of mobile devices. So I'm named personnel on 2 contracts, and then I manage another 3. I also develop training for mobile forensics. My courses have been taken by people all over the country, and Hexordia also delivers that training. I also do research and presentations for journals, conferences, etc. So a combination of casework, education, and research.
All right, ladies and gentlemen, you heard even more background from Dr. Jessica Hyde, who it looks like will be the next Karen Reed and John O'Keefe trial witness. Also, I will not be putting up a permanent Pope chimney cam, but ladies and gentlemen, we will keep an eye on it. Now, let's look at how Jessica Hyde's going to explain how badly Karen Reed's defense expert, who's kind of not really as high level an expert as Richard Green, as Ian Whiffen and Dr. Jessica Hyde. The defense witness is Richard Green, the one with the arrest record. Let's look at how badly Dr. Jessica Hyde is going to tear Richard Green apart before he even gets a chance to get on the stand.
Now, you used a term in there as far as a wall or a right-ahead log file. Is that correct?
That is correct.
Can you please explain to the jury what your understanding of that term is based on your training experience?
Absolutely. This is a really interesting data structure, the way it works. So the way SQLite databases work is the data before being committed to the database, which is almost like an Excel spreadsheet if you think about that. Each table is like a page on an Excel spreadsheet. The data before going there goes kind of to almost like a text file, like if you were to have a doc, of writing all the changes that need to happen to that Excel spreadsheet. And they're not made to that spreadsheet until it closes. So what happens is as you're doing things, either adding a website by searching for it, or closing a tab or deleting a text message in a SQLite database in general, both things you add are written to that text document or things you delete. So they all hang out there together. So it's any changes that are going to be made since you started using that application until it's closed, then they change there and then it reopens. So to make an analogy, if you're in a restaurant and you order some food, the food being the data, and you at the table being the table that the data is going to, when you request that data and you say, I'm adding it, it goes to the area where the waiter or waitress or server is going to grab it from, right? That warming station. That is almost like our right-ahead log. And so different tables are ordering food and food is constantly being put there. If somebody, maybe their steak came out rare and it needs to be cooked more, when they send it back, it'll also go to that warming area. So you can see there that you've got things waiting to go out to the tables and things being sent back to the kitchen. So simultaneously, that storage area contains both the newest stuff waiting to go out and the stuff coming back.
Now, let me just explain this to the little towels for a second, because this is a little convoluted. What we're talking about here is something called a WALDB write-ahead file, okay, ladies and gentlemen, a WALDB write-ahead log. This really has to do with just debunking how Stumble and Mumble and Richard Green, the Karen Reed defense expert, misinterpreted the 6:23 a.m. and 6:24 a.m. timestamp, which were the actual timestamps of Jen McCabe's Google searches, and thought for some reason that a write-ahead file in the WALDB log was somehow indicative of those Google searches happening at 2:27. That was wrong. What happened was at 2:27 a.m. Jen McCabe was at home and she was Googling Hawk Mock Sports, which interestingly is a plaza in Braintree. I drove through it one time, Hawkamock Plaza. Anyway, Hawkamock Sports, Jen McCabe Googles that at 2:27. Jen McCabe opens her browser at 6:23 a.m. to do the How Long to Die in Cold search at Karen Reed's request, and that does a write-ahead note in the WALDB file. Richard Green misinterprets the write-ahead as the time of the search, and that's why all this stupid nonsense started. Jessica Hyde explains what a WALDB write-ahead log is. Little Towel understands it because he speaks computer file. Towel understands what this all means. Most human beings are going to get a little bit confused because they don't speak computer. Now, I'm trying to explicate it to you in a simple way. Dr. Jessica Hyde explained it in another way. A WALDB file or a write-ahead log basically means you have something stored in a cache or a cache, basically. I forget what the way that it's said. Cache, I think. You have it stored, okay? And that file, if you open a browser at 2:27 and Google something like Hawkmock Sports, that's going to suspend in the cache. If you open that again at 6:23 a.m. to Google How Long to Die in Cold, there's going to be a write-ahead in the WALDB log. It's going to know that you suspended the tab state and you reopened it to do a new search, which is what Richard Green misinterpreted because the man is a moron. I, Little Towel, who does not specialize in forensic cell phone analysis, can explain that in 25 seconds. And this man, with an arrest record for false police reports, proclaims to be able to understand it and got it wrong? Nonsense, ladies and gentlemen, nonsense. Nonsense, nonsense, nonsense. Dr. Jessica Hyde is going to rip Richard Green to shreds before the man even gets on the stand. Oh, yes, ladies and gentlemen, and Dr. Jessica Hyde will continue to explain how Stumble and Mumble and Richard Green got that right-ahead WALDB log so wrong in his report and interpretation that Green ended up apologizing on the stand for getting that part so wrong.
And that's really what a WAL file winds up containing, your newest Google searches, your newest text messages, etc., as well as anything that you've been deleted, that you've said was deleted, because the reference in there is going to be delete this entry. And so then all of those don't happen until the application is closed and reopened. If the application's been closed, when we do the extraction, we actually don't get the wall file. We only get the wall file if at the time of extraction, that database had not been closed. So that just means that Safari in this instance was still running when the extraction was done. Most of you, when you use your phones, you leave the applications up. So because of that, we have a wall file, and so that wall file is going to contain both data that's been requested to be deleted and new data. Now, when I say deleted in this instance, I don't mean like you as a user saying delete this old text message. What I mean when I say deleted in this instance is removed from the database. So when we're talking about something like a Safari tab, deletion from the database can occur because you close the tab. We all open tabs when we use our browsers on our phone, and we all close them. And so closing in that instance would be a deletion in the database, but what that's doing is not a user requesting deletion. So I just want to be clear on that term.
Now, just so folks understand what Dr. Jessica Hyde is saying there, Dr. Jessica Hyde is saying delete, what we think of as a deletion. This is why you have to be so precise with technical parlance. A deletion just means something is removed from a log. And a system deletion can occur when, for example, a write-ahead denotation in the wall DB file gets overridden because a tab is opened. Say a tab's opened at 2:27 to do a search for Hockomock Sports. Then a couple hours later, 6:23 a.m., the browser's reopened to do a search for How Long to Die in Cold. Guess what happens when the wall DB file gets overwritten by that new search? It's going to delete some of its cache data. Richard Green got that so wrong he had to apologize on the stand during the first trial. And ladies and gentlemen, I'm thrilled that we're going to get to go through a preview of Dr. Jessica Hyde's testimony. Let's listen to stumbling, mumbling Richard Green apologize because of how badly this woman, Dr. Jessica Hyde, ripped Richard Green to shreds. Ladies and gentlemen, Richard Stumble and Mumble and Richard Green may as well crawl under a hole after listening to Dr. Jessica Hyde testify. She is a boss, and she's a Marine veteran, and God does Towel respect the Marines. Now let's listen to him apologize. Let's listen to him apologize. I want to see the apology. I want to see it. Ladies and gentlemen, I want the apology. Here we go. Where's the apology? I want it. I want him apologizing. Come on now. I want to see it. I want to see it, ladies and gentlemen. I know that I can find. Do I have to literally look up the word apologized? I think I do. I remember tweeting him saying the word I'm sorry and then me writing apologized. I found it. Oh, dear Jesus. Thank you. I appreciate it. I don't know if that was divinely inspired, but I found what I was looking for. Oh, ladies and gentlemen, I found it. Let's look at it. Let us look at the moment. Stumbling, mumbling, Richard Green apologized because of how great Jessica Hyde's and Ian Whiffin's testimony was during the first trial. There he is. That's him, ladies and gentlemen. That is Stumbling, mumbling Richard Green himself. Here we go.
That was something that was a suggestion and not something that was actually searched, correct?
Yeah, no, and I know this different from my affidavit from about a year and a half ago, in all fairness, but
that's entirely different.
One person,
correct?
Mr. Lally.
I'm sorry.
One person at a time.
Yes.
Okay. So, yeah, in fairness, I want to give you my best knowledge as I understand it saying here today, including after my review of Mr. Whiffen and Ms. Hyde's report. So I want to do everything I can to shine as much light and clarity on this as possible. So as I repeated, since that time and did the search, I would notice that is one of the things that would come up, and it would have a little picture of like a dinner plate or something like that. And there was actually a similar, if not the same picture found in the artifacts of that phone.
And so just to conclude, that's not what you said in your affidavit that was actually filed under pains and penalties of perjury with this court, correct?
Yes, and on that day, that is what my true and proper belief was. Okay, it since further testing, I have found that I now believe that was probably an automatic one, and if I've caused you any distress, I apologize.
When he says I found that was an automatic one, he meant it was an automatic system deletion. Do you understand what I'm saying? And that's what Jessica Hyde was previewing when she was talking about the write-ahead file in the WallDB. Now, for me, ladies and gentlemen, for me, I understand that a lot of you are saying, Towel, you seem to know what this means, but I still don't get it. I'm trying my best to explain to you how their systems, we're talking about like your phone, okay? Your phone is just a database of code that's running programs, okay? So you have to think of just this large data sheet that exists in probably hexadecimal format, and although it's probably encrypted and salted, I don't want to get into all of that stuff. But the point is, your phone is just this giant database of numbers, and by running specific strings of instructions, you can tell the phone to do certain things. One of the things a phone does is when you visit things like websites, it tells its big sheet of numbers, hey, somebody just visited this website. We should store it so that if they open the browser again, we're going to know what they were doing. This is called a suspend state. It's designed to facilitate effective operation of digital environments, in particular through graphical user interfaces, which have to interpolate hexadecimal numbers and display them for users, and it takes up processing power. So the goal here is to try to make things as accessible as possible by using something called a cache or a cache. It's literally just a space that exists to allow this big sheet of numbers to say, this particular set of numbers might get called up again soon in your memory. You should prioritize your system resources on focusing on this. Now that is called a write-ahead file in the WallDB, okay? And if you access that database again, it needs to update its sheet of numbers and tell that section of the GUI. It needs to tell the place that's holding this page that was suspended, oh, there's a new tab opening. And do you know what it does when you open a new tab or do a new search? It erases some of the previously cached data because that's set aside as priority space within the memory so it can access those pieces of number, those sections of numbers quicker than others. So it doesn't perpetually store everything. Thus, the system deletes things. Oh, goodness, ladies and gentlemen, I pray that I have just explained it to you in an accessible format. Towel clearly speaks to computers. I'm not really sure this is healthy for little Towel, but now you understand how Towel's mind works. And if you want to know something even more interesting, you might be saying to me, Grant, what does hexadecimal mean? I'll explain it to you, ladies and gentlemen. Most of us operate in base 10, okay? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, whatever. Those are all base 10 numerals. We can convert those numbers to base 2, okay? Base 2 is just a series of zeros and ones. Now, they exist in 8-bit strings when we're in base 2, okay? So if you want to express the number 1 in base 2, you would go 0, 0, 0, 0, 4 zeros, then another set, 0, 0, 0, 1. You have 1, 1 in the ones place. If you want to express the number 2 in base 2, you would do 0, 0, 0, 0, one set of 4 zeros, then 0, 0, 1, 0. Now you have one number activating in the 2's place. Now if you want to express 3 in binary, it would be 0, 0, 0, 0, 0, 0, 1, 1. Now you have 1 in the 2's place, 1 in the 1's place. Do you understand binary? Okay, very good. Now computers work a little bit differently. They take raw binary basically and interpret it into something called hexadecimal code. Hexadecimal code is where you represent numbers by way of things like 0 through 9 and A through Z. It is very convoluted. It is difficult to explain. But just know when we're talking about WallDB files and data sets, it is just basically zeros and ones interpreted into a string of numbers and letters, stored somewhere on a piece of, on a hard drive, and then interpreted from those numbers to what you see on your phone, which is actually just a visualization of numbers being computated through various pieces of software and code. And yes, even your phone without apps running is constantly interpolating code, such as to free up space in your cache to make your phone more efficient. And that's what's going to be talked about when Dr. Jessica Hyde gets on the stand. Oh, ladies and gentlemen, someone should have Towel go around and explain these things. I think Towel gets it. I think Hank Brennan gets it too, ladies and gentlemen. We all are learning by the moment. All right, now let's watch even more of Dr. Jessica Hyde's testimony, because I find Dr. Hyde more interesting than Stumble and Mumble and Richard Green. What else did Green testify about? Why does David Yianetti have his head in his hands for this? What was so bad about this? That's a great vision. Look at that man. He was a defeated David Yianetti.
Now, with respect to sort of the totality of your analysis, Mr. Whiffen, what, if any, conclusions did you come to as to the timing of the two searches in question?
Oh, we already listened to Ian Whiffen's testimony. No, we want Dr. Jessica Hyde's testimony, ladies and gentlemen. Dr. Jessica Hyde. There we go. Now, we listened to that one already. Now let's listen to this one. Let's listen to Dr. Jessica Hyde further confirm the 6:23 and 6:24 a.m. timestamp.
For Mr. Green, what, if any, issues of significance did you observe in his analysis?
In Mr. Green's analysis, there is a conclusion that is drawn that a search occurred at 02:47 a.m. on January 29th. Based on the artifact recovered from Browser State DB that Taillight parses. And there are two errors with that. The assumption that is the time of the search is a misunderstanding of the Browser State DB artifact, because that artifact is not the time of search, it's the time of movement of the tab, as well as the statement that it was deleted due to the demarcation of Celebrite as recovered.
And based on the totality of your analysis, your testing, and everything that you looked at in this case, what, if any, conclusions did you come to?
My conclusion is that there was a search at 02:47 a.m. for Hawk Mock Sports. That browser was in use, and there were continual searches due through the night. The phone was, I do agree with Mr. Green's findings that the phone was in use at that time at 02:27. Later, the phone a web search is done at 6:23 a.m. For how long. At that moment, Apple produces a suggestion for how long to digest food. The search is instead completed with how long TI, die, and CKLD at 6:23. A new search is conducted at 6:24 of HOS, long to die and cold, Haas, long to die and cold. That search is then the last search that is made in that particular tab. And that's my conclusion.
What, if any, conclusion did you come to in regard to items being deleted pertaining to those artifacts you were looking for?
In regards to those artifacts pertaining to those search terms, I had no evidence of deletion.
Can I have a moment, Your Honor?
Yes.
Ladies and gentlemen, fellow towels, you heard the testimony from Dr. Jessica Hyde there. No user deletion. This is the preview of what we're going to see after lunch. Now let's watch David Yianetti try to cross Dr. Jessica Hyde. It does not go good for him. It does not go good. Let's listen to watch when Yianetti tried to cross Dr. Hyde. It was literally embarrassing. Oh, folks, we're about to come back into session. Oh, let's watch this quick.
Ms. Hyde, you just spent maybe 45 minutes to an hour, whatever the time period was, explaining to these jurors what is really a complex set of facts that led you to conclude that the 2:27 a.m. timestamp on that Google search was triggered by the closing of a tab. Did I essentially sum that up correctly?
Essentially, except it's not 2:27 a.m. timestamp on a Google search. It's a 2:27 a.m. timestamp on a tab.
Oh, get ready, folks. It's going to be that good. Dr. Jessica Hyde, such a boss. Get ready. I'm going to transition to the Karen Cam. We're not entirely ready to come into session, but it will be any second. My name's GrantSmithEllis. By the way, before I forget, Towel's going to finally get his break and get to go get lunch. If you want to support Little Towel, I can say for sure that I am grateful to all of those who have been sending Super Towel chats. You can join the channel as members. You can like the stream. You can subscribe to Towel channel. If you become a member, you are even able to use special towel emojis. Look at them raining in the chat now. We even have new custom Chewbacca and Stay Puft Marshmallow Man emojis. Yes, ladies and gentlemen, if you appreciate all this information, the facts that are relayed, the documents, the primary sources, you can show your support as we get ready to come back into session in a number of ways. You can even send donations to Little Towel, which he will use to not starve, although I want to wander the countryside in a robe and preach moral philosophy, ideally without running out of food, thus inspiring a new age of Aquarius and towels based on universal love. Get ready, ladies and gentlemen.
Chrissy, do you want this under that? None of the purposes.
Get ready, ladies and gentlemen.
Enter your participant. Okay. Please enter the pass.
Okay, thank you.
You have joined the meeting as an attendee and will be muted throughout the meeting.
Please be seated, court is in session.
The host would like you to unmute your microphone. You can.
All right, I appreciate the time. I appreciate people's patience. So, in reviewing the rules, I look at Rule 2. So, Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so, upon reflection and consideration, it says, these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So bring the jurors in, please.
You are unmuted.
Chrissy, do you want this under that?
You heard it, ladies and gentlemen. GrantSmithEllis here. We're about to come back into session. Karen Reed has lost her attempt to try to undermine the credibility of Dr. Jessica Hyde, who will confirm Jen McCabe's 6:23 and 6:24 a.m. Google search, along with John O'Keefe's location on the lawn at 12:32 a.m. and 16 seconds, the moment when Karen is alleged to have struck John with her car with a BAC 2 to 4 times the legal limit. Tune in now, youtube.com/@GrantSmithEllis as we get ready for the afternoon session. I will see you then. What a ruling from Judge Cannoni. The Towel friends are celebrating. Here we go.
Back in session, you may be seated.
Jurors, I appreciate your patience. So, your next witness, Mr. Brennan?
The Commonwealth calls Jessica Hyde.
please. That's all. Face the clerk and raise your right hand, please.
You solemnly swear the evidence given to the court and jury in the case now and hearing the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica, space Hyde.
What do you do for a living?
I'm a digital forensics examiner. I'm also an an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University, not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, etc.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are three types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, you know, if you think about it, if on your phone you can go to the Google Play Store or the App Store and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues, that's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. on local time here in Norfolk on January 29th, 2022 from the device I was provided, yes. Not the device, the forensic image, for clarity.
So before we get to the two opinions that you were asked to consider, or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 time frame. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually 3, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, And then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran 2 different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns a Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual, and on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup, and I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted, or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
When you use the term artifact, what does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo. Any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So, for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town, I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search Haas Long to Die in Cold. However, that timestamp isn't about active searches, it's about the time that a tab was either opened or moved to the background. So Haas Long to Die in Cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the It's Raining Men video is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is Haas Long to Die in the Cold, because that database holds the current search. It constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Yes.
Handing you a piece of paper. Do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the thing that will help you explain?
It will.
I move this into evidence.
Can we approach you? Or I've got a bit of jacket if you want.
Come on out.
Ladies and gentlemen, Dr. Jessica Hyde has just said that this Google search from Jen McCabe was at 6:23 and 6:24 a.m. And we, as Towel Friends, await. David Yianetti is fighting hard. Karen Reed lost her motion to try to undermine Jessica Hyde. My word, friends. My word, friends. My name is GrantSmithEllis. We monitor closely. We wait for the sidebar to end. It has not ended yet. Oh, 20 seconds? Nope. I thought... Ladies and gentlemen, My word, Towel just wanted to get lunch. I stayed with you to provide commentary, and there was a sidebar right before Towel went to get his pizza. Oh, ladies and gentlemen. Oh, ladies and gentlemen. Ladies and gentlemen, Towel is watching so closely. Ladies and gentlemen, Towel is watching so closely. What is this sidebar about? Jessica Hyde must... Ladies and gentlemen, we are still at Sidebar. Still at the Sidebar. What is going on? What is Alan Jackson and David Yianetti afraid of? Sorry, ladies and gentlemen, I am setting up a fan. I need a fan in my room because the air is bothering me. And someone said they're going to bring me a fan. I am thrilled. But I don't like fans. Oh no, what am I going to do? Oh, ladies and gentlemen, as a Towel, I am just so thrown off. But how can you turn down someone bringing you a fan? Oh my word, ladies and gentlemen, I am an excitable Towel. 20 seconds, I'm going to get lunch, and apparently someone's bringing me a fan. All right, you all have fun. I'm going to eat. I'll be back with you. No more sidebar coverage for 20 minutes. I don't know who of you is. All right, you can all be in charge of each other, and everyone continue to be lovable, friendly, amicable Towels. I will see you very soon. The sidebar should be ending in 5, 4, 3, 2, 1. Oh, I screwed it up. I am normally so good at that. Maybe more like 3, 2, 1. Come on now. Now you're just tormenting me. Let's go, court camera pool operator. The world is waiting. Towel is waiting. Here we go.
In the chalk. So let's
start. Hold on, ladies and gentlemen. We have to back up a little bit.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I look at my copy of the chart or no?
Why don't I just ask you to...
See if you can answer the questions and if you can let us know.
Yes, Your Honor.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search, how long to die in cold?
Correct. I was looking for 2 searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the 3 that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrite, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrite?
I use Celebrite because on any mobile exam, I'm going to validate what is captured by Celebrite and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also use Magnet Axiom?
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company, Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image, and that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize, I also used Artex and Mushy. But the, I'm sorry, Artex is capital A, lowercase rt, capital E, lowercase x, and then Mushy is M-U-S-H-Y. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrite, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundations paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
Oh, the software updates all the time. Typically, we get an update about once a month, and to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search, did the search "How's Long to Die in the Cold" have a timestamp on it?
There are actually multiple artifacts for How's Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How's Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, how long to die in the cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that that tab was backgrounded, or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as how's long to die in the cold with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result, so it carved it out and went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp as well as the phrase, how's long to die in the cold, Where did you look? How did you make an analysis to determine whether or not that search was actually made at 2:27 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab, and then I make another search in a tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the Artifact Reference Guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question, yeah.
Okay. Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 2:27:40 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 6:23 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parsed results from all of those, and I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for browser state DB, cloud tabs artifacts, history DB, mobile Safari plist, knowledge C, each one of those, and then I was combining them to timeline out the activity.
At 6:23:51, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see, is we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari AP list.
Can they appear in different rooms in the data bank, in different places, the same search?
Searches appear in many different places. They can leave traces, such as that knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari P list, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And finally, at 6:24:47, did you identify any artifacts with that search that appears with the timestamp of 2:27:40? Did you find the same?
Correct. At 6:24, we have two timestamps in the same two locations for Ha's long to die in cold. The Knowledge C and the Mobile Safari P list.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase "how's long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no.
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "how's long to die in cold" was searched at that timestamp tab of 2:27:40?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at Sidebar, Mr. Leslie.
Thank you, Your Honor.
You've explained to us the analysis you engaged in the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How about through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
yes.
Is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, "How's long to die in cold?"
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data scientific certainty, what is your opinion about whether the phrase "how's long to die in cold" was made at the time of the timestamp 2/27/40?
It's the last time, Mr. Hesse, on this issue, okay? All right, go right ahead, Mr. Kearney.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 2/27/40 was whether or not that was the time the search "How long to die in the cold" occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search, "How long to die in the cold," occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objection's overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion, to a degree of scientific certainty, whether there was any other searches similar to "How long to die in the cold" that evening on that tab?
Objection, Your Honor.
I'm going to allow it.
May I first inquire, you meant morning, I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train of
Do you have
thought.
an opinion, to a reasonable degree of scientific certainty, whether there were any other searches on that tab before the final search at 6:24:47, "How long to die in cold"?
Same objection, Your Honor.
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Okay. Did you develop a chalk that I showed
did.
you earlier?
Yes.
Like to approach?
Yes.
Again, I show you. Same document. You recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move, subject to redaction, that this be introduced into evidence.
Your Honor, I have no issue with regard to the redaction aspect, but consistent with my prior objections, I would object to that.
Okay, I'm going to allow this into evidence. Your rights are safe, Mr.
Thank you, Your
President.
Honor. Appreciate it.
Exhibit 82.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay?
Could we enlarge the first two? And we're going to need to get the right column in if we can, please. Thank you. Ms. Hyde, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left it says 2:27:40 a.m. and then under the search term it says How Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column, it's a little bit cut off, the browser state db-wall file. That database does store, how the data is stored, the search term How Long to Die in Cold with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record. What is the term, and what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, "How long does it take to digest food?"
And then under that, 623:51, it appears it says a recent web search, and the spelling is changed. How long? TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as "how long?" TIDINCIKD. Which that is available to us in the mobile Safari plist, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see "how long to die in cold." And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for Browser State DB, that artifact will hold the most recent search that happened in the tab. So it is logical that HOS long to die in cold, was searched at 6:24:18, tracked in that mobile Safari plist, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for Browser State DB, which again has the time that the tab was opened, or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 2:27 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
And you offered that the "how long to die in cold" is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that "how long to die in cold" was searched at approximately 6:24 a.m.
Now, moving on from the 2:27 search, there are 2 other issues that you were asked to analyze. And we talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, "how long to die in cold," was user deleted on that device.
So there's 2 really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important, so we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool because that information was in that dash wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version and the version in use here uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. The waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those wall files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table. But it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file. Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that wall file can contain deleteds and food or data that hasn't yet been delivered to the database. So the wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item is a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Haslong to Die and Cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the wall file elements such as the search for the YouTube video, It's Raining Men, because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the How's Long to Die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes, hasn't been delivered to the table yet. So it can sit in the wall file for that reason. It doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web or that Safari search is characterized as deleted?
The tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parsed, so every tool chooses to do that differently. That does not mean deleted, it means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the data set generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how's long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how's long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs When you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count 2 and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all in the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining is recents is the most recent 200 of each category. Now, how further? There is a running log that exists in a phone, less on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see counsel at Sidebar regarding scheduling and a few things?
Sidebar, ladies and gentlemen, towel has returned. I know you all miss towel. Sidebar has returned. Ladies and gentlemen, towel has returned. Sidebar has also returned. Ladies and gentlemen, it is towel. We are heading towards the luncheon recess. Dr. Jessica Hyde has just decimated Karen Reed's defense again. There was never a Google search by Jen McCabe for how long to die in cold at 2:27. It was always at 6:23 and 6:24 a.m. Those Google searches, those never deleted Google searches. Ladies and gentlemen, what a day. Another vindication, another round of duck boats for Jen McCabe. Ladies and gentlemen, break out the towel duck boats for Jen McCabe. Further vindication indeed. And during the luncheon recess, ladies and gentlemen, I'm excited to be with you. Little towels, we will watch the moment at 11:56 a.m. Thank you to LA Connections. Wonderful reminder. We will watch, ladies and gentlemen, the moment when Dr. Jessica Hyde so beautifully explained how Richard Green got Jen McCabe's 6:23 and 6:24 a.m. Google search time so wrong. Yes, ladies and gentlemen, it is a beautiful day. Courtney Myers is here. Oh, my dear friend, it's so wonderful to see you. You bring a smile to Towel's face. Linda O'Gara, you as well, dear friend, and no, you are not muted. I can see all your comments. Bailey, it's great to see you. I hope we are going to have a lot of fun together, Towel friends, in lunch. It looks like lunch might be happening in just a few moments. Stick with Little Towel. Let's find out how long we're on lunch. Will Bob Alessi come back at 1:30 to start his cross? Will we all be bored out of our minds? Yes, ladies and gentlemen, I can confirm for you that in just a few moments we're going to find out how long the luncheon recess is going to be. And you may say, Towel, that's wonderful. We really appreciate you. And I would say, oh, you Towel friends, did you know we broke a record today on Towel Stream? Hold on. Stay with me, Little Towel. Did you know we broke a record on Towel Stream? 228 viewers, a new simultaneous record. The Towel Twitter stream record's never going to be broken. It was like 15,000. But on YouTube, we're breaking new records.
Ms. Hyde, I'm going to let the jurors have lunch. You can walk out after.
Thank you, Your Honor.
45 minutes.
Thank you.
45 minutes. 45 minutes, ladies and gentlemen. We will be back for lunch at exactly 1:35 p.m. 1:35 p.m. luncheon recess. Okay, ladies and gentlemen, let me come back up on the screen. I am a towel. You are all towels. Everybody's a towel. You get a towel. You get a towel. Everybody gets a towel. Now, my name is GrantSmithEllis, and we have a few things to do. One, we're celebrating, ladies and gentlemen, Towel. We broke the Towel live stream record. There are so many new Towel friends among us, and they're about to find out why the erudite lunchtime commentary from Towel and the Towel friends is so interesting. You get recaps of the morning testimony. You get insightful secrets about the complex socio-political and historical dynamics surrounding this God-forsaken chaos. And then we talk about why justice for John O'Keefe is on the way. By the way, Towel friends, did you know that at any time, if anyone tries to troll your blue wall of Towel comments, all you have to do, whether you're on phone and you press down on their comment with your finger, or you're on the computer and you click their comment, you go ahead and you click that comment, and then if this person is trolling or being derogatory or discriminatory, you go ahead and you click hide user on channel. You see what I mean? Now, if they're just doing a minor infraction, you can put them in timeout, but generally don't allow any trolling. Okay, we have to go back to 11:56 a.m., ladies and gentlemen, and you might say, why, Little Towel? Why must we do so? And it is for crucially important reasons. We are going to watch the moment that the Karen Reed trial expert, Dr. Jessica Hyde, explained why Richard Green, Karen Reed's supposed expert for the defense, was so wrong, ladies and gentlemen, about the timestamp of Jen McCabe's 6:23 and 6:24 a.m. Google searches. And yes, ladies and gentlemen, we shall do this together because I am a towel. And I continue to select the wrong window. Let's see, is this the right one? Wait, I am just not having a very good towel day. Why do I keep getting this wrong? There can only be so many windows open at once, Little Towels. All right, hold on. Here, is it this one? It is, Little Towels. Wait a minute. Why does this keep happening? I am getting exceptionally frustrated. All right, last time, Little Towels. There we go. Now I can bring this up for you. Okay, are you ready, Towel friends? We are ready together. We're going to be Little Towels. We're going to go back to 11:56 a.m. and we are going to see what happened at that moment that LA Connection was so kind to remind us about, because LA Connection is truly a super towel. Ladies and gentlemen, I had 7-Eleven pizza. I ate one of my 7-Eleven pizza slices for $1.50. I have another one to go. I literally went and got those pizza slices. You towel friends donated, and I lived up to my towel commitments. I didn't actually make a commitment. I just really wanted 7-Eleven pizza. What do you want from Little Towel? What do you want from me, friends? All right, hold on. Let's continue, though, towel friends, because we're going to go back to 11:56 a.m. 11:56 a.m. How could it possibly say 2:40 p.m.? 2:40 p.m. hasn't happened yet. All right, hold on, ladies and gentlemen. We need to go to 11:40. 11:40 at 11:56. I mean, look, I almost got it exactly. We have to look at this and we have to do our lunchtime recap. Ladies and gentlemen, we must do our lunchtime recap about Dr. Jessica Hyde, and then after that, I will take towel questions. and then we'll talk, and then we'll get ready for Bob Alessi's very boring cross of Dr. Jessica Hyde.
Forensic analysis class, my about ever.
In your teaching,
hours or the time that tab stamp.
This is it.
Is there any
instances of evidence of that was parsed by Celebrate?
Now, ladies and gentlemen, Bill sent a donation so that Towel can take a ride for D&E to get pizza. Maybe not one day this week because I can't literally, in my small 25-minute lunch break between the morning recess and the luncheon recess, drive to Canton and get back to where I am. But, ladies and gentlemen, I will be making a visit to D&E to get pizza soon. God bless Bill, the Super Towel himself. Everyone praises be to Super Towel Bill. Literally one of the greatest super towels on the internet, ladies and gentlemen. The only super towel I know with a few hundred followers that consistently gets tens of thousands of views on his social media content. Follow Bill McIntyre, ladies and gentlemen, on social media. You can find him at a handle that's like EC92 something something something. Bill, share your Twitter handle in the comments. Bill is a super towel. Yes, ladies and gentlemen, let us keep watching because this is a big moment. We have to make the clip. Hold on, we must do the lunchtime summary for the Towel Friends so we can then write it up and then publish it because we are a one-person, well, we are a towel universe that is a one-person towel news media production studio. We clip things, we broadcast the Karen Cam, the only network that shows the Karen Cam, the Bill and Janet Reed cam, the David Yianetti cam, the Hank Brennan cam. Oh, God bless you, Allie 90211. It is just a celebratory stream of towel support. And ladies and gentlemen, let's continue focusing on these precious moments. The moments that Dr. Jessica Hyde explained how Richard Green would basically fail Professor Hyde's class. She is a professor at George Mason University in high-level technical analysis of cell phone data. That's a very specific profession, but as you know, that is very complex subject. And Towel, in his polytowelmathic pursuits, may not be able to understand things like this, but regular humans and Richard Green would just fail Dr. Hyde's class. Now, okay, let's listen. I have to do, frozen pizza for $4. Yes, so Allie, I am not opposed to trying out different frozen pizzas, but it's a function of time. So if the time coefficient and the price of the frozen pizza align such that it is less than $1.50 a slice to obtain the frozen pizza, bring it home, warm up the oven, cook the pizza, take the pizza out of the oven and bring it upstairs. If that amounts to less than $1.50 per slice, I will buy the frozen pizza. If not, 7-Eleven pizza will suffice and D&E pizza as a special treat. Okay, we really have to do our clip that now, though, friends. We can't delay the lunchtime update. I'm a towel. Imagine what... Oh, Karen, God bless you for the towel support. It is just a parade of towel support. You are a super towel, Karen. God bless you and thank you for supporting Towel Channel. The Towel Friends, I am sure, will be quick to thank you for your generous support and celebrate with you as we broke a Towel Stream YouTube record today, ladies and gentlemen. Okay, it's really... so Red Bear and frozen pizza is awesome. If I can get the signature Star Market brand for like $4.99, I normally get it. If I can get, my favorite is when this like Supreme, there's one really good brand, I forget what it's called, but it's like Supreme or something. Those ones go from $9.99 to $5 occasionally. If I can get the California Pizza Kitchen ones for like $6, oh, that's like a luxury for me. Towel is a conscientious shopper. When I go to fast food, I open all 5 apps that I have. I find the best deal. I find the best price per calorie, and I go to that store. Towel is a conscientious consumer. I think I go a little bit overboard with trying to save money, but that's what I need to do to survive. And I appreciate that all you Towel friends come in here and are like, well, Grant should survive. That warms my little towel heart. All right, we have to do our clip now. Oh, the frozen Cape Cod pizzas are so good. They have this kind of like bar-style pizza crust that's almost like, it borders on almost like a muffin. It has this very delectable kind of almost crumble-style crust. It's delectable. And the way that the heavy marinara sauce and the cheese and the oils blend together with the Cape Cod pizza crust, 10 out of 10. Ladies and gentlemen, I should do frozen pizza reviews. We should just send Towel frozen pizzas. I will eat them. Then I will tell you about them after lunch. Oh, yes, it will be absolutely wonderful. Okay, ladies and gentlemen, we have to do our clip. Hello, good afternoon. My name's GrantSmithEllis. It's coming up on 1 p.m. Eastern on day 11 of the presentation of testimony in the John O'Keefe and Karen Reed retrial. The Karen Reed and John O'Keefe retrial world, ladies and gentlemen, was just rocked by testimony from state expert Dr. Jessica Hyde, who confirmed that Jen McCabe's Google searches were done at 6:23 and 6:24 a.m. in the morning for How Long to Die in Cold, and further confirmed that Jen McCabe deleted nothing from her cell phone related to calls or texts, and that Jen McCabe deleted nothing from her cell phone related to those Google searches. And, ladies and gentlemen, the pinnacle moment that we'll watch right now was when Dr. Jessica Hyde explained how it is a common error for Dr. Hyde's students at George Mason University, where she teaches high-level courses on data cell phone analysis, cell phone data analysis and forensic extrapolation. For those students to make the error that Karen Reed's expert, Stumble and Mumble and Richard Green, made as to a write-ahead file in the WallDB log for Jen McCabe's phone, and how those 6:23 and 6:24 a.m. searches, because of Richard Green's misinterpretation, were read with a timestamp for months by Green that was incorrect. Ladies and gentlemen, let's listen to the moment. It was amazing. The Towel Friends celebrated, and over on youtube.com/GrantSmithEllis, we broke a simultaneous Towel stream viewer record. The Towel Friends began celebrating wildly, and today Alan Jackson hasn't even mistoweled any paper towels. It is a glorious day. Let us watch the testimony from Dr. Jessica Hyde. I queued this up in particular.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, How Long to Die in the Cold, and seeing the 2:27 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 2:27 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded, or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as How Long to Die in the Cold with a timestamp of 2:27. Is it 2:27:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
You heard it, ladies and gentlemen. Jen McCabe, after Ian Whiffen, the foremost Celebrate expert and a coder within the company, already confirmed the 6:23 and 6:24 a.m. Google search timestamps for How Long to Die in Cold. Dr. Jessica Hyde, an independent expert with even better academic qualifications than Mr. Whiffen, arguably, comes in, multidisciplinary expert on multiple programs that interface with Celebrate, and confirms the Google search at 6:23 and 6:24 a.m. Karen Reed's expert, Stumbling Mumbling Richard Green, the man with the arrest history for filing a false police report and simple battery. Ladies and gentlemen, he is discredited before he even takes the stand. The jurors were hanging on every word of Dr. Hyde's testimony. She was smiling, and Dr. Hyde was smiling at the jurors as she explained the complex nature of how Richard Green got the Wall DB file interpretation, the write-ahead log, so wrong. My name's GrantSmithEllis. We'll be back. Hank Brennan has finished his directive, Dr. Hyde, as of 12:50 p.m. Eastern on May 7, 2025. We'll be back at 1:35 p.m. Eastern, just roughly under 30 minutes from now, to watch Bob Alessi flail around. Karen Reed's defense tried so hard to try to undermine Dr. Hyde. Objections, last-minute motions, all of them overruled. Dr. Hyde is brilliant. The Karen Reed defense is concerned about the impact of this devastating testimony, and the towel stream perseveres. Ladies and gentlemen, come join us, youtube.com/@GrantSmithEllis. Chat with us for lunch. See me talk about all sorts of interesting things, and watch the flannels, the soap dispensers, the towelettes, the washcloths, the beach towels, the wonderful paper towels, the hemp towels, the microfiber towels, every type of towel you can imagine gathered together to talk with each other, to befriend each other, to show simple acts of kindness are possible in a world defined by self-interest and greed. And yes, to celebrate the towel stream on YouTube breaking a new record, and Towel getting to over 800 subscribers. Yes, Towel stream perseveres. The Karen Cam is here, and we'll be back into session in just a few minutes. What do you think, ladies and gentlemen? What do you think? She's allowed to be on her phone, the defendant. I'm pretty sure it was negotiated by compromise. Yep, ladies and gentlemen, Karen Reed is allowed to be on her phone. All right, now, here we go, ladies and gentlemen. Let's take a look. Lunchtime, John O'Keefe and Karen Reed retrial update, day 11. The Reed retrial is on lunch break until 1:35 p.m. Eastern, and Karen's defense team has been decimated by state expert Dr. Jessica Hyde. Watch the moment Hyde confirmed Jen McCabe's 6:23 and 6:24 a.m. Google searches. Then watch Dr. Hyde tell jurors that anyone who would have misunderstood a Wall DB file write ahead log, such as to think that those searches occurred earlier in the night, would have not passed Dr. Hyde's class on cell phone forensic analysis at George Mason. Oh my word, ladies and gentlemen, this is exactly the error that was made by Reed's expert Richard Green, a man with an arrest history for simple battery and filing false police reports. And Green is discredited before even taking the stand. If Reed even chooses to call Green for the retrial. Oh my word, ladies and gentlemen, what a terrible, terrible day. Karen Reed's horrible, no good, very bad day continues. The weather is not pleasant. The Karen Reed supporters are down to 4 people. Ladies and gentlemen, I have an image from JLR reports that I found on social media that I will show you in a second. It shows the Karen Reed supporters down to just 4 people. Oh my word. Ladies and gentlemen, what a confirmed the time of Jen McCabe, sir. And also confirmed that none of those searches were ever deleted. Oh, ladies and gentlemen, it was quite a moment. Here we go. All right, I got everything all written up, ladies and gentlemen. Ladies and gentlemen. Ladies and gentlemen. Wow, what a tactical performance by Hank Brennan. Bob Alessi was just completely flustered. He could do nothing. Ladies and gentlemen, Bob Alessi could do nothing. He could only sit there and watch Hank Brennan with question after question win on each objection Alessi tried to make, and then continue to deliver devastating testimony to jurors about the timing at 6:23 and 6:24 a.m. of Jen McCabe's Google search. Okay, ladies and gentlemen, Little Towels, we have more catching up to do. We have more catching up to do indeed. I think there are other things we can watch. Let's see. What is it that we want to get caught up on? We obviously... Oh, that's what we want to see. Ladies and gentlemen, let's take a look. Oh, Roberta Glass's wonderful crime cricket. I appreciate you sharing your positive words for Roberta. God bless Roberta and all of her support for Lindsay Gattani that she's engaged over the past few months. Roberta was truly one of those voices out there saying Lindsay Gattani deserves justice. Ladies and gentlemen, look at this. This is the report. Only 4 Karen Reed supporters outside of court, maybe 6 on day 11. That means last Friday there was 11 people. Monday there were 0, at least when CPU Tom arrived. Tuesday there were just maybe 4 to 5, and now there's 6. This is the Free Karen Reed movement, ladies and gentlemen. This is all that is left of the Free Karen Reed movement. Look at it on your screens. Watch it. Drink it in. I swear you'll never see anything like this ever again. Just magisterial, the collapse. It is like a man going to kick a soccer ball into an empty net and somehow missing. Yes, ladies and gentlemen, someone asked earlier, Towel, do you need special permission? Yes, only limited people have court approval to stream the Karen Cam. And if the other networks don't take it, that means Towel's one of the only people broadcasting it, and it is a glorious Karen Cam. Ladies and gentlemen, we are the Justice Movement, the Towels for Justice Movement. Look at Free Karen Reed. There are more people in the Towel chat per 5 seconds than there were supporting Karen Reed before court this morning. Ladies and gentlemen, that's what it's come down to. That is what it has come down to. All right, let's do the update. Hold on, I must post the first update. I must post it, ladies and gentlemen. Oh, I see. I see. Watch the moment. Below that Hyde, Dr. Hyde confirmed the time. Then later in the same clip, oh, ladies and gentlemen, Towel had to do some updates. I will come back to you. Oh no, what was it that we were going to do an update? Oh yes, I was going to do a clip about the Karen Reed supporters. Yes. Yeah, no, I would not say the defense actually misinterpreted the case. Dr. Hyde was never found to be not reliable, and the reason it didn't come in is because they looked so dumb making that last-minute argument. Of course, Turtle Boy would literally spin the sky yellow if Karen said to him, "Turtle Boy, jump," and Turtle Boy said, "How high?" and Karen said, "Until the sky turns yellow." Turtle Boy would actually tell people the sky was yellow. Yep. Very embarrassing moments for Karen Reed's expert, Richard Green, who hasn't even taken the stand yet. Yep. Ladies and gentlemen, it is coming past 1:15 p.m. now. We are just 15 minutes away from coming back into session in the John O'Keefe and Karen Reed trial. We have been going for 6 hours on Towel Stream. Oh my word. No wonder you all were sending unprompted towel donations. We didn't even do the last two public service reminders. We don't really have to do it. Someone was trying to troll me earlier and saying that having a public information service and asking for support or thanking towel supporters is some form of begging. It's not. PBS, the BBC, they are user-supported public information services. That I don't run ads right now, but I would if 7-Eleven wants to sponsor me and have me talk about their pizza, which I eat anyway. But ladies and gentlemen, this is a user-supported public information service. Those contributions, like from the wonderful Allie and Bill and all the other towel friends earlier, those, ladies and gentlemen, from Dewdrops and so many towel supporters, those are what keep this public information service going. And you can see we're having an impact, ladies and gentlemen, when the trolls come into this chat and try to tell us, no, you don't support Grant. He's not building a public information service. That, ladies and gentlemen, shows you we are having a real impact. So God bless you all. But remember, there are more ways than just sending towel super chats, being super towels, or otherwise to support this stream. Yes, you see the reminders from Dewdrops and Alex and all the other towel friends. You can like this channel. You can this stream while it's live. You can subscribe to Towel Channel. Apparently doing both of those things is very helpful while the video is live. I don't know why. It is what I have been told. So consider doing that for Little Towel. That's amazing. Also, listen, as much as Little Towel would love your support, there are other ways you can show your support, ladies and gentlemen. You can go out and do simple acts of service for others around you. You can, like Francis Frutrell, the wonderful honorary towel, donate 200 tomato plants to someone who then, and in turn, the tomato plants will get dubbed honorary towels. You can visit a family member. You can donate to homeless veterans. Anything you do, simple act of service, big act of kindness, or just demonstrating unconditional and love and toleration, anything you do is something that warms this Little Towel's heart in that way, as long as it is done to uplift others and in the service of a noble end. That makes Towel truly happy. If you've learned anything from this stream, if you've become a more informed and erudite member of the wider public society, then the best way you can pay it forward is go forth and spread that message of unconditional love, compassion, and toleration rooted in small acts of service, and let 6 degrees of authentic separation, not defined by Chewbacca, but instead defined by small acts of service, come to define the transition to a new digital-based epoch. And let the history books look back and say, that digital age came in the metaphorical form of an Aquarius water bearer holding a towel. Thank you, ladies and gentlemen, for allowing me to preach and extol the virtues of Towel's public information service. Oh, Alex, we'll get there soon enough. There's some number, I think we're at the watch hours, but there's some number of subscribers you need for ads. Maybe I will turn them on when we get there every, 15 minutes. What do you want to do? Every 30 minutes? We'll figure it out. I don't even have the ability yet. We need more Towel subscribers. I think it's like 1,000 or 2,000 subscribers. We'll get there, Towel friends. I know with your support, Towel Channel will eventually continue to grow strong. Maybe I will even be able to take someone to Europe not metaphorically, which is my life goal. I just want to take someone to Europe. That's all I want to do. That's not true. There's lots of things I want to do, but Norman Towel is one place I want to visit. Don't tell the French we're coming. They will prevent me from going into northern France. They will see the peaceful revolution coming. Yes, ladies and gentlemen, just about 10 minutes to go. We see there's only 6 Karen Read supporters. It is just a devastating day. Karen is not going to be pleased. But, ladies and gentlemen, I don't know if you saw the news. If Alan Jackson calls the Stay Puft Marshmallow Man to the stand, look, ladies and gentlemen, his lawyer is Chewbacca. Our venerated reporter Towel Christina has let us know about this. And also, ladies and gentlemen, we have another update from Christina, the venerated reporter Towel Christina. And you know, when Christina sends us a Towel update, ladies and gentlemen, you don't want to miss this. I am hearing this might involve David Yianetti's spaghetti. Ladies and gentlemen, we might actually get to see David Yianetti's infamous spaghetti. I have heard from reporter Towel Christina, who is on some kind of scene. I don't know how she got into an environment where she was able to find David Yianetti's spaghetti, but this is truly not quite a breaking news moment, but it is a Towel update. Now, apparently, there might, oh no, ladies and gentlemen, I have terrible news. It's not just that David Yianetti's spaghetti is out and about. It is that the Chewbacca and Stay Puft Marshmallow Man have been caught in a web of spaghetti. Oh, goodness. This is just horrible. Ladies and gentlemen, for those of you who followed this stream, along with our reminders to be compassionate and kind to each other, we also need to show, ladies and gentlemen, our moment of levity, which is going to include a horrifying, I don't even know what to say about this, Christina. How did you get this picture, first of all? Second of all, how did David Yianetti get actual spaghetti into the courtroom? Third of all, why is the Karen Read defense using spaghetti as a trap to capture the Stay Puft Marshmallow Man and Chewbacca? Now listen to me. I have seen a lot of ridiculous things while covering this trial. I have never seen the Karen Read defense resort to deploying literal spaghetti on the courtroom floor in order to capture the Stay Puft Marshmallow Man and his lawyer, Chewbacca, who is actually a dog named Chloe in a wig. Now, I tell you, ladies and gentlemen, I am declaring a writ of shenanigans. Somebody get the brooms. I can't take it anymore. This is absolutely my breaking point. The second I saw David Yianetti deployed actual spaghetti to capture and entrap the Stay Puft Marshmallow Man, that is how he got him on the stand. This is outrageous. Absolutely outrageous, ladies and gentlemen. I am incredulous. First of all, we need to revisit this for a second. Unless it's polenta, okay? You can't, and first of all, there's not even a table, but you can't serve pasta on the floor. What is wrong with you, David Yianetti? Second of all, imagine how my dear God, imagine how the Italians would feel, David Yianetti, if they saw you using spaghetti as some kind of legal bear trap to capture a marshmallow man. Oh, my dear God. Absolutely right, Scorpion Unicorn. Nothing about this makes sense. Nothing about it. It is completely nonsensical. Somebody tell Thomas Paine. I'm determining whether that needs to. Maybe I can clip that later today. I don't think we need to do another clip about. All right, fine. Okay, fine. Hold on. Ladies and gentlemen, my name's GrantSmithEllis. We are just a few minutes away from the 1:35 p.m. return to session in the Karen Read and John O'Keefe trial. Listen, I didn't want to break in with another important update. I thought that doing the confirmation of Jen McCabe's 6:23 and 6:24 a.m. Google search via a summary of witness Dr. Jessica Hyde's excellent testimony on direct from Hank Brennan before lunch was good enough. But no, ladies and gentlemen, reporter towel, the honorary reporter towel Christina, who is not Christina Rex from WBZ, but just a woman named Christina who's an honorary towel, has gotten exclusive pictures from within, related to an update that towel friends have been following closely. Yes, ladies and gentlemen, as we wait to come back in from lunch, Christina has informed us that David Yianetti has deployed a spaghetti-based trap to capture the Stay Puft Marshmallow Man, who is represented in court, mind you, ladies and gentlemen. I am not kidding you. Represented in court by none other than Chewbacca, who is actually a dog named Chloe in a wig pretending to be Chewbacca, to prevent Alan Jackson from using the Rule 17 process to undermine and attack the credibility of the Stay Puft Marshmallow Man. But ladies and gentlemen, it gets worse. It gets worse. David Yianetti, instead of using a table like polenta demands, just put spaghetti on the floor of the courtroom to capture the Stay Puft Marshmallow Man. And yes, ladies and gentlemen, this is all happening in real time. Reporter Towel Christina is on it. Join us for the return to session at 1:35 p.m. Eastern, and maybe you too will get to see a 200-foot-tall Stay Puft Marshmallow Man entrapped within David Yianetti's spaghetti on the courthouse floor in an absolutely absurd situation that, yes, I tell you right now, ladies and gentlemen, makes no sense whatsoever. My name is GrantSmithEllis. We'll be with you until the top of the bottom of the hour, which is not how you say 1:35 p.m., but that is okay. You all figured out where I was going. Join the towel stream, chat with the towel friends, and figure out what the hell this all means. YouTube.com/@GrantSmithEllis. Towel friends, that was a pretty good clip. I didn't even finish the clip. Bye, clip. Now I finished the clip. We're back, towel friends. We're back. We're back. We did it twice. I personally thought the first version of the ridiculous David Yianetti Spaghetti, let's call him David Spaghetti. David Yianetti Spaghetti image. I thought it was okay. The first one was better. The second one was okay. It just is what it is. Now, how do we even write this up? I don't know how to write this up. Let's do it together. Okay, we'll talk this through. So, ladies and gentlemen, I don't know how to explain this, but as we await the 1:35 p.m. Eastern return to session in the John O'Keefe and Karen Reed retrial, reporter towel Christina, who is not Christina Rex, sent this image of David Yianetti capturing Chewbacca and a marshmallow man with spaghetti. It is unclear if Italy intends to invade Boston in retaliation. I will reach out to the consulate for further information. You can't just insult pasta like that. First of all, as I said earlier, even if you're going to do that, you have to literally put the pasta on a table. Even if it's polenta, you can't just put it on the floor. Absolutely outrageous. Ladies and gentlemen, this is the kind of erudite legal commentary you come to Towel Stream for. Yes, I know it. You know it. The world knows it. There is nothing anyone can tell us that will make us act differently. Watch live as we return from lunch in the next few minutes. Chat with the towel friends and see exclusive Karen Cam coverage here. I don't know how to explain this, but spaghetti. I'm not going to say I don't know how to explain this. I'm just going to deadpan it. As we I spelled spaghetti very wrong. Ladies and gentlemen, I need a lot of help spelling the word spaghetti. It has a lot of H's. It has a lot of I's and T's. I figured it out. I managed to figure it out. Spaghetti. That is very counterintuitive. Why would you oh, it's Italian. That's why. Those damn Romance languages. There we go. I figured it out. All right, ladies and gentlemen, I am pleased to announce that we have managed to tell the world about Christina's excellent insight, reporter towel Christina, the honorary towel herself, about the spaghetti. It's gone out to the world. You all enjoy that. There are going to be people who are going to say, I saw your name in a clip about a man talking about Chewbacca, the Stay Puft Marshmallow Man, and spaghetti. What is going on with you? Are you okay? And you are going to have to say, yes, things are just fine. I just happen to enjoy coverage of trials that invoke spaghetti, the Stay Puft Marshmallow Man, and Chewbacca. The person in response will probably say, okay, I'm starting to think that you are not okay, and you will have to then gaslight them and say, there are hundreds and maybe thousands of people that join into this very important analysis of Chewbacca, the Stay Puft Marshmallow Man, and David Yanetti's spaghetti. And then you'll make that person feel like they're insane, and then the whole thing will just go off the rails. Yes, ladies and gentlemen, I have thought this through extensively. So, if you do get approached asking you why your name appeared in a stream related to the Stay Puft Marshmallow Man, Chewbacca, and David Yanetti's spaghetti, you have a ready-made answer. Now, let us do one more thing. Ladies and gentlemen, we should be coming back into session in the next 5 minutes. Oh, thank you, Allie. Not only am I hilarious, but I run on towel-based pizza calories, which makes things even better. Think about it. A man, a towel together combined that lives on bread, cheese, tomato sauce, Burger King, very plain foods, and only drinks water and Gatorade and Prime, and smokes a lot of cigars, but I'm switching to vaping now. I even got a new vape device that mimics a cigar and actually is a little healthier for me. Towel is moving in a good direction, ladies and gentlemen. By the way, people have asked, why do you use cannabis as medication? I'll tell you right now, it's because the other option is prednisone, and although this medication does cost me about $50 a month, maybe $100 a month at the dispensaries, which is a lot more than prednisone, the side effects are so much less compared to prednisone. Now, I can't extol the values of this for every person. You have to work with your doctor, but for me, it has literally allowed me to go from eating like 700 calories a day to eating 1,500 calories a day, and I can't tell you how much that means to me. But yes, ladies and gentlemen, here we go, keeping an eye on the return to session. My name is GrantSmithEllis. People call me sometimes, I suppose, Grant, Howard Cosell, David Attenborough, Taillight, some combination of those names. Some combination indeed. Yes, the dispensaries around here are getting cheaper. I can get 28 grams of towel medicine for $60 to $80 if I have my medical allotment. It can go up to $80 to $100 if I have to pay tax on adult use. Medical, there's no tax, but I can pay as low as $60 for 28 grams, and that lasts me 2 weeks, even more sometimes. So thankfully, the state of Massachusetts, at least with legalization, has made Towel's access to his medicine that keeps Towel from bleeding out that much easier. Towel also helped to write the adult and medical use laws in some sense, not in the original iterations, but I helped do their update. The Chapter 180 of the Acts of 2022, I actually created a grant fund for companies in the state that's seeded with or capitalized with a dedicated levy on the adult use excise tax. So about $30 million a year goes into small business reinvestment through the Executive Office of Economic Development. And then I've obviously helped codify the regulatory framework, 935 CMR 500,000, 935 CMR 500,001, all of which I have memorized. And that regulatory framework for adult adult and medical use cannabis, of course, in Massachusetts, has been developed over the past 6 to 8 years. And Towel's investigative reporting, which you can find on Facebook, Instagram, Patreon, LinkedIn, otherwise, will explain to you the pitfalls of a regulated market, at least from the perspective of consolidation and the subversive influence of large corporate players who then facilitate dangerous product getting to consumers because they buy off regulators and use influence peddling to facilitate regulatory capture, therein preventing adequate safety testing for total yeast and mold from being done and other things of that nature. Yes, ladies and gentlemen, Towel even brought about multiple governmental investigations, including potentially a federal probe of the CCC, investigations by the Office of the State Inspector General, by the auditor, etc. Towel is a political force in some regard. But yes, I'm glad we got to talk about that a little bit. I think some of you Towel friends don't even know about all the work that I've been doing in that intergovernmental sector with regards to the oversight apparatus of the adult and medical use industry in the Commonwealth. But that is indeed what I have done. Oh, thank you. I do my best. I'm just trying to get us back into session here, folks. It should be any minute now. I am a little adorable Towel. And the best thing is, I don't even think I understand what I know. I just think everyone everywhere has the ability to know all of this without notes at all the time. And I get utterly baffled when people are like, Grant, I cannot possibly remember. Okay, folks, we're not back in session yet. Stay with little Towel. Stay with little Towel. I am waiting for the Karen Cam to return. I get up at 7:30 a.m. I can sit. What's bad for Towel's health is too much walking, too much standing, lifting things, physical things. Towel's physical vessel is not doing well, but Towel's brain is still persevering. And as long as I can make a record of that brain and the information therefrom and transfer that information to the public sphere and empower you all, don't follow me. Take my information, use it to inform yourself. Take the information I'm giving you to approach any number of topics in a more informed way. Assert your autonomy in the face of systemic oppression and powerful forces that folks cannot even understand. Do so by becoming informed consumers of information that will protect our republic and protect our democracy, and that is the legacy of service I wish to leave. So in that sense, it doesn't feel like I'm doing anything. I am just being a Towel and going where I am called, and in some sense that has been working out okay for little Towel. Oh, thank you, Ange. God bless you. Oh, P. McKinley, you're terminally ill. Oh, God bless you, my dear friend. Medical cannabis is helpful. I'm so sorry to hear. I will make a mental note, dear Towel friend, and you reach out to me on any time via on X or on any platform where you can find me. And if I don't see your message, remind me in the chat. If you ever want to talk, anything, you just let me know and I'll do it in an instant, dear friend. If we can help you in any way, if you ever need anything, you just tell us in Towel chat, okay, P. McKinley, and we will help you in any way that we can. Please let us know. Oh, God bless you, dear friend. Oh. Ladies and gentlemen, we're waiting for court to come back into session. It is just past 1:35 p.m. And yes, Towel friends, please send your prayers and good thoughts to P. McKinley. Hopefully P. McKinley will come back into our chats more often, and I hope we all continue to extend to them a very warm Towel welcome and keep them in our thoughts and prayers at all times. H, that's such a kind thing. I don't know what the Isambard Kingdom Brunel of YouTube commentators is, but I will research it later. And I must say there's nothing I enjoy more, H, than learning new things. So you have presented to me something that just baffles me, and that makes me very happy. Oh, goodness, ladies and gentlemen, we will be returning any moment now to session. Oh, Jew Drops, God bless you, dear friend. Your super stickers always warm my Towel heart. I always see the little dancing bird or the dancing sticker. It's kind of like a leaf man, I suppose. And I say, or a leaf person, that is adorable. Oh, God bless all of you towel friends. We're just waiting now for the return to session. It's a little bit past 1:35. Oh, ladies and gentlemen, we're about to come into session. I made it happen. I'm a towel. All right, we're going to the Karen Cam stream. I will see you at the next break, ladies and gentlemen. You know how much I love all you towel friends. Let's watch Bob Alessi do this cross. Let's get through this together. Continue to love each other. Be compassionate, friendly, and tolerant towels, and let's make the world a better place. One towel, one washcloth, one towelette, one beach towel, one flannel, one soap dispenser, one paper towel especially, one hemp towel, one microfiber towel at a time. God bless all of you, and I'll see you at the next break, even though I'm going to continue talking to you as I transition to the Karen Cam. So stay with me, ladies and gentlemen. There we are. Look how quickly that happened. I will now prepare the Karen Cam for you, and I will make sure that we don't get that annoying double audio ahead of time. Yes, ladies and gentlemen, I am your towel producer. I somehow managed to do all of this at once, and I'm honored that you choose to join us here and watch on Towel Stream. Now, as you can see, ladies and gentlemen, we are just waiting. Oh, hi, Anjanette. I know her. She's wonderful. I think Anjanette Levy and Julie Grant are the epitome of national TV coverage in the context of ongoing criminal cases. Towel has nothing but enduring respect for Anjanette Levy and Julie Grant. Hi, Anjanette. You are definitely an honorary towel. Yes, ladies and gentlemen, if you don't watch law and crimes coverage, in particular with Anjanette Levy, do so more often when you get the chance. They haven't been using a Karen Cam, but that's okay. Just know that Anjanette Levy is wonderful. There you go, folks, the fan. We are almost back in session. You know what that means. Ready your towels to peaceful arms. We are heading to Norman Towel. We shall plant the flag of the towel people, even though we have to deal with Bob Alessi's cross, so this isn't very exciting. Ladies and gentlemen, Norman Towel awaits. Do not fret. Do not fear. Towels to arms. Oh, thank you, Lisa Cox. Towels to peaceful arms, because we have to invade northern France peacefully. But yes, ladies and gentlemen, God bless all of you. Eva asked, did you have any idea how many towels we've waiting in exile for the main towel? I hope no towels are in exile. If there are towels in exile that shouldn't be, you let me know, Eva. All right, ladies and gentlemen, we're waiting for court to come back into session. The Karen Cam has not yet returned. I don't think there's any sound in the feed yet either. We eagerly wait and watch. Yes, ladies and gentlemen, all of the towels sit with bated breath, knowing they are going to have to listen to Bob Alessi. Oh, no, not Bob Alessi. Anything but Bob Alessi. Why are you zooming in on those two random people? That is David Bienick from Channel 5. Oh, they're doing color adjustment. That's hilarious. Ladies and gentlemen, my name is GrantSmithEllis. We're almost coming back into session. All we need, it should be starting soon. Folks, ready your towels. Ready your towels. I believe we should be coming into session in the next few seconds. Yes, ready your towels. It is going to be Bob Alessi doing Bob Alessi things, and we will be doing towel things. I may have spoken too soon. I may have spoken too soon. And yes, ladies and gentlemen, I must say we are just waiting. We are just waiting for court to come back into session, and unfortunately the Karen Cam is not on just yet. But we will know that the jurors have returned, that we are ready to go when the Karen Cam turns on. Oh, ladies and gentlemen, praise the Lord and Lord of Towels. Well, that might be sacrilegious to some extent, but okay, praise the towels, praise the Lord. As long as you don't call towels the Lord, we're okay. That could be idolatrous. Yes, ladies and gentlemen, we are waiting for court to come back into session. We are waiting, watching patiently. The court cam has not turned on. The Karen cam is on, ladies and gentlemen. Get ready to come back into session. My name is GrantSmithEllis. Ladies and gentlemen.
You are unmuted.
All right, jurors. As you know, I think I told you in the beginning, one of my functions is to make sure that a case is tried fairly and efficiently and not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I am, but if I seem to cut somebody short, the lawyers are just doing their job. When they request sidebar conferences, they're just doing their job. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing their job. Okay. All right, go ahead, Mr. Alessi, and call in a witness.
I just need a witness. Yes. Certainly.
Good afternoon.
Afternoon, Your Honor.
May I, Your Honor?
Yes.
Good afternoon, Ms. Hyde.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
I do. It's the first one. I apologize. This is the one, I believe it's May. I don't remember the date off the top of my head.
May of 2023,
May
perhaps?
of 2023, obviously. Yep. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20, yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified as Ms. McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that, quote, friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that frequent. I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records, and I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution. That's correct.
And the prosecution is paying you for your services in this case, is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
Page 15?
Page 15, 1529.
The report is.
Would you like the
50
page of the report or the page NDA number at the bottom? I can do either way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's NDAO 1529
Yes.
or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading Interactive Phone Activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that. I'm just trying to move it along, but I will be slower. I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And that if you skip down, I'm going to skip a couple sentences to the paragraph under the chart. This is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? Mm-hmm. You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct? I object.
Can you answer that? Ms. Hyde, can you answer that, yes or no?
Did I read that correctly?
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39.
Okay.
And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last, of an indication of interaction with the device, don't you think it would have been appropriate to look at that 123209 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is...
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report, so I cannot speak to that without going back and reviewing that evidence.
Isn't the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you. If you could please turn to, in the same report, page 1528, which is your page number 6. And I just want you, please, to go to the, just put a placeholder in that. And if you can now just go to the conclusion, which is your page 50. Let me know when you're there.
I am there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing, text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis?
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Can you give me my page number, please?
I will.
Okay, thank you.
You're welcome. If you could turn to your page 13.
13, Roger. Yes, I'm there.
And do you see an entry that says 12:31:56 which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Hold on. I'm sorry. I need to ask the
apologize.
questions. I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps, and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
yes.
But the sentence reads, includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were stating?
Well, I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from your report, correct?
Your interpretation that 12:32 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's not,
if I could just finish,
please,
because
absolutely,
if we
sorry.
talk over each other, the stenographer's not going to get both of us. Thank
Agreed.
you. So it's not my theory. It's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which, just doing the simple math, is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not debating that.
Thank you very much. So now what I'd like to do is to go to page 1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number, so I center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when you're there.
I'm there.
If you could please go to Apple Health Data Steps.
Mm-hmm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better?
Sure.
That 191.253 seconds equals 3.2 minutes?
Approximately, yes.
Approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022 for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is, for your reports, you don't date your reports, so I can't give you a date, but it says...
It's report 3, I believe, is what
exactly.
You're looking at.
It's 3. And there is... Bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7. And let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page
Absolutely.
for that time?
And
I do see an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no. Is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently, let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
yes.
Mr.
Okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8/59/34. That's correct?
Yes.
All righty. Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp and you would find that parlance acceptable?
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023, that is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in
Correct.
May of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right, and you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case, that
and
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 22740. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going
was
to test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X-Browser State DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words that Google search, "house long to die in cold," was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings.
Mm-hmm.
It starts with there were 2 searches of interest that took place on the iOS device, and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's,
That's
yes.
identified to you as Jennifer McCabe. And it's what you talked about on direct examination as
Absolutely,
her device, right?
yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe's.
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
Do you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I have been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those 2 search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right, and I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those 2 timestamps.
Right, so we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so we
Eastern time for clarity, because some of these records are in UTC, some are in local.
Fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly, and that's what we're talking about.
Okay,
we're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the time stamp format there, but that is the UTC time. The UTC time equivalent in Eastern Local Time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next
correct.
to it, did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern Time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern Time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have 2 additional times in addition to the 2 times, 2 different numbers added to the 2, correct?
The UTC was a typo. It should say UTC next to those, and the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So, in terms of your May 2023 report, your first report in this matter.
Yes.
You, on page 5, in the sentence underneath the block paragraph, state, in the instance of the Google search, house long to die in cold that was recovered from the right-ahead log associated with.
That's correct.
The X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report. Up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report?
Yes.
Okay, so now what I'd like to do is to go on to the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
I am now going to go to that testimony, and if at any point you would like to have a copy of that, if it's the honor, if Your Honor would like, I will do it, but I'm going to start and then we'll see how it goes. So, bear with me a moment. Do you recall in that testimony stating that you processed the image in several forensic tools? I used Celebrite Physical Analyzer, and then you list many other tools. Do you remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan. I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12.
Thank you.
You're welcome. So, do you recall giving testimony about the various tools you used for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard. Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I spoke to the tools I used.
May I approach, Your Honor?
Yes, Mr. Alessi, you offered a transcript. Do you have the whole
I
transcript?
have the whole transcript if that helps.
It might speed things along.
Agreed.
Okay.
We have one. I'll provide it to Ms. Hyde. I'm going to give you a transcript.
Thank you. I appreciate it.
So, may I approach, Your Honor?
Yes.
Thank you.
Mr. Brennan? Transcript. 112. You are. That's, let me turn it over to you. It's going to be 112.
Okay.
Got it? You're welcome.
Thank you so much. And you said we're on 112?
Yes, please.
113, I see it. I see it's highlighted on the copy, so I
Right,
figured
so
that's the
what I
one.
wanted to do, the reason I said 112 is that's where I started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding, so it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did, that's correct.
And then going up to page 114, line 5.
Slow down a little bit, Mr. Alessi.
I will, Your Honor, thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now if we can go to page 124 of the very same testimony. And feel free to go back a page just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with how long to die in cold.
Can I have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123, 13, but if you need to go back further, feel free.
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your testimony. On line 16, I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that correctly?
Yes.
And that's associated with the Google search, how long to die in cold, in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now if you turn the page of the testimony, you state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read that correctly?
You did.
Not one thing, you said it could be lots of things, correct?
That is correct.
And then you go on in line 10, and you talk more, and then you go down to the bottom. You go down to line 20, and you testified, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's specifically pertaining to that particular artifact that in Browser State DB that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going.
Mm-hmm.
If you go to page 129 of this transcript,
I'm there.
at the top,
Sure.
line 1, 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that time stamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now if we could turn to page 130 of your testimony.
I need to object.
Right. I'll see you both.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages. And bear with me, I think this may be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database, it was in the write-ahead log. And to Cellebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly.
So am I correct that here what you're stating is Cellebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
on
proceeding?
that date, that is correct,
Okay,
yes.
so I just wanted to establish that, and
Absolutely.
you were giving Cellebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that so Cellebrite and Magnet Axiom, and then you elaborate, both Cellebrite Physical Analyzer, which is a specific tool, right, of
Correct.
Cellebrite, and Magnet Axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read that
That is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur, that you use the words associated with a Safari Google search, house long to die in the cold?
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be great.
a different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. Alrighty, now let's leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have the chronology correct, Ms. Hyde?
That is correct.
So in December of 2024, just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 2:27:40 timestamp. And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a year and a half. Is that approximately from your May 23rd report?
Approximately.
Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite tools, Magnet Forensic Axiom showed up, that was removed by Celebrite, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it. Yeah.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director of forensics.
That is correct.
Still shows that timestamp,
yes.
Right?
Yes.
But Celebrite doesn't. In the automated
That is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct, yes.
However, in December of 2024, when you returned to analyze the 2:27:40 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says.
Mm-hmm.
So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term house long to die in cold, and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's
that's a fair statement. That's a fair statement. Let me rephrase it this way. You're welcome. In this report, you speak about Celebrite release reports, correct?
Are you referring to the Celebrite release notes that come out?
The release notes at the bottom, right? You referred to that?
That's correct.
And that release note states that Celebrite has removed the timestamp value from records, and I'm assuming that's a reference to Celebrite.
Celebrite no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
And I'm going to go down, all the way down to the conclusion. In that report, is there reference to any company other than Celebrite in this entire report?
In this report, no.
Okay, thank you. Now let's go to your prior testimony in the first proceeding, where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now let's go back to the issue of the extraction of Jen McCabe's phone. And what I want to do is to cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry, can you please repeat?
Absolutely. No worries, sir. Are you familiar with the phrase Apple source codes?
Apple's source code? Absolutely, yes.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art, correct.
And they keep it so close that they call it closed source.
And it's not just Apple. Lots of tools are closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I refer to that as the MB postulate. It's a shorthanded, but I don't need to have you refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source codes that are closed sources. So I just refer to them as Apple's closed sources. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place the best place to go is to the Apple source codes themselves, or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, those are incongruent statements. Apple source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation, we don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever learned of, have you ever spoken with Mr. Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just
I have not had that conversation with Mr. Whiffen, no.
Okay, already. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer-reviewed his papers.
So you have regard for his reputation?
I have regard for his reputation.
Sorry, we have to wait for each other.
Oh,
to
yes,
talk
I'm sorry.
It's all right, no worries. So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely, yes.
And you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the History DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the History DB of either of those two searches.
So I want to just repeat that in a different way. So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
You spoke about PYF, PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, a tool one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document, yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained, the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear, I have not read all of Ian's reports. I've only read some, so I don't know if... I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
I just want to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF. I would need to see the report, especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree?
His statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history from the extraction of Jen McCabe's phone? It's yes or no.
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then when I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is the document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, But prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data. So we're going to have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is, and what make and model that device is, and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
please.
And I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device, so if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time, Nick? Yes. Thank you, Your Honor. So, bear with me, it's a big report, as you know.
It is a big report.
And it was at the bottom of my stack.
Pardon me?
All right, it was at the bottom of my stack. I had to lift up the other ones to find it. All right, so.
Your Honor, may I assist and point her to a page?
Sure. That'd be
Thank
great.
you. If you could turn to that report on your page 47 and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So, the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or Faraday box. Is that correct? By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct? Or
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed. But no, best practice would be to Faraday. I 100% agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yeah.
There is activity on this phone.
Absolutely.
Which shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box, and that failure is not best practice.
Correct. It is not in accordance with the best practices. I agree. I would have Faradayed it.
Thank you. So,
if I,
that's okay. I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
Let's redirect.
Thank you. Of course.
Whenever you're ready.
Thank you, Mr. Grimm.
You're welcome. You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023. May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023, what was the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you were to focus on?
I was to focus on the two search terms from January 29th, 2022.
And were you informed why? Was there any context to that?
Probably. I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No.
When you engaged in your analysis, was it independent of the District Attorney's Office?
My analysis was independent of the District Attorney's Office. I actually, in the first case, had very little communication with the District Attorney's Office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No.
Would you ever allow anybody to affect your input?
No.
throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes.
The report regarding report number 3, regarding changes to Celebrite software, was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the scope? I believe we're talking about report 2. That's the one about the Celebrate change?
Yes.
And I have the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
When you looked at the Celebrate software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrate actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Can I read Celebrate's own statement?
Please.
Celebrate's statement in...
To yourself.
To myself? Okay, roger that. Thank you. I appreciate that. Can you repeat the question?
With us, was there any reason other than the concern about misinterpreting or distorting?
They said that the...
Your Honor, they said?
So what's your understanding?
My understanding is that it is not a reliable timestamp, and that is why Celebrate removed it.
You were asked about Axiom. Axiom, is it the same or different?
Magnet Axiom and Celebrate Physical Analyzer are two different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrate before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended StateDB artifact as carved.
Do companies like Axiom and Celebrate give releases, updates, information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide, and that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release note. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred, based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have any information, or did you know the travel of Mr. O'Keefe's phone that night, or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from, say, 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag, so usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about History DB, and it was simply whether or not How's Long to Die in Cold, whether it appeared in History DB. That isolated question, does that provide any context for you and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that. But in this instance, we have both from the Mobile Safari PLIS, which tracks the history, as well as the Knowledge C DB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between the Knowledge C and the Mobile Safari PLIS.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone?
That is correct.
And you had an opportunity to look at the healthcare data for January 29, 2022.
That is correct.
Page 6 of your report.
Thank you.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps, it could be you're carrying it, it could be that you're in some other kind of motion, you could be on a bicycle, you could, any number of things. And the number of steps is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
For Ms.
Your Honor.
I'm going to deny that question.
Can these health steps occur if somebody's holding a phone while traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical, you could be in a vehicle, you could be on a bicycle. It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you on cross-examination, do you have information or opinion where Mr. O'Keefe's phone was located around 12:21:10 while those steps registered?
Objection, Your Honor. So,
That's beyond the scope of the cross.
it was pointed out to you at 12:21:10 there was a registered 80 steps. Is that accurate?
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that that began at 12:31:56 for 20 seconds?
That's correct, per the data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes.
That appears to be the last before the 6 a.m. hour.
So that 20 seconds, if it began at 12:31:56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at 12:31:56, what was the last second that evening that Mr. O'Keefe's phone moved?
12:32:16.
And then when you analyzed the phone and were asked about these times, is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29, 2022?
I do not know precisely what was happening with his phone at that time in terms of movement. If that's, or are you asking me? I'm sorry. Can you clarify what you mean
Yes.
by the question?
The next movement after 12:32
Is the 6:04.
6:04:01
Correct.
a.m.
Correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't. That wouldn't be inside my digital evidence, I don't believe.
And the last question is, the next movement at 6:15:14, do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person, it could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
Any follow-up, Mr.
Yes, please, Your Honor.
We have a moment, Your Honor.
Yes.
Excuse me, Mr. Right. I know.
Thank you.
Ms. Hyde, you were asked questions by Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes.
And did Celebrite, beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did it give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the...
Thank you. I appreciate it.
Yeah. And I'll repeat the question for you.
Thank you.
May I, Your Honor? Thank you. In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other
I'm sorry, my
but
question
not
is, do they
Celebrate?
state in the release note whether there's a reason for why they concluded?
May I look at the release note, ma'am? Thank you, ma'am. Thank you, Your Honor.
And please try not to talk.
I will,
Sorry, Your Honor.
Thank you.
2.
Not asking you to read it, just asking whether or not they give any reason for the conclusion, not a reliable timestamp.
One moment, I'd like to review what they wrote. Thank you.
Absolutely. You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there's further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the further research is.
that is correct. They
All right,
state
now
that
what I'd like
it's
to do is
unreliable.
Move on to Axiom. You were asked questions by Attorney Brennan, and you referred to Axiom as using a different parlance with the timestamp of carved, correct?
Celebrate uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrate does not. Is that correct? Is that correct?
Yes,
Okay.
currently, previously when we did the first case.
Right, but
it's the
currently,
opposite.
Celebrate
Correct.
doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover.
is the timestamp that they show for that artifact. Correct.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example of maybe needing to use a biometric to unlock a phone, and that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Sorry.
And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to...
Well, I don't know if at some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
Fair enough, but from 6:04 a.m. until approximately noon on January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
Right, but you're going past noon.
Right.
I'm not.
Okay.
My
yeah.
question,
6 a.m. to noon, it does not appear to be Faraday.
So to be clear, from 6:04 a.m. on January 29, 2022 until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But yeah, it does not appear to have been placed in Faraday bag.
All right.
No, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but 100%, it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to hopefully what are the last two categories of questions. With regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question, if the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto-deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto-deletions because I don't know what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs, and what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
Yeah. To boil it down, isn't it correct that that phone was moving at that time?
May I check the timestamp again?
Absolutely.
I apologize. There's a lot of timestamps going back and forth.
Please do.
12/31/56? Is that
that's the start. Yep.
Oh, yes, this one there definitely is. Yes, yes, yes.
So, doesn't matter what kind of movement, but that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022, correct?
Yes.
Thank you. Appreciate again your answering my questions.
Thank you.
All right, Ms. Hyde, you're all set.
Thank you, Your Honor.
All right, I see counsel about scheduling here. First, feel free to stand up and stretch.
Insurance offered them a mere $5,000 worth of Michigan makes it so simple. You can start a claim from your phone in just 8 clicks. That's it. It could all be done on your phone. So if you're injured, you can easily start a claim at forthepeople.com/LC Live by clicking the link below or scanning the QR code on screen. the link below or scanning the
Holy Mother, Jen McCain. Jen McCain, it's me or her. Either I'm going down, Jen, or you are.
Okay. All right. So, folks, I talked to the lawyers briefly about scheduling at Sidebar, and I'm told they're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this beautiful afternoon. So we're on schedule, ahead of schedule. We'll reevaluate that tomorrow, and I will see the lawyers at Sidebar as the jurors want about to talk a little bit about scheduling. Okay, same cautions, please. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And be very careful with your social media use. So see you tomorrow morning. Thank you.
All right.
Jen McCain. Holy Mother, Jen McCain. Jen McCain, it's me or her. Either I'm going down, Jen, or you are.
I should be back with you soon. Ladies and gentlemen, I'm back. I'm back. I'm back. We had a slight microphone issue. We had a slight microphone issue. It was not you, ladies and gentlemen. As we waited for the sidebar, we had a slight microphone issue. There we go. I've confirmed the audio is back. Yes, thank you. I was trying to figure out what was causing the issue. Ladies and gentlemen, you didn't miss anything. All I was doing was saying those were bombshell moments with Jen McCabe. The video played of Karen Reed saying it was her, Jen McCabe, played for jurors to end the day. Oh, my word, ladies and gentlemen. I'm so glad you all stuck around. We're waiting. Nothing has actually happened. If there were courtroom audio, you would have heard it. It was just a sidebar as Towel was posting about that last clip that went up. I apologize that I did not see the microphone get knocked. Yes, it was quite a moment. And ladies and gentlemen, if you're wondering, you have not actually missed anything. We are still at sidebar, and you might be saying that's an incredibly long sidebar. Yes, indeed it is, ladies and gentlemen. But I'm here, I'm monitoring with you. We don't know exactly what's going on. We don't know why the scheduling sidebar at the end of the day has taken so long, but I will stay with you, GrantSmithEllis, the little towel that I am, and we will monitor closely, ladies, gentlemen, fellow towels, to see what occurs. We're watching the O'Keefe family and the Reed family. Towel is still here. Well, it was actually very difficult. I think I will be able to put together Karen's reaction with the clip. It was a little bit difficult to actually get her reaction time with the clip, but I think if I play it back, we might be able to do it. Oh, ladies and gentlemen, it was difficult because the clip was so quick that jurors were already out of the room before the Karen cam came on. So, before the Karen cam, while the Karen cam was on, the clip was not yet playing on the main feed. So in order to do this, afterwards, we might be able to stitch together the video playing with when Karen watched the video. I think I have an idea as to how to do that, and we'll do it together in a few minutes. Oh, my word. Yes, we absolutely will replay the clip. As soon as we find out what happens at the end of the sidebar, ladies and gentlemen, we'll do our full day recap. Towel is now back with you. I didn't actually go anywhere because you didn't hear. I wasn't actually saying anything while my microphone was muted. I was watching the sidebar and typing up a post about the clip we just saw. But I have a plan. I did get the footage of the Karen cam before the clip played, and we can sync back Karen with the lights off watching the clip with the clip playing. I have an entire plan, ladies and gentlemen. I will put it together for you in real time. All right, we're going to get an update. All right, that's all we got, folks. Tomorrow morning. My name is GrantSmithEllis. Okay, let's do this together right now, little towels. First of all, let me come back up on your screen because my name is GrantSmithEllis and I'm a towel. There I am. There's the Chewbacca and the Stay Puft Marshmallow Man rolling around in David Yianetti spaghetti. That was quite a fun lunchtime update. Okay, so we have a few things to do. One, we are not going to look at that. We're going to do two things. All right, folks. Here's what we have to do. This is going to be a little bit of a convoluted experiment, but I think we are going to be able to do this. Okay, so here's what we have to do. We're going to go back to the moment on Towel Feed, I think, when the Karen Reed clip played, okay? And then what we're going to do is once that loads up, we are going to go back to the exact moment the clip played. First we have to capture, I have the clip already, but I have to actually record Karen's reaction during the playing of that video. And then what I'm going to do is stitch in real time. I'm going to show you all how to do this. I'm going to do real-time video editing and stitch together Karen's reaction with the actual video clip. Okay, you ready to do this? We are going to be very effective, towels. You are going to learn how to do video editing. I may have to turn off my camera to be able to actually give the computer enough processing power to do this, but we're going to do it, ladies and gentlemen. I have a towel plan. And let me just tell you, ladies and gentlemen, when Towel has a plan, Towel acts on that plan. So what we have to do is we have to go right to the end of the day, which was right before 3:30. Now, here's how we're going to do this, okay? First, we have to jump forward to the end of Dr. Jessica Hyde's testimony, which was devastating enough, okay? Then what we're going to do is we're going to watch the moment while Dr. Hyde walks out, when the Karen's reaction to the clip plays, okay? And then we are going to sync that with the clip itself. So when did that happen? Jessica Hyde was still on the stand there, so let's keep jumping forward. Okay, ready, folks? Ready? Okay, now watch what we're going to do here. Now, we have to be good little towels while we do this, okay? Towel's going to go off the screen for a second. Everybody be good little towels. We're doing video editing here, so we're not going to see any comments, okay? We're going to go to a new screen that's going to be black at first, okay? And then it's going to show up with the, actually, you know what? Let's do it this way. Going to grab this source. Stay with little towel. Stay with little towel. No, that's not the one I want. What is this? No, it is the one I want? Yeah, but that doesn't... All right, fine. But that isn't actually that, but okay. Here we go. Going to grab that source. Okay. I've copied it. We are going to go into a new window. Things are going to go black. I have not disappeared. I have not gone into the towel void. I still exist, ladies and gentlemen. Don't worry. Little towel is not gone. Okay, now give me 1 second here. I'm not gone. Ladies and gentlemen, do not panic. Do not panic. I repeat, I am still here. Now, watch what we're going to do here, okay? There we go. Ladies and gentlemen, that's the kind of beautiful thing I like to see. Now, watch this. We're going to have to make this full screen, okay? Now, once we've done that, we have to do one more thing, okay? We have to make this wide, all right? Now, we have to make it the exact size of the screen. Yep, okay, because it's all going to line up. And then we must, all right, now watch this, ladies and gentlemen. We have to get rid of that red bar, okay? And then we're going to record in real time, so Towel is not going to talk. Well, I guess I could just get rid of the audio. But we're going to record when the lights go off and Karen watches the clip, okay? So get ready, folks. My name's GrantSmithEllis. I can actually talk with you through this. But get ready. The lights are going to go off shortly. Okay, so here's where we're going to capture. Starting in 5, 4, 3, Now watch what we're going to do, friends. You asked to see something special. Little Towel is going to show you something special. So we didn't actually get to see Karen's reaction when the clip was played, right? But we have the clip of being played, right? Okay, and then we just got Karen's reaction. Now watch this, Little Towels. I am going to show you in a way that only Little Towel can how you sync those two things, because no matter what you do, the Zoom is always going to be early, okay, compared to the feed, the raw feed. But Little Towels, we have a backup plan for this, okay? As Towels, we know exactly what we are going to do. And I'm going to show you in real time on Towel Feed how we put things like this together. So the first thing we're going to do, Little Towels, is we're going to bring up the image of Kim Reed's expert Richard Green case report. Then we're going to give Little Towel a second while I come up on the screen. There we go. Okay, now watch this, Little Towels. I'm going to do two things for you. First, in order to give us a little more power on this process, I'm going to get rid of Little Towel. The second thing I'm going to do is, and I'm sure those of you who are technical whizzes, or if you enjoyed Dr. Jessica Hyde's presentation, you're going to find this more fascinating, because I'm going to show you how to do real-time video editing and show Karen's reaction to the clip of her saying it was her, Jen McCabe. We're going to see it together. We're going to render the clip. We're going to share it. And then we are going to say, Towel friends, we've learned something new today. Oh, Towel friends, there's nothing that makes me quite so happy as helping people learn new skills. It is truly Towel's vocation. So here's what we do, friends. We go over into the video editing program, all right? You see over on your screen, just a blank canvas. Yes, ladies and gentlemen. But then what do we do? Well, first of all, we're going to take this blank canvas of Karen's reaction to the clip being played. Now, we want to do two things. The first thing, actually, we want to do, ladies and gentlemen, is we want to get the actual clip of that we have, right? Not the Karen cam, the actual clip of the documentary. So watch. Tal's going to grab that clip. It's going to pop up on your screen. And now I know you all want to see it, so let's watch it together. But remember, we're only watching this to get the clip, okay? So we're going to do it like this. We're going to take this bottom part of the screen. We're going to drag that up, okay? We're going to leave it the exact same size as that window, right? Because we don't want to throw anything off. And then all we're going to do is, actually, let's leave it. Yeah, oh, that's going to make things a little difficult. But that's all right. I should be able to figure it out. And then like that. Okay, now we're going to leave that exactly how it is, ladies and gentlemen. And then let's watch the clip together because we have to do some editing. Let me make sure. Okay, here we go. Let me get this audio. Hold on.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Okay, now, ladies and gentlemen, fellow towels, first we have that, okay? Now, we need our second video, okay? Now, we need to actually do this clip because we only want the video. We want it to stop when the lights come back on, okay? So that, because we saw it happen, and then right there, and then the lights go on, right? No, when do the lights go on? No, not yet. So we'll stop it. So let's get the end of this here. Okay, now we'll go even shorter than that because, well, we want a little bit longer because we want to be able to see Karen's reaction. So there we go, all right? Now you wonder how long is that, right, folks? 21.1 seconds. Now, we also, this is where it gets a little complicated, okay? We also have the footage of Karen reacting on the Karen cam, right? So we're going to take that footage and watch this pop up right now, okay, folks? Boom. Now, the audio, the video isn't synced, right? That's a problem normally, right? No, because look what we're going to do. We're going to make that full screen, okay? We're going to send it to the back. So layer, send backwards, okay? Now we're going to take this little box here. We're going to make it a little bit larger because this is the magic of towel wood, okay? I'm not actually, well, we're all little towels. Now it's going to look a little weird with John's head, but we'll make that work, okay? And then we just do that, okay? Now watch this, ladies and gentlemen. See that clip now? Okay, now you see Karen over here. Now we click the Karen clip and we click extract audio, okay? Because we want to rip that audio out of the background. We only want the top audio playing of the Karen and Jen clip. Now the other problem is this Karen clip is 18.9 seconds, but we know that this clip is 21 seconds. So, 21.1. So we want to make sure, are we getting this clip right from the beginning? Karen's looking over it. Nope, there's actually a little bit of pause in this clip, right? So we have some time to cut off the front of that clip, okay? How much time? About 4.2 seconds, okay? So we actually want to reduce this front end here by 4.2 seconds, okay? Now when we watch this clip, maybe a little bit less. Let's see if we can get it to 18.1 exactly. Okay, now the two clips have the exact same length. We can even change that to 18.1, all right? Now watch the magic of film editing, friends. Watch the magic. We click this, okay? Now we click them together. We've extracted the base audio. Now watch.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Now, okay, it's almost perfect. Ladies and gentlemen, that is how you do it. Now, one thing we want to do here is I think Karen's reaction isn't really synced. So what we want to do is take this video, drag it a little bit forward. The only thing is I just wish there wasn't that, I wonder if I can just cut that end off here because we only need 18.1 seconds, okay? And then drag it a little bit further. You can see how hard this is, folks. I hope you have an appreciation for how difficult it is to do real-time video editing. All right, now let's watch. From the beginning, here's the clip. Little buffer. Perfect.
it's me or her. Either I'm going down, Jen, or you are.
No, it isn't as perfect as I wanted. Hold on. Hold on 1 second. Ladies and gentlemen, isn't it fascinating, though? Isn't it just fascinating? So this just needs to be a little bit, or you know what I guess we can do? What we'll do is we'll go to the underlying Karen clip, and we'll make that closer to like 16.1 seconds, okay? Because we'll wait for the actual clip to start. Let's go to 18.1. How about that? All right. And now that we're done with that, now this clip is 16.2, so let's make this 18.1. All right. Let's see here. You might be wondering, Towel, is this actually real-time video editing? And the answer is yes. It's actually this hard. We'll add a little bit to the front here. All right. How's that? All right, now let's see how it came out. We're the only people in the world who have this, so.
Totally more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Wow, there you go, ladies and gentlemen. I pretty much synced it up. Friends, towelettes, all of the friends who watched all of today's videos, I know that that was a lot of material to get through, and I know that folks wanted to see that clip of Karen reacting to the video from Jen McCabe. You just saw it before the rest of the world. I'm now going to generate that file. I'm going to download it, and towel friends, I will share it. Now, okay. Let's see. What I want to do, towel friends, is I want to do our wrap-up, because if you stayed this long, God bless you, towel friends. You know how much it means to me. In fact, some people are still tuning in, and they may want to find out what happened during today's Karen Reed and John O'Keefe retrial. Well, first of all, look, I'm back up on the screen. Second of all, did you all learn something from our video editing experiment? Isn't it fascinating to watch how you can put, yes, thanks, Dewdrops, I'm a towel. Oh, that was fun. I didn't know that people thought that that was some kind of useful skill. Little Towel just does that stuff on the fly. Doing it in front of all of you was a little weird, because like it kind of feels like showing you all like what's behind the curtain when you're doing film production. But who cares? You may as well learn how to do it. It's all a stage. Literally everything is fake. You can do things like that all the time. And I'm not saying it's fake in the sense that obviously those moments happen at the same time, but it would be impossible to get that synced up because the Zoom is ahead of the stream. So the only way to show Karen's reaction, first of all, we were the only one watching the Karen cam. You would have had to have been recording just the Karen cam for 20 seconds, as we did. Then you'd have to afterwards record the clip. Then you'd have to superimpose the clip on the segment of the Karen cam that synced up to the clip. And we did that. Oh, ladies and gentlemen, I'm so glad you all learned something. You have no idea how pleased it makes Little Towel that you all learned something. Now, should we do our summary for the day? Who wants to get in the clip? It's the day 11 recap. Let's do our summary. In order to do that recap, I think I should do something else first. First, let's actually do a post once this file downloads where Little Towel tells his towel friends about the synced video. It's done! Okay, towel friends, you want to see me actually write the post? No, I'll just type it on another screen. Okay, but either way, towel friends, let's get this post up. Here we go. Just now. For those who were asking to see Karen Reed's real-time reaction on the Karen cam to the shocking video played at the end of today's John O'Keefe and Karen Reed retrial, day 11. I have compiled the footage below. Karen said it was her, Jen McCabe. And jurors know. Oh, my word. Ladies and gentlemen, I'm uploading it now. You all were some of the first people in the entire world to get to see that clip come together. Little towels, we are learning. We are evolving to a higher state of towel consciousness. We are somehow going to become a world force based on towel production. I didn't think it was possible. I didn't think it could happen. But somehow we've all come together. Bill, you can be a soap dispenser. We have a flannel in the mix from Sheffield as well. Oh, Bill, by the way, we are all fans of Sheffield United, the greatest team in the English football pyramid in the late 1800s and early 1900s. Every single one of us are honorary Blades, and so therefore all of us are fans of the Sheffield United Football Club. Every single one of us. It is not an option, ladies and gentlemen. You must be a Sheffield United fan if you watch Towel Stream. It really makes Sheffield the Sheffield flannel very pleased. Yes, you can be an honorary washcloth. Absolutely, Marianne Nunzio. Okay, I put together the clip for the Towel Friends on YouTube, and you know what that means. That means we're ready to do our Day 11 Karen Reed and John O'Keefe trial summary. In order for us to actually do that, I think it is pertinent for Towel to go back a little bit on his feed and figure out what actually happened. Give Towel a second. Your comments will load up in a minute. Towel overloaded things a little bit there. But yes, day started with, what did it start with? Karen Reed tried to undermine Dr. Jessica Hyde before she even... That plan did not work. And we then went right into that testimony. Oh, yeah. The pieces of Taillight and Jew. Oh, ladies and gentlemen, it was an agonizing morning. Okay, let us begin. Let us begin, little towels. I shall do our overview. I will let you know when the clip begins, because therefore you will become part of the towel clip. Yes, here we go. All right, so let's get rid of that. 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 And here we go. All right, if you've never been there before, we do our daily recaps and all types of, then we say goodbye for the day. So everybody get ready. I'll tell you when the clip starts, and all your comments get highlighted. Towel loves all you Towel friends. We broke all sorts of records. We almost got to 300 Towel friends on YouTube. We had all kinds of support going around. The Towel friends are truly a wonderful, wonderful series of friends, and if you have not gotten to know them, if you're new here, don't forget to subscribe to the channel, like the video. We have been going for almost 9 hours. Little Towel is delirious. I'm pretty sure it's Wednesday. We'll get to Friday. Aiden Kearney isn't in the courtroom next week at all. Again, he's not on the media list or the backup list. Oh, ladies and gentlemen, we shall dine on the finest muffins and bagels in all of the land. Towel will go for another walk. It shall be a glorious Wednesday. Oh, H, you must keep us updated about the playoff involving Sheffield United. We will all be cheering for Sheffield United. I don't know how to do anything other than just say I hope they win the first leg of the playoff and obtain promotion in the football pyramid. Maybe all the Towel friends one day can be like that guy, Ryan Reynolds, who invested in that other club, and we will invest in Sheffield United, and they shall rise through the pyramid again and win the FA Cup, win the Champions League, win the whatever the other domestic cup is, and then capture some kind of quadruple and put Manchester City and the rest of the Prem to shame. Yes, ladies and gentlemen, I have thought this plan through extensively. Okay, we got to do our summary now. Here we go. Ladies and gentlemen, good afternoon. My name is GrantSmithEllis. It's just after 4 p.m. Today's Karen Reed trial wrapped up at 3 p.m. with an absolute bombshell. Ladies and gentlemen, if you did not see it in real time, it is how we will start the lead with today's Towel News at 4. And the Towel friends are here with us, ladies and gentlemen, watching along. Day 11 of testimony in the John O'Keefe and Karen Reed retrial, to put it lightly, was devastating for Karen Reed and her defense. This is the clip jurors were left going home with after hours of testimony confirming Jen McCabe's 6:23 and 6:24 a.m. Google search at Karen Reed's hands. Karen literally said to the news, now played for jurors, that it was going to be Karen or Jen. Karen definitely put out false information to try to throw Jen McCabe under the bus, and now jurors know. Let's watch the moment.
Either I'm going down, Jen, or you are.
Ladies and gentlemen, oh my word. You heard it from Karen Reed's own lips. Either I'm going down or you are. Karen Reed tried to throw Jen McCabe under the bus. Look at Karen's reaction to the clip, folks. Look at her head snap over to the juror, wants to side eye. Oh, it was devastating, folks. It was as devastating as possible. Now, ladies and gentlemen, we also had further developments in the Karen Reed and John O'Keefe case during the pendency of this afternoon's proceeding. We've even had a request to play this one more time. We're going to do it with your towels. The first time I've ever played a clip twice.
Totally more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Oh, devastating, ladies and gentlemen. Simply devastating. No other way to describe it. But that was all. The day started even worse for Karen Reed, folks. If you missed it, the day started with a state trooper from the Massachusetts State Police holding up John O'Keefe's shoe that was found on the morning of January 29, 2022. And we'll watch those moments now.
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag.
And ladies and gentlemen, it only got worse as then pieces of Karen's broken taillight found at the scene of John's death were held up for the jury.
Thank you, Trooper.
Oh, ladies and gentlemen, the moments did not get better for Karen Reed, as then we found out that Reed will not be calling her own, potentially not calling her own expert, stumbling, mumbling Richard Green, who it turns out has a police history of arrest for filing a false police report and simple battery. And then, ladies and gentlemen, we saw Karen Reed attempt to prevent Dr. Jessica Hyde at the last moment, another expert from cellular technology data expert, who confirmed Jen McCabe's Google search at 6:23 and 6:24 a.m. for how long to die in cold, and who confirmed John O'Keefe's phone never moved after 12:32 a.m. and 16 seconds on January 9, 2022. Ladies and gentlemen, Reed lost her attempt to have Jessica Hyde limited or banned or presented with nonsensical impeachment evidence. Listen to the ruling.
I appreciate the time. I appreciate people's patience. So, in reviewing the rules, I look at Rule 2. So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So
that was it, ladies and gentlemen. And no, there's no confusion at all among the jury, in my opinion. Jen McCabe Googled how long to die in cold at 6:23 and 6:24 a.m. A search at 2:27 for Hockomock Sports was entirely unrelated, and Dr. Jessica Hyde made it abundantly clear. And ladies and gentlemen, this was that moment. We will watch it right now. Here is the moment where Dr. Jessica Hyde confirmed that the Google searches were done at 6:23 and 6:24 a.m.
Digital forensics tools maybe support generously 1,000 applications.
All right, so this was her introduction. Here we go. Here we go. This was the confirmation of no deletions. Let's watch.
That's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the data set generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how's long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records.
So yes, ladies and gentlemen, not only was that the search at 6:23 and 6:24 a.m., there were no user deletions of any kind related to that search. You heard it from Dr. Jessica Hyde firsthand. And then, ladies and gentlemen, we came back from lunch break, and Bob Leslie absolutely got decimated. Oh, I do have the moment Dr. Jessica Hyde confirmed the 6:23 and 6:24 a.m. Google search. We can even watch that together because I recorded it before during lunch. Let's watch right now, ladies and gentlemen. I'm a towel. I queued this up in
Is
particular.
there any danger for an untrained eye to rely simply on the software when looking at a search like this, how long to die in the cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that that tab was backgrounded, or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as how's long to die in the cold with the timestamp of 227. Is it 2740?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
You heard it, ladies and gentlemen. Jen McCabe, after Ian Whiffen, the foremost Celebrite expert and a coder within the company, already confirmed the 6:23 and 6:24 a.m. Google search timestamps for how long to die in cold. Dr. Jessica Hyde, an independent expert with even better academic qualifications than Mr. Whiffen, arguably, comes in multidisciplinary expert on multiple programs that interface with Celebrate, and confirms the Google search at 6:23 and 6:24 a.m. Karen Reed's expert, stumbling, mumbling Richard Green, the man with the arrest history for filing a false police report and simple battery. Ladies and gentlemen, he is discredited before he even takes the stand. There you go, folks. Towell did his own meta commentary. I am my own reporter. I'll toss to you, Reporter Towell. No, Reporter Towell, I want to toss back to you. Ladies and gentlemen, as if that weren't enough, we have one final update. How did the day end in the Karen Reed and John O'Keefe trial? With none other than the clip of Kate saying that it was her or Jen McCabe going down. That's how we'll close this recap. Towell friends, I'm going to say bye to you too, but that's how we'll close this recap clip together.
Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Look at that look in Karen Reed's eyes, Towel friends. It says it all. She even side-eyes over to the jury. She snaps her head. She tries to avoid looking at the jury, but look at her head snap after that clip plays. She side-eyes the jury right away, Towel friends. Look at that. Look at those eyes. She wants to know how the jury reacted. She knows it's a big deal. My name is GrantSmithEllis. I'm going to end this clip now and go back to the Towel friends. Join live with on youtube.com/@GrantSmithEllis for more coverage of day 12 in the John O'Keefe and Karen Reed trial. We are ahead of schedule. Jurors got 30 minutes off at the end of the day today. Go enjoy the sunshine if you're watching this, but tune in at 7:30 a.m. Eastern. youtube.com/@GrantSmithEllis. Chat with the Towel friends. Join the Towel universe. I'm ending this clip now. Ladies and gentlemen, I'm back with the Towel friends, and you know what that means, folks. We did our recap. We saw the clips. I know you want to see it one more time. Let's do it. Let's do it one more time.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
And you know I'm going to leave it with the jury side-eye look. All right, ladies and gentlemen and fellow Towels, my name is GrantSmithEllis. I think you know what it's time for now. Together, as one, Towels, I will go through your comments. I must say hello and goodbye to every single one of you. Amber Am, have a great rest of your day. It was a pleasure. Bailey, I always love seeing you pop in, friends. Jew Drops, the best towelette I've ever met in my life. The most dedicated towelette to justice for John O'Keefe and his family. God bless you for everything. Get some rest, my dear friends. Alana H. Sheffield Towel, keep us updated. Diana Natale, great to see you. There was no new pope selected, by the way. I will let folks know. Beach Nance, God bless you, friend. It was wonderful to see you. JJU as well. Jew Drops, of course, I'm going to say thank you every time I see your name. Kelly Patton, my dear friend, God bless you. Have fun getting your granddaughter. Be well. I'll see you in the morning. Paul Doherty, great to see you, dear friend. Amber Am, I saw you already. Macy, I'm so glad you were with us. Lauren Ellen Geisler, thank you so much for your kind words. It was a big day. I'm going to keep on keeping on. Ed Jobs, dear friend, appreciate all your good questions. Keep those FKR people in line by your erudite fact-checking. We had Kat. Oh, dear Kat, it was great to see you. We don't know who's next after Dr. Jessica Hyde. Tomorrow is a cliffhanger. Who will show up first for the state? We'll be here to cover it. We saw Paul Doherty. I saw Claudia Montano. It was great to see you, dear friend. Barbara K., my dear honorary towel friend. It was wonderful to see you. And then I saw some other wonderful. Alex, of course, friend. I hope you have a great rest of your day. Alana, great to see you. Of course, I saw you down in the chat earlier. Charlene, dear friend, it's always wonderful. Elevate the process. You are a wonderful towel friend. God bless you and keep up your good work. Wild Roses, you as well, dear friend. I always enjoy your comments. Ems, I love your tweets. I love your comments. Keep it up, dear friend. Sis, seeing you pop up in the chat always makes my day. Don't ever stop coming back. Keep it up. Linda O'Gara, I was so thrilled when I got to chat with you earlier in the stream and confirm that we could see your comments. And Twittick, oh, dear friend, I hope you've been doing well. I've been keeping you in my thoughts and prayers. H, every time I see you, Sheffield Towel, I'll say hello. Modelo Macy, I always love your comments. Thank you for celebrating the Towel Stream record number of viewers. It was great to have you here for that moment. Paisley Park, I love your name as well. Justice for Officer John O'Keefe. I'm so glad that I was here with you. Eva, God bless you. We need to ask Christina to insert Obi-Wan Jessica Hyde to the Chewbacca photo. Christina, if you heard the clarion call, dear Eve says that we must find a way to get a on-the-ground photo of Chewbacca with Obi-Wan, Jessica Hyde, and potentially the Stay Puft Marshmallow Man. And then also we had comments from, who did we have in there? Tom Grist, it was great to see you. I'm so glad. I'm humbled by your compliments. I am but a mere towel. Bill McIntyre, it was great to have you with us. Marianne Nizio, I always love seeing your name pop up. Oh, my word, Linda A., it was great to see you. You're such a dedicated towel friend. Laxi Daisical, you have a wonderful username. I'm glad we saw you. DJ Naptown, you as well. Great to see you. Claudia Montano, I think I saw you in there as well. It was great to see you. Oh, Second Peach Gal, I knew you'd pop up for us today. It was great to talk with you. Elevate the process. I'll say hello to you every time your name pops up. You all were ferociously chatting, I see here in the towel stream. Lynn Hennis, my dear friend, God bless you. I hope you enjoy the rest of your evening. Amber Alexander, you as well. It was great chatting with you. I'm just scrolling up, friends. There's so many of you. Allie 90211, God bless you for the support, towel friend. Oh, all of you who supported Towel Chat today. Lisa Cox, it's great to see you, friend. I'm glad I got to see your username in the scroll back. Oh, there's so many of you who are wonderful towel friends to each other that chat and keep each other company. That really warms Little Towel's heart. I'm jumping down to the bottom to make sure I didn't miss anybody. I always feel bad when that happens. JJ, Trevor McIntyre, my dear friend, it was great to see you. I'll see you in the morning. All new towelettes, of course. Welcome, washcloths, beach towels. Pamela, I'm adding you as an honorary towel. Welcome to the honorary towel fold. Leah EGE, welcome to the honorary towel fold as well. We have so many new friends and old. Joe O'Keefe, it was great to see you. Susan Spadafora, God bless you as well, dear friend. And Luisa Ramirez, I always love seeing your name pop up, of course. It was great to see you. And Bailey, the hearts on your name and the hearts on Dewdrop's name are some of my favorite parts of this stream. All right, ladies and gentlemen, as you know, we'll do this as the close. Okay, a few things. One, the ways you can support Towel Stream. Let your friends know about the Karen Cam. Let your family know. Let other people know this is the channel where you can see Karen's real-time reactions. Let them know about Little Towel. Share the stream, like the stream, subscribe to Towel Channel. We're over 800 subscribers now. We're going to keep growing the Towel universe. The fabric of the Towel universe is strong. The other thing is, a lot of you ask, after 9 hours, how can we support this stream? This was informative. You're the only place that had the Karen Cam. I'll show you, folks. I will share with you in the chat. Begrudgingly, the donation information, if you want to support Little Towel, it goes directly to helping continue this public information service rooted in Lord Reed's values of educating, informing, and entertaining the public. And furthermore, ladies and gentlemen, more important than supporting Little Towel, although I think we should prevent Little Towel from dying of starvation and wandering the countryside in a robe, preaching morality, although I'm sure that would be quite fun. But more than just that, ladies and gentlemen, you are helping other people learn the value of informed public discourse. And yes, there might be some entertainment here, but the primary goals are educating and informing the wider public. And God bless you if you support Little Towel in those efforts. But As you know, we always close with the most important way you can say thank you to Little Towel for this work that he does as a vocation, as a towel. And that, ladies and gentlemen, is whether you are out there as a towelette or a washcloth or a paper towel or a hemp towel or a beach towel or a soap dispenser or a flannel or a microfiber towel or otherwise, or a towelette in particular. You can go out there and do small acts of service for those around you. You can donate to homeless veterans or a cause that you support. You can say hello to a neighbor, smile at a friend, go visit a family member, call someone you haven't talked to in a while. Find ways to show compassion, let that radiate outwards, and may this earth move in a better direction, away from vacuous self-interest and greed, and towards a world intent on preserving, demonstrating, and expanding its capacity to demonstrate universal love by way of small acts of service. And in that, ladies and gentlemen, let that be the legacy, not only of uplifting the discourse of this country and this world, but also let our legacy be one of a kinder, gentler, more compassionate world, and let our legacy be one of selfless acts of service for others. So God bless you, Little Towels. Go out there, donate tomato plants to others. We'll name them honorary towels. Donate food to the homeless. Help people in any way you can. And let's, through 6 degrees of authentic separation, not Chewbacca, bring about a new world age in the digital world, not defined by self-interest and greed, but instead by universal love, compassion, towels, warding off the rise of the bricks, protecting the petrodollar, and appreciating the little moments in life. God bless you, Little Towels. We made it through another day of the John O'Keefe and Karen Reed trial. I will see you all very soon. Until we see each other next, God bless. Be well. Remember to always smile at your fellow towels. And I will see you at 7:30 a.m. tomorrow. Have a good rest of your Wednesday.